very good morning to all of you. My name is Rajkumar. I'm the founding Vice Chancellor of Judicial Global University. I would like to extend a warm welcome to all of you to the second day of the National Virtual Conference on Economic Dimensions in Judicial Decisions. I'm very delighted to see three wonderful former judges of the Supreme Court of India, outstanding jurists, and I will be introducing them very shortly. But before I do that, I want to give you a brief introduction of what has happened since yesterday. We began the inaugural session yesterday on the theme, the economics in judicial decisions or judicialization of the economy. And we had both the inaugural address and the keynote address reflecting on the broader theme of the conference. As you know, the conference is organized by Judicial Global University in collaboration with Cuts International. And we have been discussing this issue since yesterday. The first thematic session that happened yesterday was on the theme, economic analysis of public infrastructure, trade and constitutional law. The second thematic session was on the theme, law and economics, approach to corporate laws and corporate debt restructuring in India. The third thematic session was on the theme, law and economics, approach to competition policy, digital economy and new technology. And the fourth thematic session was on the theme, an economic analysis of industrial innovation and intellectual property law. These four thematic sessions and the inaugural session yesterday morning was followed by two plenary sessions. The first plenary session was on the theme, getting policies right for an inclusive future. There was a keynote address delivered by Mr. Manish Tiwari, Member of Parliament, Lok Sabha, and followed by another plenary session on the theme, institutionalization of reforms in courts in India. The keynote address was delivered by Dr. Abhishek Manu Singhvi, Senior Advocate, Supreme Court of India, as well as another Member of Parliament. This was what happened yesterday. Today we have with us, we are here for the fifth thematic session, which is a judges colloquium on the role of economic analysis of law in India. We have three outstanding judges, Honorable Mr. Justice Swatantra Kumar, former Judge Supreme Court of India, Honorable Mr. Justice B.N. Sri Krishna, former Judge Supreme Court of India, Honorable Mr. Justice Madan Lokar, former Judge Supreme Court of India. All three of them need little introduction. They have been leaders in their respective fields, truly intellectual giants, but more importantly have made significant contributions to the development of law and jurisprudence in a range of fields and have continued their work even after they have left the bench. As we know, judicial system plays a dominant role in the progress of a country, as each judgment and development of jurisprudence may have a strong link between governance and economic activities. Economic analysis of law seeks to explain the effect of laws on the behavior of economic actors and whether the effect of such laws is socially desirable or not. In that sense, judges are constantly making important, let's say, nuanced interpretation when it comes to those implications. Economic analysis of law addresses questions about the cost, the consequences, or even the social value of a specific law. An effective legal structure helps a country to boost its development. As in international trade, India sometimes imposes anti-dumping laws to protect domestically produced goods. Freedom of speech and expression and freedom to carry trade or occupation over the internet, it is also protected under the Indian Constitution under Article 19(1)(g), which could boost the economic activities of the state. Say bringing lottery and gambling and the GST possibly can help to channelize funds towards economic development. The removal of the RBI's restriction on, say, cryptocurrencies could tend to boost investment, and the decision that protesters cannot occupy public spaces indefinitely would decrease the inconvenience caused to the locals. These legal provisions, protections, and decisions tend to promote economic activities and well-being of the people at large. But in recent times, especially in the light of the COVID-19 pandemic, we have seen India experiencing complete lockdowns under the Epidemic Diseases Act 1897 and the Disaster Management Act 2005 to prevent the outbreak of coronavirus. This has prevented the spread of virus, but also has had a huge adverse impact on economic activities of a developing country like India. Due to the nationwide lockdown, there was mass suspension of economic services, which caused inconveniences to different sections of society. The worst affected were the migrant workers, the jobless people, and the vulnerability was further exacerbated In countries such as US, Singapore, and other places, they passed, legislative interventions, including the Coronavirus Act in the US, and Singapore had passed Infectious Diseases Regulation Act and a number of other legislations. So the question then is the consciousness in which judiciary and judicial institutions and even legislative and executive to strike a delicate balance between law and economics is at the heart of today's discussion. So before I begin in the colloquium today, I would like each of our distinguished judges to briefly reflect on their own impressions about this conundrum, in the sense that to what extent law and economic analysis has become more relevant now than, let's say, at a time when they started their own legal and judicial careers. So let me begin with Justice Madan Lokar.
Yeah, good morning. Good morning, Professor, and good morning to all the panelists and the audience. Today is fortunately a wonderful day, nice weather outside, and but we are discussing a very important subject about economic analysis. And my reflection on this really is that, I think right from the very beginning, when we are looking at land laws, land reforms, right from the 1950s onwards, there have been, some sort of an impact, some sort of an economic impact in judicial decision making, whether it pertains to big landlords, whether it pertains to small landlords, whether it pertains to tenants, tenure landholders, and so on and so forth. But today, the situation has changed in the sense that today we're talking about really very, very big business. Well, in the 1950s and 60s, if one held a lot of land, one was considered to be economically well off. But today we are talking about persons who are not only economically well off, but who are, super well off in that sense. Billionaires, multimillionaires. You can see that in Parliament, for example, where more than 50% of the members of Parliament are what are called crorepati's. So really, I think, lawmaking is going to take this bias, if it has not already taken this bias, which is in favor of, big corporates, multinational corporates within India and outside India. Something that was, debated in terms of land holdings in the 1950s. So we are seeing a very massive change. How it's going to play out, after this pandemic is difficult to say, because the pandemic has shown, at least that's what the figures seem to suggest. The pandemic has shown that, the rich got richer, the super rich got super richer, but those at the bottom of the ladder, economic ladder, were the ones who were very badly hit. We saw that last year in the migration of millions of people back to rural areas, back to their homes. We are seeing this perhaps on a smaller scale this year when the pandemic is ravaging the country. So how this is going to play out in the years to come is really very difficult to say. Now, judicial decision making and legislative action must factor in all these issues. Looking not only at the the importance of corporates, their contribution to society, but also looking at the marginalized sections of society, those who were migrants, walking home for a couple of 1,000 kilometers. Also need to be taken into consideration not only by judges in the courts, but also by the legislature. I think this should really be the focus on the next couple of years. But like I said, how it's going to play out is very difficult to say. Thank you.
Thank you very much. Thank you very much, sir, for setting the tone of the discussion. I'm going to now request Justice Sri Krishna to reflect on the theme, the role of economic analysis of law in India.
Thank you. Morning to all my brother judges on the panel. Good morning to you, Raj, and all the viewers. Raj, the way I look at it is the first person to talk of economic activity being the focus of all human life was Karl Marx himself. The Marxists believed that nothing in life could be separated from the key thing, namely economics. Now that is one extreme of the Marxists. Now on the other extreme, you have the capitalist country like United States, where a judge like Posner believed that all law must follow economics. Please note that whether you approach the issue from the left or the right, economics is the key thing. I do concede that economic activity needs to be governed and balanced with human rights and human lives itself. Now, in this aspect, judges play a very critical role. Now, take a simple thing, whether tobacco is bad for human health and therefore it affects the human life. Alcohol, people believe is bad, some people believe it is good. Now, without any kind of quantitative research, as a judge, I cannot jump to this conclusion that alcohol is bad because I don't drink, or alcohol is good because I drink. I got to have some kind of quantitative research into how much of the ban is going to affect the human health, how much of it is going to affect human economic activity, how many people will be thrown on the streets, how many production establishments will have to shut down. Now, if I don't do this, I'll be just sitting there at a King Canute on the beaches and saying, waves, go back, and command the sea to go back. But 15 minutes later, the sea is going to lash back at me. This is precisely what is going to happen. Now, for example, it did happen. Take the question of how the alcohol was banned near the highways. What quantitative research went into it? Now, take, for example, tobacco has been banned by Parliament. I'm not a great votary for government activities, but I'm saying this. I assume that tobacco is not banned in this country, please note. The law only says you shall not sell tobacco products within certain specified limits of various institutions and under certain stringent conditions. Now, why was this made? Because I assume that there was some quantitative research, some economic analysis of the pros and cons of total ban and not banning it. Now, similarly, if the Supreme Court before, or any court for that matter, any constitutional court, before it takes a jump into the sea, must gauge what is the depth of the water. If it doesn't, then there is going to be infinite chaos, and that is going to affect people who are not intended to be affected by it. Now, sitting in Delhi, I might pass a judgment of the Supreme Court. If it had been purely inter partes, what I say will affect only two parties, one the appellant or the respondent, doesn't matter whatever decision it. But if it's going to affect the entire country because of Article 141 or otherwise, then it is time to sit back and reflect and say, should I or should I not jump? That is the take I have on the matter.
Wonderful, sir. Thank you very much, sir. Well, I was waiting to go back to Justice Satendra Kumar because, sir, you have been in a very vantage position, not only having been a Supreme Court judge before, but you later, assumed a very important role as the chairperson of the National Green Tribunal. And that's one area where you came in directly in conflict with the ability to, both government as well as industries to advance economic activity on the one hand, and the core and critical mandate of protecting the environment, and how does one strike a balance? What is your take on this?
Well, good morning to my respected brothers, Raj to you particularly, and the entire audience. Firstly, I think what you are doing with Jindal University is a remarkable contribution that you have made, not only in India, but across the countries. I would just come on a very plain language. When we talk of contribution of judicial decisions or judicial creativity on our economic impacts, then it should not be counted in terms of GDP. See, that will be the biggest folly that one could consider. See, economic, as Justice Krishna said, Justice Lakur said, is an essential feature not only of a law, but of the society per se. So once we are talking about the contribution of judiciary and its impacts on economic status of the country, we have to have a very diverse view. We cannot think on a one-track mind that what is the gain, what is the loss. I will just give you that in economic standards have to be considered on a cumulative effect of a judicial process or a judicial decision-making power. Why do I say that? I would be giving you example. There can be fiscal laws. Fiscal laws would have a direct impact on economic affairs. If we talk of environmental laws, it may not have direct impact, but what I call is indirect impact on economic standards and economic implications of the country economic growth. Now, thirdly, you can say the social laws, the punitive laws. Each judgment will lead to a different conclusion. Why do I say that is for this reason? If you take Vodafone judgment of the Supreme Court, it had a direct impact on taxation law and therefore the taxation contribution by the taxpayer. While on the other hand, in Kamal Nath's case, the Supreme Court judgment totally had a different dimensions. It prohibited activities, constructions in the interest of the environment, but it had a lot of economic impact that people started thinking of providing different standards for their economic development. That is a sustainable development. While in our case, if Kamal Nath judgment had not come, people would not have thought of environment, and therefore the entire industry which is dealing with sustainable development would not have come into existence. So that's, I think, the great contribution and impact of the judgments of the Supreme Court which have been done. Now, when we talk of judicial creativity, that means the court is expanding the principles of law in order to meet the social needs. So it's not just the social needs. It's inbuilt element of economic need. For example, if you take any judgments that have been passed, even in relation to pandemics, they have been on the economic criteria. And then lastly, they lead to legislative actions. If you see, the judgments of the Supreme Court had led to legislative enactments, which in turn had a direct impact on the economic standards of our country. So I would just put it in a very simple thing that the cumulative effect of judicial decisions and judicial creativity by the higher courts is a greatly contributing and relevant factor for economic growth of our country. Thank you, everybody.
Well, thank you very much, sir. I think this is a very, very good stage that has been set for the ongoing discussion. So let me now go into a bit of a deeper analysis of some of these issues. And I'm going to ask Justice Madan Lokur to begin with. So what do you think is the role of the judiciary in promoting the intersection of welfare, economics, and law? And arguably, does our judiciary in its current form, including the training and the capacity building that has happened, are our judges, particularly the Supreme Court and High Court, and I don't even want to talk about the lower courts there, do they have the knowledge, the expertise, the skills to dwell deep into this analysis to understand the intersection of economics and law?
Professor, it's like this. The judges really interpret the laws, all right? So if a law comes to the court for interpretation, for example, you have the Manrega Act, all right? It is something for the welfare of the people. It is to provide them employment, guaranteed employment, and so on. Now, it's one thing to say that the law should be implemented, right? And another thing to say what will be the consequence of the implementation of the law. Now, supposing the act requires 100 days minimum guarantee. Nowhere, just about nowhere, is 100 days actually working out. probably the maximum would be about 60 days in a year for a household. Now, supposing the courts were to say that, no, you see, the law says 100 days, so I don't care what you do. You make sure that 100 days employment is given, right? It's going to have remarkable consequences as far as the economy is concerned. Does the government have that kind of money? It doesn't, right? So why do you make a law like this when you know you cannot implement it? I'm just giving you one example. Now, you've had, in drought-stricken areas, it's from 100 days, it goes up to 150 days. It doesn't work. Even there, you can't get 100 days work even in drought areas. So really, the hands of the court are in that sense, tied. Let me give you another example, where the economy, for example, has been talked about. That is the coal scam. All right. Now, the question before the court was that was there any corruption involved, or was there any dishonesty? Not necessarily corruption, but was there any dishonesty or some wrongdoing? Let me put it mildly, involved in the allocation of coal blocks. If the answer is yes, what do you do? Right? You say, all right, I'm going to stop all the coal blocks from functioning. The consequence of that is going to be economic in the sense that a lot of people will be thrown out of their jobs. Coal production is going to stop. Okay. So otherwise, what do you say? That it's okay. It doesn't matter if corruption has taken place. Doesn't matter if wrongdoing has taken place. Let it continue. Why? Because if we try to stop the corruption, people are going to get affected. And now, when you have situations like that, it's very difficult for the court to take a decision which is going to have an impact on everybody in the sense of employment, or is going to have an impact on everybody in the sense of saying corruption is okay. It's perfectly all right if people are corrupt and they get coal blocks allocated to them. So whichever way you look at it, environmental issues, right? Now, there are violations of the environmental law. What do you do about it? Do you say that, well, it doesn't matter, let the law get violated? If the law is not violated, people are going to suffer. What are people going to do about the environment and so on? You have public health issues. In Delhi, for example, in November, December, you have massive air pollution. Now you turn around and say that, well, all the factories should be closed. Why? Because people need to breathe air in Delhi. But what is going to be the impact of that? One doesn't know, right? So these are very difficult decisions, and they really, in my view, they cannot be, a cut and paste kind of solution. That if this happens, this must follow. It really depends.
Thank you.
Case to case. Yeah.
Thank you very much, sir, for that. In fact, I'm going to push it further, and I'm going to ask Justice Sri Krishna. In fact, what Justice Madan Lokar has just probably raised in the context of the coal block aspect, but also other issues, is that the heart of the problem seems to be that lawyers and judges are simply not able to reconcile the what comes natural to economists when they look at what is known as cost-benefit analysis. Because as lawyers, we are all along trained from a disciplinary standpoint to look things pretty much in black and white in terms of what the legislation is and how do we ensure that we adhere to that legislation, particularly when the legislation becomes very sharper. So my question to you, Justice Sri Krishna, is that if you look at, say, European developments, if you look at the United States, they have a very rich tradition of determining wrongdoing on the one hand, on any matter. And then when it comes to the judicial response to the wrongdoing, it's based upon serious law and economic analysis. A lot of emphasis is on impact and ensuring that the impact of the judgment does not affect significantly the entire fabric on the basis of which things govern. Is this the way ultimately we may have to go? Justice Sri Krishna.
I think that is the way. Now look at what Madan said. let me give you another counter example. Take, for example, the minimum wages payable in the country. Now, that a person, that the state is obliged to make sure that the human beings don't lose their lives because of lack of economic activity is one of the obligations of the state. Now, particularly, you cannot allow employers to exploit, otherwise because of the rampant unemployment, a worker may be able to come and say, I will work for free, I'll work as a bonded labor. Why was all this possible? Because of economic oppression. Now, in order to say that, you have to pay a minimum wage. Now, the determination of minimum wage itself is a very tricky thing. It varies from track to track, it varies from place to place, from city to city. Therefore, you have got to go into a great economic analysis, find out what is the minimum amount of money required to a person to sustain his body, life, and a little bit of animal, human comforts. Compute it in terms of rupees, and then say this should be the minimum wage. Now, is a judge capable of doing it? I cannot sit in the Supreme Court or any other court and say, because the law seems to be very strict, that if you don't have the capacity to pay minimum wage, you shall shut down your economic activity. You have no business to run an establishment and exploit like labor. Therefore, before I say this can be done, I have to have some kind of quantitative research behind me. So that is, the court is never capable of doing that. Court can only, see, this is because traditionally, what is our concept of law? Our concept of law has been traditionally the edict issued by a sovereign, failing which is backed by a penalty, which is backed by a sanction. You breach it, you breach the law, and you are answerable in sanction. Now, the question is, you raised the right question. This is exactly the question that Posner repeatedly asks in his writings. He says, if you breach it, what is the consequence? If the consequence is death of human beings or some serious inroad into their fundamental rights or human rights, then obviously you have to jump in and protect it. But if it's a question of how it is going to affect the economy, then there should be certain amount of quantitative research and, as you rightly say, a balance sheet. Now, hey, look, take environmental laws. Environmental laws are intended to protect the human rights of human beings. Therefore, if I don't do it, so much of human rights will be lost. So much human life to be lost, human life will be threatened because of disease or whatever the pollution. But if I do it, then there is going to be economic activity. So somebody has to make a balance sheet of this and say, hey, look, it is this one that is better, it is predominantly necessary for which I am going to do. In this case, I will not do it. Now, this is a conscious decision which must be made. Now, if the judges of this country were to sit down and do this, they would have no time to deal with the other things. The routine matters of X versus Y will never be solved. Therefore, it is better that either you have an economic research wing attached to the Supreme Court or to the High Court, ask them to do it 24 hours, 7 days a week. And on a given issue, look at the solution that they propound, or look at the research that the report of the research, and then take a conscious call. This is exactly the problem. If you don't do it, then what happens is, yes, I sit here and give an edict and say, all the waves should go back. Looks very nice, people will clap. The newspaper will even report my picture in the newspaper. On the TV, Raj will also give me some kind of an applause. But tomorrow morning, what happens? I love that book by Arun Shauri. I don't know whether you have read that book. Beautiful analysis of all the Supreme Court judgments, starting from your Bandhava Mukti, saying what is happening on the ground. It is happening like that because there was no quantitative research. Had anybody calculated the immense harm that is going to be caused to human beings as a result of the judgment, forget the economics. See, economics is not something in the air. It's not something that's dealt with only by the Babu sitting in Reserve Bank or in the North Block or South Block, whichever that block is in Delhi. It is something that affects me on the ground, something that affects every citizen on the ground. So that is the analysis which has to be made. How many people are going to be affected, to what extent, by this kind of decision being taken is absolute sine qua non for that. If you don't do this, then we are just sitting like Canute and passing judgment. That is my take on the whole issue, and that is my answer to it. Therefore, I come back to the first question he propounded. A balance sheet is absolutely necessary. Now, if the balance sheet is done by the judge, lovely. That is the best thing that he could have done. But if he has no capacity, if he has no competence, if he has no assistance to do the balance sheet, then he should be very hesitant then the right thing to do is the traditional method by which the judges used to operate. Tell the government and say, we don't agree with what you have done, redo it. And leave it for the the government to do it, because the government, at least in theory, has a lot of capacity to do it. They'll have a lot of competence backed by experts to do it. That's the way I look at it.
Thank you very much, sir. Let me move to Justice Swatantra Kumar. Sir, I'm sure you are obviously very familiar with the discussion that we are having in your work, as particularly as chairperson of the National Green Tribunal. My question to you is that when you do that, and I'm pretty confident that with the NGT was beautifully structured with expert panel members and judicial members. In those debates and discussions, when you make those judgments and interventions, to what extent a nuanced understanding of economic analysis is brought to bear when determining particularly, let's say, closure of industries, for example, or complete rejection of development planning or development projects? To what extent all or nothing, as opposed to some or more type of analysis is made?
Well, I don't think I would have a little difference of opinion with both the brothers who have just expressed. See, courts in the decision-making process can have an access to economic analysis. I don't think it is prohibited or judges are incapable of understanding economics. I'm sure that there are judges and judges who were tremendously competent on economic principles. What I am trying to say is, I would put it in two ways. One, in relation to environment, since you have put a specific question, and second is with regard to the generic terms. In generic terms, I would say, for example, the Supreme Court, while expanded Article 21 in relation to education, in relation to right to livelihood, and then decent and clean environment. All these three things created a new impacts on Indian economics. It was not, who thought of education going up compulsory, therefore consequently infrastructure, teaching staff, generating employment, then educating people in your country so that they can participate in better livelihood of their own. Similarly, when they said about environment, the moment the Supreme Court emphasized on that it's a fundamental right to have a decent and clean environment, the outlook of the government changed. So as Justice Harishna said, the government has started thinking in terms of positivity on environmental concept, hence impacts on, you have to put up treatment plants which nobody thought of ever. So the whole mechanism on that changed the concept of economics as far as the environmental laws were concerned. Secondly, I would make a mention about the concept by courts. This was not only by the environmental courts like all over the world. It was, I think, Indian Supreme Court and Indian High Court deserve a compliment. They were complimented for being so rich in their implementation of environmental laws. The compensations were imposed by the Supreme Court, the High Court, and then National Green Tribunal. The compensation imposed was running into crores. So this obviously, that crores were not spent just as a punitive measure. It was put as a remedial measure, therefore economic growth. It was given to people for environmental damage. So that was the other thing they did. And impact of economic study has a very relevant consideration. For example, in Yamuna judgment, every penny to be spent on the project was calculated through economic committee. So it was not that the courts of the tribunals are totally foreign or alien to economic fundamentals. I think they have a very effective role to play. And I do say that the judges need to, kind of acquire greater expertise on or help or assistance from the expert body to apply more effectively economic factor into the judgments which they give for the purposes of bringing economic prosperity. Because no court is unconscious of the fact that the economic prosperity is the fundamental of the rights. If there is no economic prosperity, what will your fundamental rights do? If you don't have the funds to give it to them, for example, today we are talking You don't have an oxygen. So what kind of a right are we talking about? So what I am trying to say is that role of courts is very relevant in economic growth of a country. And I think the various factors would come to the rescue for the purposes of giving effective and implementable judgments of the courts. Thank you.
Well, thank you very much, sir, for that fascinating exposition. And we are, of course, live on Facebook and YouTube. For all those who are watching from India and beyond, please send in your questions, and I'm going to get those questions to our distinguished judges shortly. Let me move to Justice Madan Lokar. Sir, I think in 2017, we had the Shiv Shakti Sugar Mills case in which the Supreme Court said, and I quote, the court needs to avoid that particular outcome which has the potential to create an adverse effect on employment, growth of infrastructure or economy, or the revenue of the state. And it further said, India is on the road of economic growth. In such an environment, it becomes the bounden duty of the court to have the economic analysis and economic impacts of its decisions, unquote. Now, can we say that this analysis or this reflection that the Supreme Court of India has had, let's say in 2017, is a significant evolution from the early origins of responding to issues that will impact economy?
Yes, certainly. I think there is a sea change. There's no doubt about it. But, Professor, I think let's not, kind of sandwich the court into this entire issue. The court is one of the institutions, right? Now, judges
Yes.
are well equipped, as Justice Arvind Kumar said. I mean, it's not that economics is something new to them. I'm sure they have at least some basic knowledge of economics and so on. But what about legislatures? Does Parliament think about all this? They have standing committees. When they enact a law, do they not realize or do they not look into the economic impact that a particular interpretation may have? Or why are they doing a particular thing? What about the executive, who are going to implement the laws? Do they not know, what is going to be the impact of a law which Parliament is likely to enact? When they, give the information to Parliament, or when they give the information to a standing committee and all that. So it's a role that everybody has to play. And to say that, well, because the court has given a particular interpretation, therefore this is the consequence of that. But the court is not the one which enacted the law. It's somebody else who enacted the law. Did not that person who enacted the law, Parliament, think about all this? What about the role of the executive? Didn't the executive tell Parliament that, listen, this is likely to happen if you do this? So let's not, think that if the economy has to function, the courts have to look at everything. They must be fully equipped. Yes, they should be fully equipped. But prior to their getting fully equipped in interpreting a law, there are two other players who need to be fully equipped. And they are the ones who are supposed to guide the court. So let's.
I think it's a very, very important
perspective. Sorry?
Yeah. No, sir, I said I entirely agree with you. And it's an absolutely critical point, because one of the things that we end up doing is that since there are huge social expectations generated out of the functioning of the courts in particular, given the fact that it not only has the power to adjudicate, but also it has the power to challenge, question, and even invalidate actions of both legislature and executive, that creates an additional burden and expectation on the part of the courts. But I totally agree with you that this type of analysis should be equally mandated within the context of the functioning of both the legislature and the executive, sir. Now, let me move to another dimension to it. And Justice Sri Krishna, I would like your reflections on this. Now, I think there is large consensus, at least in the panel, that we need to have this analysis. And as Justice Swatantra Kumar said, there are a number of judges who do have it, and we can improve and increase their expertise, and the recent jurisprudence is going in that direction. My question to you is that, what are the constraints faced by the judiciary in undertaking an economic analysis of law? Are there any, let's say, moral, constitutional, legislative capacity or practical constraints which impede and inhibit and affect such an analysis to be possible? Does the economic analysis of law also pose a challenge to traditional approaches towards interpretations of law that our judges are usually trained, and how can we overcome this?
I've been a judge in 3 courts. At no time did I find that the courts were so well funded that they could have a research wing to do research on any topic of interest. Least of all, we would be happy if they released our pay allowances and administrative money required on time. Apart from that, look, it requires a massive expenditure. For example, economic analysis would require collection of data. It requires a carefully structured survey. Now, I'll give you an example. Take, for example, the 2G case. Very simple. On account of some administrative goof up, you say the action is bad. So by one dictum, you say that this is bad and I strike out the whole thing. 128 licenses were cancelled. Now, each one of these companies borrowed money on the strength of the license. Who paid the money? Banks paid them. Why? Because it was a rich business and they knew they would get it back. Now, what analysis had gone into it to examine how much of money was really raised on the strength of 2G licenses? How many such licenses are there? Apart from that, how many of the companies were really unqualified for the licenses? It is not that all the 128 were incapable. It's not that all the 128 were economically bad or because of some other vitiating factors. Now, what analysis, at least in the judgment, I don't find any. I do not know if there is any analysis done anywhere else which is kept unpublished. Now, as a citizen of this country, I read the judgment. I know that by one sweep, you have cancelled 128 judgments. And I also know that so several banks have gone into NPA because of that. The non-productive assets increased. And how are you going to repay it? The license is cancelled of a company, he has no money to pay it back. So whose money is it? It's the taxpayers' money. So this is where I say you require a massive amount of research. Now, please note, I agree with Madan's hypothesis that this is basically the job of the executive and the parliament. Before you pass a law, understand if you bring about this kind of a thing, what is going to happen? Who is going to be hurt ultimately? If the license is cancelled, whose money is it going to be blocked? Now, if a survey is made, then you will realize that this 176,000 crores of presumptive loss was nothing compared to what happened actually. This is the problem.
But sir, I'll quickly respond. I'll quickly push you on one aspect, sir.
Yes.
Many of these judgments are not necessarily originating to some legislative basis. They are to a large extent evolved through public interest litigations that have been brought, and Article 14 and arbitrariness as a framework has been used to respond. So in that context, is it time for us to, and I know it's a difficult question, is it time for us to really evaluate on under what circumstances we end up using Article 14 and arbitrariness? Because it is a carte blanche framework which has been welcomed by many of us as law students. As a law student, I grew up, inspired by the role of the Supreme Court in expanding the rights jurisprudence using Article 14 and 21. But now when that gets translated into economic decision making, it creates a different type of consequences. So do we need to reimagine that as well?
But please note, while you are protecting somebody's Article 14, you are hurting somebody's Article 21 rights. As anybody else, that's why you need a balance sheet. So if I uphold Article 14 here, am I going to hurt somebody else's fundamental right under Article 21? How many lives are going to be lost? How many persons are going to be thrown out on the street? How much of money is sucked out of the economy, as a result of which there will be a devastating effect on somebody else? This is exactly the point that I'm making. Therefore, what you need is plus minus. If I do this, I'll gain this, so many people will gain so much. If I do this, there will be a harm to so many persons. This is a balancing thing which has to, in fact, the role of a judge is to balance conflicting rights. Nothing new. The traditional role of a judge is that. But sometimes what happens is we become rather forward looking. I don't want to.
Thank you very much, sir. Thank you very much for that. That's very, very insightful. Justice Satendra Kumar, now let me slightly alter the debate that we are having today. Now, with the advent of globalization and liberalization, the Indian economy is clearly more integrated and new technologies are being adopted to expand that as well. Now, in your view, how does the judiciary recognize the role of economics in the application of regulatory laws? Because that's an area where there is a lot of changes that have come in recent times. And to what extent, this is more personal for you, you saw your own, let's say, approach to adjudication change or remain the same from your transition from a judge of the Supreme Court of India to the chairperson of the National Green Tribunal?
Right. See, the role of global economy is inevitable, I'm saying. The technological developments, I again think you are hinting at the NGT role. So I think what I'm saying is that during that period, yes, you came to know that the technological development all over the world were of great assistance for protecting your environmental interests. Now that changed the outlook of our country vis-a-vis other countries. So the borderline became very thin. They had to adopt modern technologies for the purposes of complying with the regulatory laws. The regulatory laws in our country, I think, are more than needed. I think we are overburdened with our regulatory laws. It is the understanding and implementation of the regulatory laws which is a matter of great concern. Firstly, I think as citizens, we have not really the desired respect for law. We always want to avoid law rather than obey the law. So what I would say is that I would just give you a very interesting example. In 1 minute, I think I should be able to say that. There was a very big industry in Agra, which was a very paper mill and sugar. So the board reported that the industry has no discharge. That means ZLD, zero liquid discharge unit. So it was very difficult for us to believe it. So we thought, but the board says, official has said, so it must be true. Then it came to be known that the gentleman does not use the ETP at all. He just put a pipe into the ground, discharging the entire effluent into the ground and has become obviously on the surface no liquid discharge. So what he did was he frustrated the law, and then what I'm trying to say is that the damage which he has caused, which Justice Krishna is saying, that you then balance out things because the damage he was doing was immense. So you drive out and then you put him under economic constraints, injunctions, then you try to achieve the object. But there is a direct link between the economics that is running the industry, the development of the country, and anything and everything. But what you need to do is, if you see the essential of a sustainable development is doctrinal balancing. That is the essence, and that is across the globe. It's not for India alone. So what I would say is that we must apply the economic principles to the best of our understanding. And unless and until, now, in Korea, I was an institute, which was pre-legislative active institute that used to conduct economic data, social data, field data, prepare a draft, give its, either way it's do's and non-do's, then that will go to the pre-legislative assembly committee, then it will go to the legislature. So by the time it reaches the legislature, the executive and the research field has been completely done, which I think I would fully agree with my brother Madan. I think we lack a lot on that count. Economic and legislative functions, if are performed to its perfection, the burden on judicially to judge on economic principles would definitely become the least.
Well, thank you very much, sir, for that fascinating, response to the complex conundrum that we are facing. Let me move to Justice Madan Lokur. Sir, one of the things, we all remember that in the S.R. Bommai judgment, there was a very interesting phrase used that judicially manageable standards. The words judicially manageable standards was used in the context of the fact that the judiciary may not have those standards in determining and responding to issues, and there is a lot of subjectivity that needs to be brought to bear in responding to a situation in hand. My question to you is that doctrine, or rather interpretation, relevant in the context of the law and economic analysis, whereas both Justice Swatantra Kumar and Justice Sri Krishna mentioned, many a time judiciary is actually groping in the dark because of what the legislature and executive had failed to do, and judiciary is actually pretty much asked to, for lack of a better phrase, clean up the mess that has actually been created by the failure of other institutions.
Yes, Professor. Actually, this is playing out today, in the pandemic. Now,
yes,
one, of course, is the failure of the legislature or the executive, to do its homework. That is one aspect. The other is the, transparency angle. Okay, now today, the courts do not have, in fact, I don't think anybody has the exact number of people who have died, because of oxygen shortage, all right, or the number of people who have died because of COVID. Okay. Now, the courts, there are at least, I think, about 7 of them or 9 of them or something. 9 high courts are trying to monitor the situation about the pandemic today. What is the expertise available with them? Their heart is in the right place.
That's the whole point.
The data is not available. They don't know whether oxygen is going to come, from where it's going to come, how it's going to come. If the executive does not tell them, if information is withheld from the court, I'm now talking about the current pandemic, but you look at it from the larger context of economic policy or economic analysis and all that. If information is not given to the court or is withheld, how is the court going to take an intelligent decision, or how is it going to come out with something which is a judicially manageable standard? It's just not possible. So there are these huge constraints that the courts face, and whatever the expertise is available, will come crashing down if the court is not given the proper assistance that it, demands, and the proper assistance that it should be given. So we are seeing that being played out today, right? Not only in these 7 or 9 or whatever number of high courts, but also in the Supreme Court. Why does the Supreme Court today say that, we don't mind if the high courts carry on, but we are also going to look at it? But does the Supreme Court have all this information? We don't know. Probably not. Okay, so we are going through this at the moment.
Absolutely. Thank you very much, sir. Justice Sri Krishna, this is a very interesting point Justice Madan Lokur has raised. I want to take that to the next level. In fact, what we have seen probably in the last, say, couple of decades is that many a time executive and legislature are kind of using, almost, not necessarily consciously, but wanting to use the courts to do things which they are uncomfortable to do. And unfortunately, willy-nilly, the courts end up becoming at the center of it. So my question to you is that at what point of time courts have to exercise a certain degree of judicial restraint, or the idea of judicial restraint is actually undermining the ability of a constitutional court to seek accountability of the executive? Because the reason I raised this aspect of judicial restraint is that there have been judges and judgments in the past. I remember a 2012 judgment which talked about, it ordered interlinking of rivers, for example. the ability of courts to, pass orders and directions, including the use of the writ of mandamus, but also writ of continuing mandamus. These are all extraordinary powers which end up being used more often. And in that process, we might actually end up losing the effectiveness of it. So my question to you is that how does the notion of judicial restraint, play out in the law and economic analysis?
Two things come to my mind. One is this question of judicially manageable standards, a beautiful phrase picked up from the American Supreme Court. And number two is a classic interview that was given by Justice John Roberts, the Chief Justice of the US Supreme Court. At the time, he was appointed as Chief Justice. In a press conference reported in Time magazine, he had said that it is time, if the judges arrogate to themselves the notion that they are going to cure the society of all the evils, they will neither do it nor will they do their job properly. Basically, the whole idea was it is the job of the executive and the parliament or legislature to go into all these details and come up with a solution that will be acceptable to the people at large who have voted them to power. Now, yes, we do grant you that it is our heart which is pierced, which is pricked. When I see that somebody is dying on the street, somebody has to die while cleaning a gutter. Now, if I were to issue as a Supreme Court judge and an order and say, all wastage disposal will not be done in this country in this manner, the question is, what is the capacity of each municipal corporation? Do they have the trucks to carry the garbage? Do they have the incinerators? Do they have people to do this? Now, it is basically the job of the constitutional courts is to ensure that fundamental rights of the citizens residents are protected. That's all. Now, while doing this, if they find that there is a law which is impinging on that, you have to protect them against the invasion by the law. While doing that, also they must keep in mind that what is the consequential ripple effect or the wave effect that it's going to produce. Now, in order to protect somebody's Article 14, I cannot by a sweep of my pen or a stroke of my pen do something that is going to hurt everybody's interest. This is the whole difficulty. Now, why is it not possible? It is possible. Now, the question, I'm asking a simple question. Is the Supreme Court or the High Courts all put together capable of running the country? If they are, my answer is yes. If they are not, what is the reason? The reason is they have neither the resources, nor the ability, nor the manpower, nor the competence to do it. So let them do it. I grant you, I accept Madan's thesis that the legislature and the executive are very much deficient. They are not doing their job properly. Therefore, does it mean that I have to do their job? I would gladly do their job if I had the competence to do it, if I had the resources to do it. If I do not, all that I can do is the failure of the parliament or the executive to do something should not hurt the fundamental rights of the citizens. To that extent, I can act as some kind of a barrier and try to give relief wherever it is possible. But if I make it overarching, then I have to look at the rest of the citizens also, seeing what is happening to the rest of the citizens. And you were saying that one more thing before I wind up, this tendency of the executive to say, let the courts take care of all the problems. This is there uniformly, whether it is a case of administrative law, when some clerk is dismissed on a petty charge, and it's honest that you find that it is a wrong order, you could withdraw it and do it. But no government officers will do it. He will say, no, let the matter go to Supreme Court, let the Supreme Court decide it. Land acquisition, let the Supreme Court decide it. Tax laws, let the Supreme Court decide it. Why? Because they are either incapable or unwilling to accept responsibility. If I do something, I should accept responsibility and say, yes, I've done it honestly. Now everybody's honesty is suspect. Everybody's motives are suspect. So how do you run the country? This is exactly the problem. And this is where we judges rush in, where angels fear to tread.
Well, thank you very much, sir, for that. Let's move to Justice Swatantra Kumar. Justice Swatantra Kumar, now let me move beyond the environmental field that you have, of course, strong expertise in. What I wanted to ask with you is that in developing this, framework of adjudication, to what extent judges actually look beyond the law? Because having been a judge for a very long time, the first obvious look at it for judges is to look at the law, the precedents, and all of that. But to what extent your training and your own, let's say, worldview has enabled you, or just not just you, but judges in general, to look beyond the law? And to what extent looking beyond the law is even considered appropriate within the judiciary? Because after all, you have a constitutional duty and responsibility to interpret the law, and the fact that you have to fulfill that responsibility. So using, let's say, economic or other factors, does it, let's say, undermine the legitimacy and credibility of the judicial process? How do you deal with this?
See, let's get into the constitutional status of the Supreme Court of India. You know, the framers of the constitution, their wisdom, gave a dual status to the Supreme Court. One was their duty to protect the fundamental rights and writs under Article 32. Second, which is more important, is the law declared by the Supreme Court was said to be law of the country. Why these two canons? It could simply make, like you have in US, you have UK, you have the statutory control over the Supreme Court. If the Constitution of India gives a particular stature to the Supreme Court, I do not think we would be fair in law or in fact to dilute it. That's the first principle on which at least I would work. There are three aspects. One is judicial creativity, other is judicial activism, and third is judicial overreach. The third certainly needs to be excluded while you are doing the judicial process. But first two are the essentials. See, how can you protect somebody's fundamental right if you are not ready to think beyond? If you are not ready to consider, now Justice Shri Krishna gave the minimum wages example. Now, it doesn't matter if an economic committee has recommended to you that the minimum wages should be X. If you feel that the X is impossible to be achieved and it will deny you the right to livelihood, certainly you should interfere. Therefore, it should not be an embargo on the constitutional powers of the Supreme Court or the High Courts. It should be in aid of the justice. What is your function? Your function is to do justice to people. Now, justice sometimes can lead to some inconvenience to some people or a group of people. But that doesn't mean if the larger section of the society in terms of law needs something and it is going to cause a prosperous section of the society inconvenience, let it be so. How does it matter? That is how you balance it. The balance is not what just now said was rich should become richer and the poorer should keep on becoming poorer. That is against the very spirit of our preamble. How do you give social, and they wanted to give social, economic and judicial protection to the citizens of India. So that is how so I do not think by any standards the court should feel shy. Yes, court should be willing to learn. Court should be ready to consult experts. It should be prepared to get and invited to the executive proper data to feed its decision-making process. Its decision should, as far as possible, correct according to law, implementable in law, and for that, whether you take aid of economic principles, social principles, or progressive principles, I do not think you hit or expand the constitutional powers beyond the permissible limits. That's what I would say.
Raj, I have one remark to make.
Yes, please.
When I was a judge of the Supreme Court, I was invited to a seminar on competition law. And there was a judge of this French Supreme Court, I don't know what they call it in French, a judge Supreme Court sitting next to me. I talked to him. I said, when did you pass your law? Where? He said, I'm not a lawyer at all. I said, what are you? He said, I'm an economist and I'm an expert on competition. So I said, what are you doing? He said, I'm a judge of the Supreme Court of France because I'm an expert on competition. Now, can we not have this kind of thing in our country? Now, I can say I am an expert, not that I'm really an expert on law, but I can boast to be an expert on law because I happen to be a judge of the Supreme Court. But I don't think I can with a clear conscience say that I know economics or any of the other subjects that are not concerned with law. This is exactly what I'm saying. Yes, you have actually, if you look at the United States, what happens? Every legislator, every congressman, every senator has a huge fund allocated to him, huge set of people who research for him. Now, that is, of course, not done in India. I don't know whether they do it. I'm not even aware of that. Much less in the courts. In the high courts, at least, I was told that originally there used to be a clerk. Now that has all been abolished. I'm not sure what is the situation in Supreme Court now, because I left the Supreme Court in 2006. After that, I have not gone to the Supreme Court. That is the way it ought to be done.
You are absolutely right. And I'm going to ask, the next question is going to be, and the same question to all of you. And I want to bring a very interesting point. In fact, all these disciplines are going through a lot of change. And I'm going to ask Justice Madan Lokar. Sir, you know, I think in the year 2017, Professor Richard Thaler from the University of Chicago's Booth Business School received the Nobel Prize for Economics. And his work was essentially on something known as the nudge theory. The idea was that he co-wrote one of the globally bestseller book called Nudge, which looked at how people make bad or irrational choices and how one can, behavioral economics is a discipline and can respond to those choices. My question to you is that, to what extent, let's say, law, for example, and adjudication can rely on theories and developments in other disciplines, including, for example, the theory of nudging in adjudication, and not to only focus on the all or nothing fashion of judicial interpretation, but to recognize the complexity when it comes to adjudication, particularly on matters that will have significant economic consequences. In a way, my question to you is that, are our judicial institutions, or for that matter, a legal framework, open, or to what extent are they prepared to respond to these changes? Because frankly, even economics as a discipline was not ready till the work of people like, Thaler.
Yes.
This question is to all of you.
Yeah. You see, the way that I look at it is this, that the courts, lawyers, law students, judges, everybody must look at every discipline. Okay, it can't be in a silo kind of a thing or a watertight compartment. Let me give you one example. Justice Swarendra Kumar had mentioned about committees and all that. Excellent idea. Now, you look at the judgment of the Supreme Court in Rural Entitlement and Education Kendra, 1986, about the environmental damage being caused to the Mussoorie Hills by limestone quarrying. The Supreme Court appointed 3 committees, to see the impact of the quarrying. Now, those 3 committees looked at the environmental impact, not the social impact, not the economic impact. Okay. So now, would the decision of the Supreme Court have been different if the economic impact had been considered? I don't know. Would it have been different if the social impact had been considered? I don't know. But like we're talking about 1986, But today, we have the resources. I mean, we means the country. I mean, not the judiciary. Yeah. The executive has the resources to feed all this information to the courts, and to feed the information to themselves, and to feed it to the legislature, and to feed it to the courts. And they must do it. You can't say that, well, I'm only going to look at the economic consequence of some action that I'm taking. Forget about, public health, right? I'm going to look at the social consequence, forget about the economic consequence. It can't be. I think things have changed dramatically between 86 and today. So we must bring everything in together.
Well, thank you very much. The same question to Justice Sri Krishna as well.
No,
the question to repeat is that whether, just as nudge theory has been used and developed behavioral economics in understanding decision-making process, can we bring in a similar type of using even like psychology and economics in understanding, adjudicatory processes?
Absolutely, I agree with you. What Matan says is 100% correct. You have to look at the holistic 360 consequences of a decision. Basically, the decision of a constitutional court is focused on fundamental rights. But while doing that, what are we doing to the rest of things? What are we doing to the environment? What are we doing to social circumstances? What are we doing to the lives of the persons? What are we doing to the rest of the country? Something that is kept in focus. If you do that, then there can't be an objection. In fact, that is the right thing to do, because today all disciplines merge into it. And finally, all disciplines must merge into the concept of justice, not only law. Law is just the means by achieving justice, but while doing that, you can't ditch all the other circumstances that are there. I agree with you. That's the correct way of doing it.
Thank you very much, sir. This is Swatantra Kumar, please.
Yeah, I think
The same question.
to sum up is very simple. I think that we must, functioning of the courts should not be defined by restrictions which are neither intended in law nor which are required. The court should be open-minded to consider all facets of the problem and be ready to accept and educate. And I'm telling you that one of the introduced concepts in Maharashtra was that the judges during the training period, after they have joined service, would be learning all subjects. So I thought that was a very good suggestions made by the government, that the judges would be able to learn everything during their tenure. So it's an effort to learn. So you can't take education outside the ambit of the judicial process. It should be part and parcel. I think academics should have a greater role to play in the interaction with the judicial system of the country. I think it's a very progressive attitude. So I think we should cumulatively consider various factors and try our best to achieve a balanced solution which will not create an imbalance either in economic field, social field, or administrative field. That's what I think we should do.
Well, thank you very much, sir. It's been a fascinating discussion. I can go on and on. We have only 15 more minutes, and I want to take several questions have come, but I'm going to limit to a few questions. So let me start with Justice Madan Lokar. This question has come from a student. It says, the judiciary has been at the forefront at securing socio-economic rights to often the most marginalized. How does the judiciary go about balancing the rights of business or industry or the government with the rights of the public at times which come in conflict with each other?
Yeah, that's a difficult question to answer. Yeah, I really don't know. You know, it would depend on each case. You know, are you going to give greater importance to environment, for example, right? And if you're going to give a lot of importance to the environment, are you going to give greater importance to wildlife within the environment, or air, or water? It's very difficult to generalize this sort of a thing. But I think the judges would have to be well equipped, with all the facts before they take a decision in a situation like this. But I don't think it's possible to give a general sort of answer.
Sure. So you did pretty well for that question. It's obviously a difficult one. Justice Sri Krishna, there's another question. This is, of course, it's an opinion by the person who's asked the question. And the question is, in your opinion, do you think that high courts are often more sensitive to the needs and wants of the public at large, rather than at times the Supreme Court? And this person is making this observation in the light of decisions taken by the various high courts during the recent COVID-19 resurgence. They seem to have a better sense of the economic resources available and the situation on the ground, and can allocate accordingly.
Perhaps that may be true, because the high courts are in the midst of a state, and they know they have the pulse of the state in their hands, and the extreme distance between a state or the locality in a state and the Supreme Court might really not give them complete information of that. Sitting in Mumbai, I know what is exactly happening in Mumbai, but sitting in Delhi or elsewhere, it may be difficult to get a correct ground view of what is happening. So to that extent, it may be true, but not necessarily true in all cases. I wouldn't agree it as a general principle, but in certain circumstances, for example, if you are dealing with a local law, which person is better equipped to understand the Bombay Rent Act than a judge who has run through the Bombay Judiciary or the Maharashtra Land Revenue Act? Or like in Uttar Pradesh, some other law, and in Kashmir, some other law, in Kerala, some other law. People they have grown up with it, so understand it better. Ultimately, the matter will have to go to the Supreme Court. The Supreme Court will decide it. But then the person who has done it has a better equipment of the whole thing.
Thank you very much, sir. This question is to Justice Swatantra Kumar. The question is cost-benefit analysis, or as some of you mentioned, the balance sheet approach, a solution to many of the challenges that are being discussed? And if it is the case, why are we still missing it? Is it the problem of human capacity, or are there institutional challenges and limitations to implement the cost-benefit analysis across the board? In a way, NGT is much more suitable, but why not the courts as well, is the question that is being asked.
See, I don't think so that the balance sheet principle should be applied stricto sensu, in the sense that that should be the sole criteria for adjudication. I would frankly not agree with that, because normally your economic interests are in conflict with the constitutional rights. For example, whenever you will see, there will be a conflict between development and the environment. So you have to balance it out. You can't make economic factor as the basis for determination. Similarly, when we talk of right to life, as it will have a conflict with the industrialists. Minimum wages, it will have a conflict with the industrial group. So therefore you have to draw out a balance. I don't think you can say that the balance sheet in a given case should determine the fate of that case. I don't think economic principles is the sole criteria for determining judicial adjudication.
Thank you very much, sir. This is Madan Lokot. There's a question about the issue of healthcare. A contemporary issue is the issue of healthcare, and as can be seen by the current scenario, there is a need for massive overhaul of the healthcare system. This requires a deeper understanding of the interlinkages of economics and law. How can the judiciary help, especially with the need for striking balance in the public health system?
Yeah. Okay. The way I look at it is this. That issues of public health are issues that are concerning the entire country, right? And I agree with Justice Sri Krishna that the courts are not well equipped to say that, well, this is what should be done, that is what should be done. We need 1,000 beds in Delhi, but we need 2,000 beds in Mumbai. That's not the function of the court, and the court cannot do it. But I think this opportunity should be taken. I mean, this pandemic or the crisis that we are facing today should be taken to tell the executive that, listen, you guys have got to do your job. Don't just say that I'll go to the court, let the law take its own course. I can't take a decision, but if you want, you go to the court, let the court take a decision. Don't do that, At least definitely not in issues of public health and so on. Parliament sat for just a handful of days last year. Okay, no legislation. You've got legislation. You will see in the United States. You've got legislation. In England, because of the pandemic. What are we doing? We're looking at 1897 Epidemic Diseases Act. Why did we not legislate? So I think this opportunity should be taken. It's an unfortunate opportunity that has been placed before the courts, but I think this opportunity should be taken to tell the courts, to tell Parliament, and listen, you guys have got to do your basic job of governance. And then, if there's a problem, come to us. But don't come to us as the first resort. That's good.
Thank you very much, sir. Well, there are several questions, and we should wind up. I have one last question to all of you, and each one of you. I'm going to start with Justice Swatantra Kumar. So for all those students who are watching this program and across the country and beyond, what would you like to tell them particularly the ones who are aspiring to become a judge, what kind of, let's say, qualities and expertise and knowledge and perspectives and skills that they need to develop with a view to aspiring to becoming a judge, because you have all, had your own role at your time. But as we saw in the last an hour and a half discussion, how the world of law has become more complex when it comes to the kind of institutional expectations generated for the need for bringing in different types of analysis, including the law and economic analysis. So what is your message to the law students? What should they be doing now with a view to becoming a more holistic, engaged, effective judge in the future?
I think the law is complex today. The profession of law is even complex more than that. So it's definitely very competitive today but then it provides you a tremendous opportunity. My request to the young blood today is, which I normally call, is the 3H principle. So be humble, be hardworking, and be honest. Once you do these three things, and God being with you, whether you become a judge or you become a lawyer or you become, a corporate lawyer or you become an arbitration specialist or whatever, I think it will primarily depend upon your attitude, and you must judge yourself what appeals to your conscience the best and stick to that and go for your aim.
Thank you very much, sir. Justice Sri Krishna.
A question like this was addressed to a Chief Justice in England as to what qualities would he prefer in a judge, and he answered it very beautifully and said, basically, he should be a gentleman. He should have a liberal education. He should know music. He should know literature, a little bit of literature, blah, blah, blah. So they asked, the person who was asking the question said, but what about law? He said, a little bit of law also helps. So I would say, yes, you have to have an all-rounder ability and a little bit of law also. My father used to say, be a jack of all trades, but be a master of one. So be a master of the law, but be a jack of all the trades. Understand economic implications, understand the technology that goes into it, understand social justice. Well, you'll be a good lawyer, you'll be a good judge also. And as a lawyer, I have the 3 C principles, which I have adopted from Supreme Court judgment of the United States. One is to the court, to the client, and to your conscience. If you have all the 3, you'll be a good lawyer, and consequently, you'll be a good judge. Thank you.
Thank you very much, sir, for that. Justice Madan Lokar, you will have the last word on that.
Yeah, there's a law student who had asked this question to Justice Felix Frankfurter, right? And Justice Frankfurter gave a detailed kind of a reply as a letter. I was trying to locate it quite some time back on the internet. I was not able to locate it, but with great difficulty, I did eventually locate it. So I would request, the questionnaire and the person who's asked the question and several others, try and look.
But this is my question anyway, sir.
Huh? Oh, your question.
I'll look at it. Yeah.
Yeah. Okay.
Yeah, it was my question.
Well, you don't need an answer.
No, but for my students, yeah. But I will look at that, sir. That's very interesting. I'll look at that.
It's a beautifully written letter, and it just encompasses everything that we have actually discussed today. It's worth going through that letter of Justice Frankfurter. Yeah.
But you can still add what you think.
Well, what I think to be a good judge, well, you need a good executive who doesn't push judges around, and you're going to be a fine judge.
Yeah,
well,
being overall, that is most important.
Absolutely, sir. Well, I cannot thank you enough for this fascinating discussion. It has been an absolute treat and a privilege for me to have this FaceTime with the 3 of you. What an extraordinary tour de force that the 3 of you have provided. I think so many people who have seen it live, but also will be seeing it, would be immensely benefited by your candid discussions, your intellectual rigor, and the kind of extraordinary experience that you brought to bear to discuss a very complex issue with a sense of responsibility and a nuanced understanding. I'm grateful to you, each one of you, for your presence, sir. Thank you, sir, very much, Justice Sri Krishna, Justice Madan Lokar, and Justice Swatantra Kumar. With that, we come to the end of this thematic session. We will be starting in, say, 10 minutes at 10:55, the next session on a book discussion on Supreme Court and the Indian economy. We will have a group discussion on that, and we'll start in 10 minutes. Thank you very much.
Thank you, everybody. Please, thank you.
Thank you. Thank you.
Bye.
Good morning, Professor Sudarshan. How are you?
Good morning. Very well. Thank you.
Okay, so I think a very, very good morning to one and all present, to the entire audience who's right now watching us. I welcome you all to this session where we are going to have, I believe, a very enriching and interesting discussion on, again, Supreme Court and the Indian economy. The background for this particular session will be that there is a book that is being written on this particular subject, and that's why we've gathered here today to discuss the same. Before I talk a little bit about the context, the content, and very briefly about the book for which we have gathered here today, let me just introduce the exemplar panel that we have amongst us right now. Let me start by, although I don't think the audience anymore requires an introduction, but Professor Dr. Raj Kumar, who is the founding Vice Chancellor of OP Jindal Global University, Mr. Pradeep Mehta, Secretary General, Cuts International, Professor Dr. Ashish Bharadwaj, who's the Dean of the Jindal School of Banking and Finance, and Professor R. Sudarshan, who is the Dean of Jindal School of Government and Public Policy. My name is Sakhisha, and I am truly, truly excited and very, very delighted to be moderating this session amongst all of you. So thank you and welcome once again. In terms of setting the context, I think this entire two-day conference is very, very important right now, and it's very, very pressing, considering that due to COVID, before COVID, we are seeing the intersections of law and economics come to fore even more. We are understanding the importance of balancing lives and livelihoods, the importance of looking over at the economics side of it even more now. And so I think that this conference is very, very timely, and equally timely is, I think, the book which is being authored by Mr. Mehta on this panel with support from JGU. So I think that having closely worked and the research bit of the book, I can say that it has been a very, very enriching experience. The book covers almost 5 to 6 cases where we are trying, where Mr. Mehta has tried to, map out the trajectory of how these decisions have come about and what has been the economic impact of these decisions. I think what the overarching narrative that is coming to the fore, like I said, because of the pandemic and even otherwise, has been that there needs to be a balance. There needs to be a very, very fine balance between economy and probably every other domain. Of course, that doesn't mean to say that, we have to overlook all of the other aspects, either it be the letter and the spirit of whatever law is in front of a particular bench, or it is social justice, public interest, environment. The debate isn't to put those things down. But I think one of the main reasons why we are having this debate in the first place is that since a very long time now, all of our attentions have been on the social environment aspects of things, which rightly so is very, very important, because we are going through, again, very, very unprecedented times with respect to climate change and emissions and environmental degradation. And of course, we need to fix that. But I think the reason we are here today is that because earlier, I think it was just economy. And now we are moving from that narrative to environment and social justice. And what we are failing to do is draw a link between these two. What we still continue to do is look at these domains and these particular aspects of our lives in silos. And I think which is why this session right now and the book is very, very timely and very, very important, because we are focusing on and we are talking about drawing a balance between all of these domains, which is exceptionally important. I think without me delving more into providing the narrative and setting the context, I think I'm going to now move to Mr. Mehta, considering that he is the author of this book. Mr. Mehta, I would like to start with you, and I think it'll be great if we can understand that what have been the motivations to write this book in the first place.
Thank you, Saki. I've been a consumer activist and a public policy advocate since the last 40 years. So this is another milestone in my life, in the sense that something which we have always been worried about, as well as the concern that, how does the judiciary come up in terms of the kind of adjudication it practices, and what would be the impact on the economy? Has it had the kind of the desirable impact on the economy? At another level, what we have been doing on a regular basis is regulatory impact assessment. And there again, what we are looking at is how regulations and policies impact the economy, looking at a cost-benefit analysis and so on. And that wisdom or that kind of experience triggered us into looking at this kind of economic impact of judicial orders. And it is with this kind of background that we spoke to friends in the government at a very high level, and particularly Niti Aayog. And it was decided that we should do a case study of a particular order which did not have the desirable result as it should have. I'm talking about the sale of liquor, a ban on sale of liquor within 500 meters from the highways. And very interesting, muddled up story if you look at it carefully, and that is what you'll find in the book that I've written. So how muddled up it was, and that it did not achieve its objective at all. On the contrary, what it did do was to cause a huge loss to the industry, tourism, etc., job losses and so on. Now that particular learning that we could derive and led to a good debate, even among the legal circles, and you have already heard from some of those people who are participating in the debate earlier during this conference, and you'll hear more about it as we come across. Now, as I said, if you look at the kind of career which I've led, and Sudarshan is a fellow traveler in that sense since last 35 years, 40 years, that he has been supporting us when he was with the Ford Foundation. How do you create a questioning culture? That has been the primary motive behind this particular journey that I've had. And that then therefore reflects in this kind of book also. And Shaki, as you rightly pointed out, the book will certainly have some reverberations and would lead to further discussions and debates. More importantly, when we analyze these cases, we did not question the legality of the orders as such. I mean, instance, courts are entitled to having their mind set in a particular order, what they argue. You may not agree with it, and there's a provision for appeal and revision and so on and so forth in the procedures matter. But what I'm looking at is, could there have been a better remedy? What could have been an alternate remedy? And in order to arrive at an alternate remedy, one can understand that judges may not have that kind of thinking or wherewithal mentally in order to think about alternate remedies. In many cases, we require more technical advice, either economic advice or financial advice or subject matter expertise as well. Now, when you look at road safety, for example, I mean, the case that I spoke about, there was already a committee established by the Supreme Court to look into road safety. And one of the muddled up things about the highway liquor ban case was that committee was not even referred to. I mean, the kind of continuity which is sort of lacking, which only showed as to, what is happening. And that committee has two road safety experts. In fact, one of them is an administrative expert, so that if that committee was consulted, the committee would have given the right advice to Supreme Court as to what is enforceable, what is not enforceable. And we did a lot of field work also in order to see that, to see what would have been the enforceability. It was impossible. Having said that, the learning from that particular case was what led to further work from Niti Aayog to look at 5 more case studies, 3 from Supreme Court and 2 of the National Green Tribunal, very famous ones. The Goa iron ore case, the Mopa airport case in Goa, the Sterlite copper case in Tuticorin, which is again in the news now because they're not allowed to reopen their oxygen plant, which is what is a dire need today. I mean, look at the kind of situation that we are now in. Now, when we started looking at all these cases, we found that there are alternate remedies which are available, and that could have been explored by the court before jumping into this. Not only that, but there was a very interesting case law which came up in Supreme Court, which is what I've covered in this particular book. The book contains 6 case laws, of which 5 are the ones which deserve better handling. And the 6th is this very small case law of Shiv Shakti sugar mills, where the learned judge, and I use the word learned in common parlance and not as a legal jargon, said very rightly that one has to look at overall justice. If you look at a comprehensive justice, which means you have to look at the economics of the matter as well. Unfortunately, that precedent which was set by that Justice Serene and Justice Sapre in that division bench in the Shiv Shakti sugar case, we thought would become a kind of a lodestar or a
Justice Sikri. Justice Sikri it was. Yeah.
Sikri, I'm sorry. What did I say?
Serene.
Sorry. Yeah, Sikri. Yeah, of course. That unfortunately it did not sort of, how should I say, translate itself into the thinking of other judges that this could be done. And Justice Sikri very rightly in that case also pointed out that Article 142(1) of the Constitution of India allows the court to take a broader view. Of course, there are counter views to it as well.
Mr. Mehta, if I just may, I think before we move on to the counter points of it, could I just request you to maybe conclude so that we can go on to further questions and then build?
No. That was a very good case law which would have set the road. But we hope that the book would be able to raise the ante on the debate further than what has already happened. Thank you.
Absolutely. Thank you, Mr. Mehta. I think I greatly agree with the fact that Shiv Shakti Sugars indeed was a very unique judgment in terms that the bench in that particular case did take into account the fact that we need to look at the economic side of it. But at the same time, I think Mr. Mehta also spoke about subsequently the other 5 cases that we at Cuts are currently studying. Interestingly, all of those 5 cases are environmental cases, and all of their decisions and judgments have come because the bench adjudicated that there were environmental harms which were being caused. My next question is to Professor Ashish Bharadwaj, where I think it'll be great if you could shed some light on what exactly does an economic analysis entail. And when you look at all of these case laws, for example, these 5 cases, either it be Sterlite, Mopa airport case, Goa iron mining or sand mining, so on and so forth, or even the ones which are covered in this book, how do you draw that balance between looking at economy and environment, or economy and public justice, and economy and the law, the letter and the spirit of the law? And a follow-up question to that, Mr. Bharadwaj, Professor Bharadwaj, that I have for you is also that how do we balance? And does that mean that economics will overrule all of these other aspects as well?
Thank you, Sakhi. First of all, let me congratulate Mr. Mehta for the book. It really is it's a very brave and ambitious effort to make a real contribution in a field that's largely neglected in India. And this book certainly promises to change that. Let me address your question now. What exactly is law and economics? What does it entail? First of all, it shouldn't come as a surprise to learn that lawyers and economists, they think in very different ways. They are trained to think differently. And as a matter of fact, the book is a fascinating example of how the academic rigor of this discipline, law and economics, is applied to the real world to understand consequences that are far-reaching in nature. So let me elaborate on that. I know there are a large number of researchers, students who are watching this, who are going to be viewing this later. Lawyers typically begin with a dispute or a loss which has to be resolved. Right now, the approach focuses on the distributive issue of how to allocate or reallocate a given loss or harm between parties in the dispute. Given this focus, the professional skills that lawyers are wonderfully equipped with in law, they tend to be seen through a very narrow lens, I'm afraid to say. Because if you think about it in this way, there is no necessity to develop either a theory of law or a broad view of its social or even economic effects. These are simply irrelevant to applying and to understanding the law. The wider effects are not likely to be part of a lawyer's experience, in my opinion. Think about it for a minute. If the law is successful in deterring all kinds of wrongdoings, accidents, crimes, whatever, it means that a legal dispute has been avoided. In short, successful laws would mean less business for lawyers at the end of the day or the entire field. Now, the economic approach differs from this practical process of applying law to cases. For economists, typically, anything that has already happened in the past is just sunk cost. The economist does not view law as a set of rights or remedies, but in fact as a system of incentives and constraints affecting any kind of actions that may come in the future. And as a result, the primary focus of economists, unlike lawyers, is on the wider repercussions of law on potential litigants. I think we're going to get into the specificities of the cases that Mr. Mehta has wonderfully analyzed over the course of this session. But I'd like to say that the two disciplines really complement each other, as has been demonstrated in the book by Mr. Mehta in each of the 6 cases. The last part of your question, when you say, does economics trump law? Does it have to outweigh or law or legal principles? Absolutely not. I mean, and at any point, if that is happening, then we are taking the wrong direction in this analysis.
Thank you very much, Professor Bharadwaj. I think that the mere fact that both of these disciplines, law and economics, as Professor Bharadwaj, you rightly pointed, that their purposes and their aims are different, but at the same time, all of those purposes and aims, they do at one point, they do meet each other. There is a coherence between the purposes and the aims of both these domains. However, considering because they are so vastly different at the same time, I think the perspective of the judiciary has been, which we have seen over and over again in various debates, various articles, and with the way that the judiciary takes this entire law and economics approach to head, that it is beyond the mandate of the judiciary to do this. That it isn't in the mandate of the judiciary to look into the economic analysis of things, but rather stick to the facts and the evidence which is presented before the bench, stick to the letter of the law. With that, I think I will move on to my next question to Professor Raj, which is that what do you think are the main challenges, the main barriers which impair our judiciary to look into and undertake such analysis of to undertake an economic analysis of their decisions. Do you think it is a lack of infrastructure, or do you think that there is genuinely a problem in not understanding the intersection between these domains? Because of course we understand that the judges which are sitting on the bench are not necessarily experts in economics. They're not necessarily experts in undertaking such analysis. So what are some of those key barriers, and how can we probably overcome those?
Thank you, Saki, for that question. And I will join hands with Ashish and other colleagues from OP Jindal Global University to congratulate Mr. Pradeep Mehta for really producing this book, and also Cuts International for taking leadership in addressing some of these issues. Saki, one of the things that I've realized over the course of the last several years interacting with both sitting and former judges of the Supreme Court of India and also other high courts is that there is something to be said about, legal and judicial responses to visible forms of injustice and invisible forms of injustice. And visible forms of injustices are easier to respond, and their comfort zone is that. So, for example, if you look at the growth and evolution of public interest litigation, as well as human rights elements of a whole range of invoking constitutional jurisdiction, the courts have been quite active in responding to more visible forms of injustice, where their training and their knowledge of law and expertise and skills, there's a comfort zone to it. But the moment you enter into areas such as economics, for example, even when there are what I would call invisible forms of injustice, where the nature of analysis expects a far greater and a deeper and a more nuanced approach to its evaluation and examination, the courts simply do not have the capacity to pursue that. And in that process, what ends up happening is that most of the time they are actually left with the dominant voice of the executive, which has its own, let's say, biases and prejudices. Even arguably the public and civil society discourse, which at times dominates as well. Those in the cacophony of the discourse that happens in many of these matters, and 2G and 3G and coal block are very good examples. Courts are hugely, let's say, disabled when it comes to having a more nuanced understanding of it. So I strongly believe that I think the economic dimensions towards adjudication need to be brought to bear at a very early stage of legal education training, which we do in law schools. But equally important is what we end up doing in state judicial academies as well as the national judicial academies, that more and more expertise need to be developed within those institutions. And unfortunately, there also, I must say that more of the same is happening, as opposed to people coming from very different disciplines. Typically, a large number of judges themselves go and train other judges. I think while there is a case for that to be done, there's a lot more need for economists and sociologists and anthropologists and political scientists and others to constantly be engaging with the judges. The third thing, which I think is something that we need to also recognize, and this is a very unfortunate aspect, is that we have seen a huge, if I look at in the criminal justice world, we have seen two trends in the last 3 decades. We have seen criminalization of politics, and we have seen politicization of crime, both of which has affected the ability to protect the rule of law. In the world of law and economics, we have also seen, politicization of judicial decision-making, and also politicization of, economic decision-making. And both these things have adversely impacted the ability of independent institutions such as the court to respond to it. So in many ways, if you look at these cases, the biggest reliance that the Supreme Court actually has is largely to Article 14 and the use of arbitrariness, almost arbitrarily using arbitrariness. And so the arbitrarily using the doctrine of arbitrariness has a deleterious impact on very many aspects of the economy, and that is exactly what has happened in a number of cases. So I think we need to bring in expertise. In fact, we just had a very interesting discussions with the 3 former judges, Supreme Court of India, a few minutes ago. And one of the things that emerged out of the discussion was all of them were in consensus that we need to have more, but most of them were not sure how to bring that expertise in. And we really need to address that question. To what extent? We are far away from the French Constitutional Court and maybe other courts in the world where non-lawyers could be judges. We even have a much lesser, not that lawyers have, by the way, expertise in this actually. So Competition Commission is one of the fewer examples, and the National Green Tribunal is another example where adjudicatory bodies have had people who are not trained in law to be part of the decision-making process. We really need to evolve a system whereby other disciplines, including law, including economics, play a very substantive role in the adjudicatory process.
Thank you. Thank you very much, Professor Raj. I think you've raised some exceptionally great points, which is going to make it very easy for me to move on to my next question to Professor Sudarshan. Professor, I think Professor Raj very, very appropriately and very succinctly put it that we need more expertise. We need more diverse fields to come together. We need more people learning and reskilling and upskilling with respect to these various domains and various fields of whether it be law or economics or so on and so forth. Professor Sudarshan, do you think that making economics as a subject, a mandated subject for law students, and I don't mean it only the microeconomics, which I think most of the 5-year courses do offer in the first semester for 3 months, but I mean in terms of looking at the economics of probably all of the laws that you learn, whether it be competition law, whether it be corporate law, whether it be civil law, tort law, contract law, so on and so forth. Do you think there is a need to mandatorily imbibe economics in the coursework of law schools? And secondly, do you also think that it is equally important for other domains such as students of economics or students of other social sciences or even engineering or mathematicians for that matter? Is it equally important for those domains to also teach law to ensure that we can have a holistic interpretation and intersection between these domains?
Thank you, Saki. The general point is that all education should be much more interdisciplinary than it has been. Over a long period of time, different disciplines have placed themselves in silos. And it's like then the fable of the blind men looking at the elephant and touching one part and inferring from that what the rest of the elephant would look like. And there's a good moral lesson in that fable, which is that you cannot narrowly be just the economist or the political scientist or the lawyer. All education should be, as far as possible, interdisciplinary. But before I come on to that, I just wanted to say that I'm particularly happy to be in this particular session because of my long association and friendship with Pradeep. I thoroughly enjoyed reading the book last night because it's so, it's written with his characteristic style. It's not a heavy, turgid academic kind of book. It's very matter of fact and makes the points very succinctly. So the readability of this particular book is first of all to be commended, although it's dealing with an issue that's reasonably complex. So having said that, and to your question about whether, you see, my first lesson when I tried to understand, my training is in economics, but then I got very interested in law. My first discovery, so to speak, for myself, is that lawyers and judges, by and large, because they deal with rights, and one of the fundamental principles of law is that everybody is equal under the law, right? So that first principle, that the law applies to everybody equally, gets into the DNA of judges and lawyers, so to speak. Now, consequently, what happens is that unlike policymakers, judges think in terms of all or nothing, whereas a policymaker has to think in terms of more or less. And we encountered this difficulty at the start of the Constitution of India. The moment the Constitution of India provided a right to property. Now, even when the right to property was being inserted into the Constitution, all members of the Constituent Assembly, barring one or two, who were themselves zamindars, had agreed that zamindari abolition is necessary, that these big landlords who had vast estates like Maharaja Kameshwar Singh of Dharbhanga, their estate should be taken over by the government, expropriated actually, for no compensation or a token compensation, and that land should be redistributed to tenants who are actually tilling the land, and this is fairness. Moreover, there were compradors with the British; they did not support the nationalist movement, and so on. Now, the first thing that happens after the Constitution comes into force is the judges say there is a right to property. And this right to property applies to everybody, whether it is the humble man in his hut, or whether it is the Maharaja Kameshwar Singh of Dharbhanga. They all have the right to property, and the right to property in effect means that you must, when the state takes it for a public purpose, let's say redistributing it to tenants is a public purpose, it ought to pay a fair equivalent or compensation. Now, everyone understood before the right to property was inserted in the Constitution that there would be an exception for the sake of the zamindars. And in fact, the zamindari abolition laws in many states had been passed before the Constitution came into force. And there is a reference to those laws in the right to property as it was originally drafted in the Constitution. But still, the judges, being judges, say, well, I can't understand why we should make a distinction. Everyone has the same. Now, if they only thought about how income tax is structured, tax rates are higher for those with larger incomes and lower with smaller incomes. And the line that you draw between 100,000 and 500,000 and the tax rate is completely arbitrary. It could be something else, right? Now, somehow that's been internalized and accepted. But when they are asked to adjudicate, they tend to, now let me give you a very recent example, which in the second edition of Pradeep Mehta's book, we should discuss. And this is a recent judgment on the 21st of March regarding a moratorium on interest payments because of the COVID crisis, right? The RBI and the Government of India declared that there would be, that people with loans to banks needn't pay interest for a certain period of time. They would have to pay interest, but later. The interest payment was deferred, right? And many of these people in a public interest litigation case, and this is not the kind of public interest litigation that we originally know that was created by Justice Krishna Iyer and Justice Bhagwati. That was meant for, the really voiceless underdogs in our country, the underprivileged. Anyway, this came as a case with a public interest label to the court saying that, it's so difficult that all interest should be waived. And the period of waiver must be extended, and so on. So in a remarkable judgment, M.R. Shah writes this judgment. He quotes a number of precedents of the Supreme Court in a number of cases, including the Narmada Bachao Andolan case. But the court says it's not our business to interfere with economic policy. We don't understand economics. We don't understand the financial implications of extending the moratorium or canceling interest rates and so on. These are all in the domain of the courts, or in the domain of policymakers, and we will not overturn what they do. So they refused all of these requests. But being judges, and judges thinking in terms of all or nothing, what do? The Reserve Bank regulation said that this moratorium on interest payments would apply to loans that are of a value of 2 crores, I think. And this means it's meant to help retail businesses, small businesses, medium and small scale enterprises. The court then says, after having held forth on why they shouldn't interfere with what the government had decided, they say, no, why is this limit there? What is the rationale for this limit of loans of 2 crores? Suppose somebody had taken a loan of 5 crores and had paid up, but they now had 1 crore left. Why don't you give them a moratorium on that 1 crore? Just because the original loan was 5 crores doesn't mean they're not in difficulty now today because of COVID. So we don't understand the rationale of making a distinction between those with loans of 2 crores and those with higher loans. Therefore, all loans would have the benefit of this moratorium. Now, isn't that making policy? Right? Quite unconsciously, even after having recited at great length many judgments saying they should not enter the policy-making arena, they don't know the financial implication. What's the financial implication of this decision? It doubles, it more than doubles what the government of India would have to underwrite if the party concerned in that loan is unable to repay that, right? So eventually when the moratorium ends. So this is what I mean. There is, first of all, it's important not what you teach, whether it's economics or sociology or politics. It's about how you approach your profession and your job. And if you remain fixated in this business of all or nothing, and this is an instance, very interesting instance, because a judge who's conscious that they must not interfere with policy, nonetheless can't resist coming up with a verdict that has policy implications and revenue implications for the government. So this attitude needs to be changed. So I'm not saying that you should learn economics. I mean, you need to have common sense. What comes through glowingly in Pradeep Mehta's account and his critique of the 5 cases is common sense. And what comes through in Arjun Sikri's judgment in the sugar mills case is common sense. 15 kilometers, 2 sugar mills should not be there, right? And there's a big dispute about whether the other sugar mill was functioning at the time the other sugar mill started and so on. These are common sense. There are 2 sugar mills. They are servicing it. There are sugarcane farmers who are willing to give them the sugarcane. The original rationale for that distance was that each mill should have a sugarcane supply. And if they were too close together, all the sugarcane may go to the one mill and the other mill may be left with too little sugar to crush and may not be viable. Whether that's right or wrong is not the point. But what the judgment comes through is common sense. So it's not sophisticated economics. So the only regret I have is that Pradeep makes references to these American scholars who have created a movement called law and economics, which is part of a neoliberal agenda, which buys wholesale lock, stock and barrel, that economic rationale and economic efficiency is the be all and end all. And judges in their decision should not just do justice between the 2 parties before them, because that's a contingent circumstance. They must think ahead and maximize wealth for the country and make a decision on that basis. Now, judges have to decide equity, fairness, justice between the parties. That's very important. So I completely disagree with the law and justice movement in the law and the economics movement in the United States. And in the next edition, I wish Pradeep Mehta will excise references to Richard
Posner.
Yes, and Guido Calabresi. Thank you.
Sudarshan, you referred to both of them in your opening remarks.
Yes, I did, but I also meant
and vividly.
Thank you.
Thank you very much, Professor Sudarshan. I think I think there is no doubt there is no doubt that there is a greater requirement for interdisciplinary approaches to come together, either it be in schools or either it be in policy making or in the judiciary or wherever. I think it's the comment that you made, Professor Sudarshan, about lawyers looking at all or nothing, whereas policymakers looking at more or less. I think even over there needs to be a fine balance again, something that remains the constant narrative, the constant theme of this entire conference, I believe. But in that sense, I think, how do we go on achieving that? How do we go on telling the judges or the judiciary that you need to move beyond all or nothing, maybe come in the middle, look at the gray part of it as well? Do you, in that regard, I think I'm coming up with my next question, which is to Mr. Mehta. Do you think, for example, all of the examples and case laws that Professor Sudarshan talked about, do you think it would help if we institutionalize a feedback mechanism, a post-judgment audit system, which does not necessarily, of course, if it happens by and for the judiciary, it's nothing more that we can ask for. But even outside of the judiciary, do you think that policy think tanks or research institutions or academic institutions should undertake such post-judgment audits more and more, and probably then go and probably submit that to the benches, to the courts, for them to understand that this is the impact that there has been, whether it is a positive impact or a negative impact, that could be besides the point. But do you think that there has to be an inbuilt, institutionalized post-judgment audit, which also Dr. Manu Singh, we talked about yesterday in his plenary session, that we lack such an audit system? So Mr. Mehta, what do you think could be the enablers for such kind of reforms? And of course, at the same time, what are the barriers in institutionalizing such systems?
Thank you, Saki. Thank you very much. I think it is an imperative, I would say, if the judiciary would like to see it evolve as a very sensible institution, where to get its own actions analyzed and publicly debated. There's no harm in that. And how it can be institutionalized could be various ways. You have the Law Commission of India, for example, which could also look into this, or maybe the Supreme Court itself could set up a body which will do this on its own, because ultimately the court is fairly independent and does not wish that the administration decides to develop an institution. Because you saw what happened to the National Judicial Appointments Commission bill. It was thrown out. I mean, I didn't see anything wrong in it at all. It was still chaired by the Chief Justice of India, and it had two people from outside the judiciary to assist the commission in order to. That was a very good approach in a sense. What has been said so far, that look, there are many issues which require to be looked at in a different way than in the traditional way, which is not a black and white way. And therefore, that again is a very good example of something. Now, one debate of which we have been a part of, adjudication versus technical expertise in India has been the Consumer Protection Act and the medical profession. And they've been asked, they're saying the same thing. If you remember, there was a time when the medical profession argued against the application of Consumer Protection Act to the services, which of course Supreme Court struck down and so on and so forth. But the questions again was, look, the fora do not have a doctor on board. You don't have to have a doctor. You don't have to have any expert in any matter. It's the court which has to ask an expert to come and lead evidence, and then decide on that particular basis as to what is the best way forward. So, Sudarshan, the point which you made, and you made two contradictory points. One is that commonsensical, yes, but interdisciplinary would not work at all. It would not work. I mean, you can't expect a lawyer or a law professional to learn economics. The least they can do is to learn appreciation of microeconomics or behavioral economics, which is very important in order for them to use appreciation only, I would say. I would not go beyond that. And then ultimately,
I agree with you. I agree with you. I meant general education should be more
exactly.
interdisciplinary.
No, I'll give you another example of, there's a very big loophole that I discovered the other day. That the medical course does not teach anything about medical safety laws, the Prevention of Food Adulteration Act or Drugs and Magic Remedies Act, etc., etc. And the same doctor, as the chief medical health officer per district, is also required to administer these laws. Yeah. But we were never taught this in our course. For example, there could be many such anomalies we can come across. So my answer to them is the same. I said, look, you are supposed to have a food safety expert with you. You need not know the particular laws yourself, but commonsensically you can understand when the law says that, look, adulteration is, this is an adulterant, and this is not an adulterant, or whatever it is. So
actually, Pradeep, I want to just quickly add that, well, I do agree on that point that you don't need the knowledge of economics in its profound manner, but you need sufficient individual and institutional humility to recognize that you need to go to others, including experts, to come back to you with a report or whatever that will help you inform the decision-making process. I, for one, strongly believe that both the coal block judgment and the 2G and other judgments would have been vastly different if such a study was commissioned by the court with a bunch of economists to come back to them that the economic implications of this whole thing, that to inform the decision-making process. And that requires not so much knowledge of economics, but a recognition that to make a judgment of this kind, you need to apply some thinking that goes beyond law.
Raj, I agree with you 1000%. If there is a word called 1000%. The point is that I agree with you wholeheartedly. And whatever you have said is something which is what I was also saying in some other words, not as sophisticated as your language. But the fact is that, and Sudarshan rightly said, that it's a common sense that you have to use in many of these issues. We cannot look at the rule of law. And one thing which was said in my opening remarks as well, the inauguration, competition law is one great teacher which teaches you about rule of reason rather than rule of law alone. So there are laws which are designed and drafted in a manner where rule of reason is important. Now, when you look at rule of reason, the kind of parameters which have been prescribed in the Competition Act, they require an economic analysis. Perforce, they require an economic analysis. It cannot be done by lawyers or by the court which is sitting, or the bench which is sitting there. So what I'm only trying to say is this, that we have to be careful about this, that there should be regular orientation of judges. Now, particularly, Raj, now that we have these commercial courts. Commercial courts will deal with all disputes straddling law and economics, whether it's auctions or contracts or Sale of Goods Act or what have you. So therefore, those judges particularly should have a little better understanding about economics than what they have today. So what we have to look at is the future, as well as to where is it that we should do. And this is what we have said, I have said in my book as well, that we require these kind of changes to come in. And of course, just to conclude, Sakhi, the question which you said, a sort of ex-post audit is always helpful in any situation. You do post-mortem, don't you, of a dead body? Why do you do a post-mortem? In order to ensure that the cause of death has been established to be the right cause and not any other thing which may have happened. So similarly, that post will help understand, will allow the judiciary to evolve, to understand that, look, this is a mistake made in this particular case, and this is how it could have been handled. Thank you.
Right. Thank you very much, Mr. Mehta, and also Professor Sudarshan and Professor Raj. I think we have spoken about the need for a post-judgment audit. And I think we understand. And of course, I personally believe that that is an important system to integrate, because that is the only way to have a feedback mechanism for the judiciary, to understand that the decisions that they give, what has been the impact of it, as I said earlier, positive or negative, that is besides the point. However, I would very briefly like to go back to Professor Sudarshan again. And so I wanted to ask, do you also think that an ex ante economic assessment could be maybe a better alternative to a post-judgment audit? Or are both of these exercises parallelly equally important? And do you think that an economic analysis, when we talk about economic analysis in the current context, I think we are focusing largely on numbers and data and quantification of the data. But do you also think that behavioral economics should make part of such analysis, especially when we are dealing with cases of social justice and environment versus economics?
Yeah, thank you. Yes, the point is that judges can't be expected to be economists in their own right? But they're dealing with matters that have economic implications and consequences, which they are not expected to know. Now, firstly, what's happened in our country, unfortunately, is there was a time, and I've seen statements of objects and reasons of statutes and gazette notifications of subordinate legislation under the statutes. And in the earlier years, there would be a note appended to it on the economic implications of that particular statute. What would it cost the government? It's an estimate, but it is done by the government, and that forms part of the legislation, the statement on objects and reasons. Now, unfortunately, over the number of years, the legislature and the executive have dispensed with this exercise. Very often they come up with ordinances first, and ordinances don't have, an elaborate statement of objects and reasons and an analysis of the economic consequences of that particular piece of legislation. Now, the ordinance mentality has taken over, and this affects the bills, eventually the acts. Now, that would have been informative to the judges to have that. It's not that. Now, I can't understand why in other common law countries, it's a constant practice to invite an expert. In fact, my classmate from Delhi School of Economics is a very wealthy person in California today, because he appears as an expert witness in matters related to telecom. Exactly the sort of thing that our judges were woefully unmindful of when they canceled and said auction ought to have been followed. Even though in the judgment, they write about auction not being the only one and they are not the best judges of it, but they never consulted an expert. They don't invite an expert to give testimony to the court. Now, it's in the case of public interest litigation, when Bhagavati and Krishna had started it, they appointed commissioners who were knowledgeable people, who had experience. Go and find out what is the circumstance with child labor in in Mirzapur district or bonded labor in Mehrauli. They did that for those cases. But when it comes to cases like the 2G case or the coal block case, which is quite complex and sophisticated, with a number of complex issues, a number of different players differently situated. Now, normally, judges should be very good at looking at individual parties and doing justice unto them. But in these cases, they kind of clubbed everyone together. And, for instance, they imposed a unit, which means that their integrity is assured. The concern we have with expertise appearing in a court is, are they in the pay of one party or the other? Are they doctoring their so-called advice to the court because they've been paid by one or the other parties? But if you have a culture where there's professional sanction of integrity, that is, somebody says so-and-so is a cardiologist, well-trained, knows what cardiology is or what dentistry is, there are certifying institutions. Similarly, in many areas of economics, we could have this kind of a certification process so that those people are called upon to give advice to the court. So ex ante is very important. Ex post is for the education of judges, for them to feel guilty, really, about the enormous consequences they have unmindfully imposed on the larger polity and the community.
Thank you, Professor Sudarshan. I think very quickly now I'm going to move to Professor Bharadwaj and take on from Professor Sudarshan's comments, especially with respect to the coal block allocation case and the need for experts and the need for the courts to, call upon more experts or maybe create expert committees for that matter. Professor Bharadwaj, do you think, especially in the coal block allocation case, that things could have been probably done differently? And what do you think that when we, let's say, when the court constitutes an expert committee, how should, even by the committee, an economic analysis should be done? What do you envisage that these expert committees, how will they analyze these decisions? And a follow-up that I have very briefly for that is also that we have a very, very grave problem of pendency and backlog in our courts. And we have seen more often than not that when the creation and the introduction of such expert committees probably prolongs these processes as well. So how do we ensure that the pendency goes down, the judicial decision-making process is faster, but at the same time, we're also able to engage with experts?
Thanks, Saki. Very important question that really requires a comprehensive response, because out of the 6 decisions that have been analyzed in detail in the book, I believe the oldest one is the coal decision, which simply means that there's more data available now on how it impacted, what exactly did it impact, and in what ways. So please bear with me as I kind of try to provide a context and provide some details of how to look at economic impact. And Mr. Mehta has captured it really well. The way he has analyzed this particular case, it gives us insights into how, if you use reliable data and a nuanced economic reasoning, or as Professor Sudarshan says, the logic, common sense, it really provides you with a very different picture than what is captured by either the court or the media. So if you recall, just before COVID struck, the biggest worry for the government of India was the out of control fiscal deficit, if you recall. And it was being caused by slippages at the state level because states had waived farm loans. They had pumped a lot of money to rescue bankrupt state electricity boards, and this led to piling up of a lot of excessive debt. Now, the result was that the combined fiscal deficit of both the center and the state, which is a figure which economists very closely look at, reached, and I remember very clearly, a dangerous 8% of GDP. The question is, how did we get here? The reasoning, in my understanding, is the failure to complete existing projects on time due to cutting off of the entire supply of raw materials forced so many industries, so many firms in heavy industry to resort to lending. This happened between 2015 and 2018, and there's data available for this. Now, remember, this lending that I'm talking about is to cover operational losses. This lending is not to fund capital expenditure for any new projects or expansion of projects. You're trying to cover your losses by borrowing more. So owners of these distressed assets, including those in energy sector, steel, power, and so many others in heavy industries, they had zero to uncertain fuel supplies left as raw material. So the last resort was, and in some ways it continues to be, to contract with commercial coal suppliers abroad to revive domestic projects in India and stay afloat from the risk of liquidation. And this is where I think your question now kicks in, that this started with the decision that came out in 2014, cancelling and arbitrarily, in my opinion, more than 200 coal blocks, not just in the private sector, but also government-owned blocks that were allocated not just from 2004 or 2010, but since 1993. And relying on an erroneous figure, I don't remember exactly, but around more than 200 lakh crores, which was cited as notional loss. And this is what the media captured. The book and the chapter particularly that Mr. Mehta has on the case capture some of these details quite comprehensively. Saki, I use the word erroneous in this figure, this notional loss figure, with responsibility. I've even written about it. The basic understanding, the basic underlying logic, common sense, as Professor Sudarshan is saying, the economic reasoning was completely missed or ignored by the court. So let me explain. The report that the court relied on, from CAG, it had a figure that was calculated, simple economics, deducting the cost of mining from the price of coal. Right? That's how we get to the outcome, revenues or losses. Now, this was not just any price. The price that was taken was the price which Coal India, PSU, receives. The price of coal, by the way, is neither constant over time nor across firms that are operating in the same country, in the same industry. And that massively affected the calculations. It's just astounding that CAG ignored the basic concept of net present value. I mean, we learn it in school and then in first year in college, which is the simplest method of calculating return on investment, which is made over a period of time. Now, there were two more assumptions taken in the report, which just turned everything upside down, that were completely flawed and they turned out to be blunders eventually. Which is what I meant when I said it's the oldest decision captured in the book, so we have more data now. It was assumed that the quality of the coal remains the same, and Mr. Mehta has captured it wonderfully. And not just the quality, the cost of mining also remains the same in the industry. Completely flawed assumption, both are incorrect. There are 7 quality or grades of coal that are found everywhere in the world. In India, we have the 2 lowest grades, the worst quality possible, which means that when you start mining it, you need to invest a lot of money to make sure it reaches to a certain level before you can, generate electricity or do anything out of it. So this is what I think was missed or the court kind of overlooked in pronouncing that decision. Your second question, which is about the real economic impact of the decision, is still unanswered. So let me take a minute or 2 minutes to answer what was the impact of that decision in 2014. You see, soon after the decision, there was an excessive and artificial shortage of coal because of the dependency that the entire economy has on this raw material. Now, this led to a major crisis of non-performing assets. Now, basic economics tells us that rising NPAs, non-performing assets, are always a reflection of an underlying systemic problem. It's a means you use, you base your reasoning on to get to the real end of the problem. The heavy industries, including power sector, has an almost automatic ripple effect on the banking system. Because if you are not operating plants, they won't be servicing debt, period. And it's true for all heavy industries because the sunk costs they have to incur are enormous, unlike any other industry. And the repayment of debt can only start after you commercially start your operations. Now, if you remember, NPAs were also headlines for several weeks in 2019. The late Finance Minister Arun Jaitley was kind of very vocal about his views back then. Even our largest bank, State Bank of India, had a massive exposure to the power sector that was hit by the same judgment in 2014. So this is about the industry. What about the other key stakeholders that are relevant in the economy? The decision even resulted in households carrying the burden of higher electricity prices. The state lost income tax revenues from the cancelled coal blocks, which could have contributed immensely to all kinds of state spending, including social sectors. On the contrary, the government ended up paying heavy import bills from coal from all around the world, including Australia, Middle East, Africa, which increased the trade deficit. It continues to be dismal even today. Finally, several small firms, incumbent firms in the industry, were wiped out, eliminated from the entire economy, from the entire sector, which has implications for market competition. Reduced number of firms is not healthy for competition in a market, and the impact is going to be felt by consumers. It's competition law 101. So no wonder there are hardly any international players operating or investing in the power sector now, right? So I've already taken a lot of time, but the point is that it would be really naive to suggest that there wasn't a significant economic cost attached to all of these judgments that have been analyzed in the book, but particularly the coal judgment, because now we have 7 years of data, almost 7 years of data after that was pronounced. And sometimes this burden, this economic burden, financial burden can be exponential. And the ripple effects are felt for many years to come. And this is exactly what Mr. Mehta has captured in even the coal chapter. But let me stop here because there's so much more to say, but yeah.
Thank you, Professor Bharadwaj. I think I do agree that there is a lot more to say and a lot more to be done as well. But I think we are unfortunately, very, very unfortunately running out of time. It's already 12 o'clock. Before I move on to my last question for Professor Raj, I did want to pose a question to everyone in the panel, whoever wants to take it up, or probably if everyone wants to take it up, which comes from the fact that very aptly, Professor Bharadwaj, you said that there is a very, very obvious and a very big ripple effect that these decisions have, which is why when we talk about doing these kinds of analysis, we say that it is important so that we move beyond just the parties to the case. Either it be economics, either it be environment, the end is still the people. And when you talk about households getting affected, workers getting affected, businesses who are dependent on businesses getting affected, the end result is still that overall the people, the citizens of the nation or even otherwise are getting affected. So I just broadly putting a question out there that whether it be economy, it be environment, it be any other domain, how important is it and how can the judiciary undertake such analysis with the purpose and the aim of reaching the people? Anyone who would like to take it up?
It would be great to get Mr. Mehta's thoughts also on this. But Raj, please go ahead.
No, I was just saying that, Saki, the first principles are obviously important, which is the fact that ultimately every institution has its own mandate. And the judiciary, when it does what it does, it is expected to look at the relevant laws and the facts and respond to it. But I think one of the things that has come out through this analysis that we're having, and of course, Mr. Mehta's book, is that when the judiciary is entering into a territory whereby it is not only depending on existing laws and regulatory mechanisms, but is actually assessing, responding to a certain externality in the form of, for example, in the case of the coal block allocation, it was responding to a public interest litigation in which allegations of improper allocation were made. In those matters, particularly, as opposed to certain other matters, the decision of en masse cancellation of any kind, before it does, it needs to enter into an economic analysis. This should become part of an institutional responsibility. And that's where I think what Shiv Shakti Mills has precisely done is basically to bring home the point to the judges that when you are making decisions regarding these matters, you need to go beyond the law alone, because many a time the response you're going to fashion may not only be limited by law. And I do recognize quite consciously that this expertise, while it may be available with some judges, it is unfortunately it may not be available to other judges as well. But we also need to recognize there's something else that we haven't talked about it, which is that it is also possible, and I think judges need to recognize that there is a whole range of politics that is in play, and willy-nilly judges on many such matters become participant to it. So, for example, on matters relating to exercise of state power, which has implications on human rights, civil liberties, fundamental rights and things like that. There is a much more coherent discourse when it comes to limiting state power. But when we are discussing and adjudicating matters in which the state has exercised powers to provide certain resources to parties, be it public or private, and that decision is being challenged for whatever reasons, the final outcome of the decision has to be more consciously and in a more nuanced manner adopted, precisely because of the fact that there is a potential political angle to it. And of course, we have debated for a very long time whether judges are addressing political questions. And judges cannot be naive to think that they were willy-nilly put into a situation where they were not expected to be mindful of the politics behind it. But of course, they end up being part of that political process. And hence, it's important for them to do that analysis that stretches them to go into areas of economics.
Sakhi, can you reframe your question?
Sure, Mr. Mehta. So I think what I was trying to understand is that in this entire assessment of whether it be environment or economy or whatever else, are we still missing out on people? Are we still failing to understand whether we take an analysis, whether we do an economic analysis or we do an environmental analysis? Whatever analysis that we do, is it still reaching people? When we talk about a bottom-up approach, let's say, do these kinds of analysis actually help in such approaches, in reaching to the people?
Right, Sakhi. We have an ideal case study on this particular point which Sakhi raised, Sakhi, with which you have been involved also. The Sterlite Copper case in Tuticorin, for example. If people have lost the confidence that the state will not be able to do what it is supposed to do to prevent that pollution, and as a consequence of that, there was a protest and a lot of people died out of firing, etc. So you have, in a sense, lost the whole game. Even if today Sterlite Copper decides that they will follow all the norms which are required, to build up that faith among the people in this kind of situation would be difficult. Now, that is a case study of an example of where a community is affected. Let us look at Bhopal gas tragedy, for example. Now, who's going to trust Union Carbide any longer? I mean, what happened was the world's biggest industrial disaster. Now, you don't require an economic analysis to show as to there was sheer negligence in that particular aspect, in the sense that how gas leakage could take place due to some fitters, carelessness, and so on. So one has to understand and distinguish between these kind of cases to understand that people will only have faith on what they can see or feel as palpable, rather than coal block allocation case. Now, people are not directly connected with it at all, except for people who are living in those areas whose jobs would have been affected. That is certainly a downside in the sense that the mining labor who would have been affected if the mines had been closed down. But beyond that periphery, there would have been no impact felt by people as such. Perhaps, and so on. And in terms of power plants, they anyway imported coal and ensured that the power plants were continued to generate and so on. Price was more, they had a fight with the discoms, etc. And there's a very interesting case, Raj, if you remember, we ran a debate on that also, in terms of contractual integrity, And you have already entered into a contract where this kind of force majeure is not covered. So how can you say that, no, you must give us a high rate, bad luck? It's a very interesting debate. Again, that could again be a part of the second edition of the book, along with that particular case.
Can I respond to?
Yeah.
Saki, yes, that is ultimately the.
I have just one more point, Sudarshan. just one more point. This is a little aside, but it is a very important point which is briefly touched upon by Raj. And this is something which I've written in my book also. It's a lack of humility among our people. And not only judges, but bureaucracy as well. Egos, which often dictate their thinking, they cloud their thinking. This is what I have seen happening on many occasions. And judges particularly, and especially if you see. Now, if you talk in terms of the justice delivery system, Raj, it's such a major cancer in our society, the delays which is taking place. As a consumer of justice, I'm paying for it. But nobody is willing to discuss it. The judicial is not willing to discuss it with the executive. For a simple reason that why do we have these stupid holiday systems in the courts? Why can't they work like you and me? Take their annual leave and work. But they'll be resisted again and again, again and again, and again and again, and let the litigant go to hell. Sorry, thank you.
No, I just wanted to say that, in addressing these concerns, I think it's, I don't know how to put this across. I mean, maybe in this day and age, the times we are living in now, it would be a good idea to refer to the Bhagavad Gita. The argument there is, Arjuna is like an economist. He's a consequentialist. He says, only death and destruction will come from this war. And so I will not fight it. And Krishna is the deontologist. He says, consequences are none of your business. Don't worry about them. Nishkama karma. The right thing for you to do is fight. You're a Kshatriya. That is your duty. That is your dharma. So in all of these issues, we have a tension always between what is the right thing to do and what is it that would be a good thing to do. And the right and the good don't necessarily go together often. And when they say common sense, it means being able to make that distinction. For instance, in the Narmada Sagar case and the number of judgments of the Supreme Court, they felt that 3 million people in downstream with the dams in Saurashtra, drought-affected districts benefiting is important. And so displacing 200,000 people to help 3 million people is all right. Now, the same Supreme Court, the Supreme Court is never the same, it's multiple courts. That's one other problem, 13 courts, we should say. In the bauxite Nyamgiri case, Vedanta, they said it's a sacred grove of the tribals, the Khon tribals. And unless every one of those villages votes and says they don't have an objection to the mining, you can't have the mine. Now here, of course, if you looked at it from an economic analysis point of view, all of these tribals who really want a better life. I mean, they don't want to be, we assume that it's nice and romantic that they are pristine and live in the forests and have their way of life and so on. But actually their children have aspirations. They want to be like anybody else. And if the mine had started, more jobs would have been created. The economic analysis would have said that mine should be permitted to work. But in that case, the court was mindful that it is not right to interfere and take away something that is sacred to a set of people, right? So there, it's a question of judgment. That's what I mean. In all of these decisions, you have to say, so economic analysis is important, but you have to use judgment as to when you must be guided by the economic consequences and when you should uphold what is the right thing to do.
Thank you very much, Professor Sudarshan. I think we are running out of time and we do have a couple of questions from the audience as well. So I think I'm just quickly going to flag one or two questions which I think will very nicely probably mold this entire discourse and discussion that we've been having till now. I would like to start with Professor Raj. Professor Raj, one of the questions that is being asked probably it's more of a suggestion actually, which leads to a question, is that should courts have departments, or should courts have like specific people or committees, or let's just say departments for economic affairs, which are headed by experts whose job should be to assist the court whenever required? Could this suggestion become fruitful, or do you envisage grave barriers or challenges?
Well, Saki, we don't need that. I mean, I'm not in favor of having, because already I think one of the big challenges courts are facing in India, as you know, 30% of judges are, the vacancies are not filled in the high courts, and courts are over, our judges are, in terms of their capacity, there are, I don't know, 3.4. Yesterday, Abhishek was saying that now the cases pending are over 4.1 crores. In the pandemic, 1 year has increased the 3 crore pending cases to 4.1 crores. So in that milieu, having people who need to be, kind of given work and extracted work and things like that, it's a huge transaction cost, and I'm not in favor of it. However, what all of us have said, and enough experiences around the world, is I think the heart of it is, and I think this is what we have to hammer, and this point of view, Pradeep's work, this conference, and many more discussions, is that we need to bring home the point that judges should have a greater degree of both individual and institutional humility. They need to recognize and appreciate that a lot of matters that come before them require expertise that may not be available internally, and they have vast, institutional capacities and credibility to seek out to and other people's work. And I think particularly academics, but also non-governmental organizations, think tanks, research institutions, other agencies, to actually commission studies and even expert testimonies, witnesses. Those things should become much more common. I mean, frankly speaking, I'm very frustrated by the fact that even when amicus curiae is appointed, it's mostly another fellow lawyers. So the judiciary as an institution is having great discomfiture to come out of its comfort zone to interact with people, anybody outside the law. And we know for sure that when adjudicating a number of matters relating to what they are doing, the knowledge and understanding and expertise from other disciplines become very critical. And I think that's a better approach than having multiple departments within the judiciary, within the courts itself. Absolutely,
Professor Raj. In that context, I think I would like to ask the next question to Professor Bharadwaj. When we talk about the courts probably not moving beyond their comfort zones, do we also feel that sometimes probably things which are not necessarily in their domain, which for the general public, which according to the existing frameworks should be out of their comfort zone, but it has become imbibed, or they're trying to imbibe it? For example, let's say as Professor Sudarshan talked about the moratorium case, and that's the question that has been raised, that in that case, do we feel the judiciary is moving on to policy making? And in that sense, are they imbibing something that should be out of their comfort zone into their comfort zones?
I'm glad you asked that question, Saki, and I'm again going to go back to what Raj just said, and before that, the other speakers. It's really the lack of humility on the part of decision makers, which even includes judges. So I just pulled out a news piece which is going to help me address this question. So last month, the Supreme Court, as you all know, rejected the plea for increasing the span of the economic packages that were announced last year in the first wave of COVID, the moratorium of the finance ministry to provide relief for economic activities hit by the pandemic, right? So Justice Bhushan in this judgment just a few weeks ago said, and I quote, that there are matters regarding which judges and the lawyers of the court can hardly be expected to have much knowledge by reasons of their training and expertise. Economic and fiscal regulatory measures are a field where judges should encroach upon very warily, as judges are not experts in these matters. End quote. So, the things are changing a little bit. I hope the thought process continues to be in this direction. But there are some significant challenges that the judiciary has faced in not just applying economic rationale in their decision making, but just acknowledging and appreciating that it could help in the first place.
Yeah, but that's the point I was making, Ashish. Having said this, I think the judgment was written by M.R. Shah. Having said what you just quoted, the court goes on to remove the distinction that the government had made, saying that this relief is available to those with loans of 2 crores. Having just earlier said this is not our domain, we should be careful, and so on. The next thing they go and do is to say the moratorium is available to all loans, regardless of amount. And that has huge implications for the banks and for the government, which is underwriting these loans on behalf of the banks, right? So I can't understand how on the one breath you say what you've just said, and in the next sentence, you go down there and say, we'll not give you any relief, nothing that you ask we'll give you, but we find this unjustifiable, that there is a limit of 2 crores. Why should there be any limit? Now, this is pulling it out of thin air and making policy, right? So this is what I don't understand. I mean, so it's simply the inconsistencies that are there in our judgments. We just assume that somehow a judgment is well-rounded and well-reasoned and so on. But quality of judgments is something we should worry about. I think increasingly over time, I mean, whenever we say, oh, the good old days, things were so much better, I always think that no, that cannot be true, because the athletes are setting new records. Everyone is looking more beautiful nowadays, and so on. But quality of judgments in our Supreme Court has undoubtedly declined, and there must be something about more rigor to how they handle the job. We have some very bad judges.
Absolutely, I fully agree with you.
So I guess on that point, I'm going to pose my second last question, which I think again is open to the floor. And I'm picking on this question, I'm framing this question picking on the last bit that Professor Sudarshan just talked about, that the quality of the judgments is something which is very, very important. In that regard, lately there has been a lot of discourse and discussion about using technology in judicial decision-making processes, whether it be in drafting or research, whatever it might be. How useful do we think that will be, the usage of technology in the judicial decision-making process? Also, do we think that the judiciary will be open to using technology, given that there are a lot of fears with respect to automation, and there's a lot of discourse which goes around saying that automation is going to take away jobs and it's going to displace humans? Is that a fear which is going to hinder us or stop us from accepting technology in the judicial decision-making process? And also, can we rely solely on technology to address such systemic issues or to address the lack of quality issues? Anyone?
That sounds like a topic of another book, but please go ahead, Professor Sudarshan.
Yeah, no, I wanted to say, you see, all the noble professions have a problem. By that, I mean universities and faculty, doctors, medicine, and the law. These are considered noble professions. The practitioners of noble professions somehow think that they must be in charge of everything. And if they are not in charge of everything, somehow what they are doing is going to be affected. The quality of justice would be affected. So what is being taught and the quality of teaching would be affected, or the quality of healing would be affected. So in this situation, medicine has made great advances. Doctors now, as somebody in this conference pointed out, that the heart surgeon comes in and does that bit of high sophisticated work and leaves everything else that needs to be done to prepare the patient for it to others, anesthesia, whatever. The medicine, and they don't worry about who is going to indent for what drugs and manage drug stops. The medical profession has made advances. Universities have also made advances to the point that faculty complain that the administration is taking over everything, and their autonomy and their control over what they are doing is less, and registrars and administrators are highly paid, and they run the universities, and so there's a kind of a backlash. But in the case of the judiciary, there's been no improvement or change. They hold on to everything. I mean, automating the registry, case management, everything the judges want to have a hand on and control. So I think, therefore, when you say technology, yes, I mean, I for instance, I was looking at Rajasthan. Rajasthan has, a system now where once the case is filed, it is allocated by a computer randomly to different judges in the district court and the high court. So the earlier corruption, paying the registry, money so that your case comes before a favorable judge and so on, has more or less been eliminated. But when it comes to the Supreme Court, I remember Justice Bhagwati invited people from the Indian Institute of Management, Ahmedabad, to set in place a system to manage this. Now we've got it asserted. I am in control of the roster. I will allocate which bench will listen to which cases. Now, this is the kind of thing that technology can help and do justice to litigants. But look what we've had. After judges came and complained about this practice on the part of the one Chief Justice, two subsequent Chief Justices have, with a vehemence, enforced their powers as being in charge of the roster. And they will not let technology take over. So there is great resistance, I'm afraid. And we need to look to lawyers that Professor Rajkumar trains in this university and some other universities, a new generation of people who will do things better, who are more technologically savvy and are less, adamant about not allowing technology to do the good it can.
Thank you very much, Professor Sudarshan. I think I'm someone who I genuinely wholeheartedly agree with everything that you just said with respect to the usage of technology and imbibing changes and not being so resistant to them, at least. Having said that, I have so many questions still that I want to ask, but I think we have run out of time, probably exceeded 2-3 minutes. And I do believe that the next session is scheduled in the next couple of minutes as well. I just want to take this opportunity again to thank each and every one of you, the entire audience, the entire panel. I think it's been a phenomenal discussion, and I hope that this is one of many, many discussions to come, because I believe this is a discourse which has just started, but it has still a long, long way to go. And before we close this session, I do want to say and reiterate that we are living through some very, very difficult times, some very unprecedented times which I think has made probably, hopefully, all of us more humble and more human in our approaches, which I think has been needed for a very long time. I hope everyone listening to us right now, the entire panel, I hope all of you are safe and your families are safe. And my heart goes out to everyone who has lost their families or is struggling with this pandemic right now. Having said that, I thank each and every one of you once again. It's been an absolute pleasure.
Thank you, Zaki, for a fascinating, panel discussion moderated by you, and it's so good to see all of you. I really enjoyed being part of this panel, although I am not an economist, and all of you have been forgiving for a non-economist to be part of this discussion.
Not really. You do a common sense. That is what matters. Thank you, Zaki, for doing a good job.
Thank you.
Keep it up.
So we will be joining very shortly in another 5 minutes for a fascinating discussion, and I'm really looking forward to it. Teaching economics to law students and law to economics students in India. That will be beginning in the next 5 minutes. Thank you.
Thank you, everyone. Stay safe. Take care.
Good afternoon, everyone. Welcome to the 5th technical session of the National Virtual Conference on Economic Dimensions in Judicial Decisions. This session is themed Teaching Economics to Law Students and Law to Economic Students in India. The new age caused by globalization had the base of social organization shifting from socio-polity to political economy. The new age in the newer social conditions demanded a reevaluation of our thoughts and actions, from family management to protection of environment, from market regulations to constitutional governance, from social welfare to distributive justice. We reinvented reason, refined it in the cauldron of renewalism, and optimized its use through the discipline of economics. Evaluating our thoughts and actions from the perspective of economic motivation exposed to some of the normative ethical fallacies of the past, primarily that reason was never free of passion. You realize the hard truth that we are egoistic per se. You realize that normative behavior is motivated by self-interest. Ethical dilemmas were coordination problems. Moral stances were in pursuit of payoff, and that altruism was yet another form of ego. Beyond these behavioral revelations, we also understood the importance of optimizing thought and actions for efficient outcomes. The surge of economistic thinking had law evaluating every bit of its structure and function through the method economic analysis of law. Such analysis have helped us understand the effect of rules and the human behavior to such rules. In this national conference, economics features as a method and a domain, and law as an object of analysis and a process of human self-becoming. This bone-crushing embrace of law and economics has its own discomforts, especially in reorienting law students to the need to understand economistic reasoning in opposition to the normative reasoning, and economic students to understand the emergence of new spaces of imagination like law. This panel of the 5th technical session comprises of 5 distinguished colleagues who will discuss the opportunities and challenges of teaching economics to law students, economics students. The panel comprises of Professor Dr. Yugal Goyal, Professor Jindal School of Liberal Arts and Humanities, Professor Dr. Divya Gupta, Assistant Professor and Assistant Dean, Jindal Global Law School, Professor Dr. Abhishek Konar, Associate Professor, Jindal Global Law School, Professor Deepanshu Mohan, Associate Professor, Jindal School of Liberal Arts and Humanities. Today's moderator of the panel is Professor Dr. Ashita Davar, Associate Professor, Jindal Global Law School. Over to you, Ashita.
Thank you, Professor Srijit, for this wonderful introduction. I want to begin with highlighting the importance of interdisciplinarity. And basically, we all understand that we live in an interdisciplinary world. For example, it will be quite a difficult task to separate economics from society and politics. Similarly, law and economics have also developed a very close relationship over the years. Whether it is tort law, contracts, or company law, or for that matter, even environmental law, all these subjects have their roots in economics. As we are in a globalized and liberalized world, we see the need to integrate various fields as this prepares the students to become better professionals and deal with upcoming challenges. Especially in today's world, when we are amidst a pandemic, and every day we see that there is increasing unemployment, migrant crisis, and oxygen shortages, the role of lawyers has become increasingly important in knocking the doors of the courts to ensure economic and health justice. To do so, lawyers do need an understanding of basic concepts of economics. This helps them comprehend the real economy and its challenges better. In the same breath, economic students need to grasp the nuances of legal policies, as these have direct impact on the functioning of the economy. For example, Fiscal Responsibility and Budgetary Management Act of 2003 mandates the fiscal deficit to be 3% of GDP. This is the reason for constant decline of fiscal deficit over the years, barring the pandemic year. Also, the new labor codes have increased the length of working days for workers, meaning further exploitation. Without understanding of these laws, economic students will not be able to decode these regulations and their impact on the economy. Economics has a considerable role to play in the analysis of legal issues. Expertise in law and economics enables lawyers to have an impact on a wide range of issues related to law, business, and finance, and also help economists to analyze the situation and make rules and regulations socially desirable. With the introduction of public finance, environmental economics, social choice theory, and regulation and antitrust law, the linkage between economics and law has gained more significance. Economic analysis of law proves to be a powerful framework for predicting the consequences of legal rules and for understanding when legal rules are warranted. It focuses on efficiency, incentive, and response of people's to incentives. In various parties' litigation, the tool of game theory is applied to answer pure legal questions. Thus, it is imperative to have an understanding of both these fields to become successful lawyers and economists. Incorporating both fields in the curriculum will lay the right foundation for future professionals. With this, I'd like to open the floor for discussion. As Professor Srijit has mentioned, we have Professor Goyal, Professor Mohan, Professor Panar, and Professor Gupta with us. First of all, I would like Yugang and Dipanshu to actually tell us about what is the contribution of economics in developing of the legal system of a country. If any one of you can, like Yugang, you can go ahead first and then Dipanshu.
Okay.
Or Dipanshu first.
All right, I'll do that. Well, I mean, thank you for organizing this. And I would like to first thank each and everyone who is a member of the organizing team, starting from Abhinav to the Vice Chancellor and everyone, I think, has been involved in organizing a conference in this hour. It's a very difficult time and transition for a lot of people and what we are all grappling with. And I remember and I recall the Vice Chancellor mentioning this yesterday, that universities have a very important role to play, and they have a larger responsibility towards the process of knowledge creation and dissemination across periods of time, no matter what it may be. We might be in a process of a crisis right now, but going forward, we'll reflect back on what we did around this period of time. And some of us who are in a more privileged position ought to make more of the time we have in hand. Just to respond to Ashita's question, the contribution of economics in developing the legal system of a country is, I would say, probably embedded in the very classical roots of thinking in economics that evolved largely around, if one had to go back to the work of Adam Smith, or prior to that as well, or even Kautilya for that matter. Something that was very integral to the body of work produced was in terms of gauging the nature of interaction between what we consider today as the state and the market. State-market integration or interaction was the way in which most discussion, what we today call as political economy, was central to the thinking of classical thinkers. It was of a subject of interest to political philosophers. It was a subject of interest to sociologists. And later on, when we saw the application of that evolving in a separate discipline, that is of economics independently, a lot of the application went about looking at how we can study the nature, form, structure of markets, largely as tools in organizing economic activity to make what Smith argued as our own natural instincts to truck, barter, and exchange. A lot of these things were integral, I think, and skewed more towards the understanding of markets and what markets can do. And the idea may be, and this was relevant in the context of the time we were living in, or the human civilization was in at that period of time, that is an excessive command control of the state in the way in which we did everything, from kind of getting up, going to the market, what to buy, what to sell, how to purchase, at what price to sell. I mean, everything had a very stored state control. And to detach away from that, there was a lot of discussion moving towards how markets can organize economic activity better. Now, what happened in the process was that we somehow tried to move away. And this happened largely with the neoclassical advent, or I would say influence of the school of thought in economics. And when I'm talking about a sort of a critique to the way we look at economics distanced from law, I think a lot of that is possible and available today because of the divide and the gulf seen in this from neoclassical thought. Considerations on redistribution, equity, welfare were very central to even classical economists as well. Smith was very considerate about that. If you look at Before Wealth of the Nation, Theory of Moral Sentiments, Hume and his influence on Smith's thinking, many aspects that are interestingly part of jurisprudential considerations in terms of principles of law were very integral to thinking around economics as well. Even the idea that Professor Srijit was mentioning around the idea of self-interest maximization is more of a 20th century introduction in thinking. In Smith had no way, if you look at even Wealth of Nations, meaning or deluding to maximize one's self-interest while ignoring the well-being of others. I mean, the Moral Sentiments sketches that out in more detail. Just to kind of look into the situation that we're in today, I think it's important. What is one of the central challenges that is affecting us, as a civilization today? And I think the challenge itself has a question which is connected with how both, legal stakeholders and economists need to come together to be able to look at that challenge. One is, of course, we can look at climate change and others as part of many challenges that are there. But one of the challenges I feel is to be able to see how technology and the pace of change that technological pace, I mean, we're seeing that with the education sector right now in the midst of a pandemic, is changing and altering the way we process, absorb new information, right? And how that affects the human, not just the human brain and human mind, but everything that human beings do. Because whether you look at legal jurisprudence based on what you call as quote unquote the reasonable person, or in new classical economics, the quote unquote rational man, or rational person for a more gender sensitive approach, which many economists usually kind of distance away from, is concerned with how rapidly technology is changing the way we do things. And I don't think that both in the legal vocation and also in economic thinking, there's a significant amount of attention being put. And I think that's an area which can allow for a bridging force in looking at not just the role of institutions, in the way in which we look at considerations around the digital economy. Employment patterns are focused now mostly on the gig economy considerations. We don't no longer look at just the idea of what opportunity cost means. It's an attention economy we are grappling now with. There are signaling costs that are involved in the way in which you can hold each other's attention. And the entire dynamics of market is around catering to that attention and signaling cost itself. So everything that we study, from government failure to market failure, the role of intellectual property rights, everything in the kind of a structure we're living in right now is based so embedded in strong technological adoption and absorption that the state-market interaction, which is at the core of economic thought, ought to bring forth a more convergence or a strong degree of convergence between thinkers in the legal and the economic diaspora.
Thanks a lot. Very quickly, I'm going to put forth my thoughts in 3 layers. You see, drawing from what Dipanshu mentioned, essentially allocation of resources in a society, takes place through either hierarchy or through markets. Legal discipline largely has been driven to design allocations through hierarchy, because in markets, allocation by markets, the legal system has to become more of a facilitator or enabler. And so as the state is receding from being from being the primary service provider to being a service facilitator, legal system. So like you asked, what is the contribution of economics, right, to develop legal system? I think central, because it's the legal system that creates framework that enable market-based allocation of resources, and that's what's happening. I mean, electricity privatization is one such example. The second layer, in fact, Srijit was talking about the bone-crushing embrace of law and economics. I don't think there is any embrace going on, actually, frankly, in India. Think about a framework, the second layer that I wanted to talk about. Think about the framework of right to property. We've been oscillating between it being a fundamental right and constitutional right, and how various countries are debating about this aspect of right to property. It's inherently an economic concept. It ceases to be an economic concept if property is not valued monetarily. The moment it is an economic concept. So right to property, which I would say is the cornerstone for development/growth, you can define them whichever way, of any society, is deeply embedded in economics framework. And so understanding right to property by lawyers will be inadequate if economic impetuses or economic variables that impact property rights are not laid out in a classroom, for instance. And then, of course, I can go on to mention about specific aspects like, let's say, bankruptcy law. It is only now that we have an insolvency and bankruptcy code, which is central to development of a legal system in an economy. Think about public policy, think about blockchain. Dipanshu was mentioning about technology. Regulation. I mean, we are, I'm reminded of how little is economic thinking, employed in understanding regulation, which is what we are saying also. We are seeing it while the present pandemic is unfolding. And so insofar as issues of public policy, like we see in pandemic, are important for legal system in the country, economics is important for the legal system of the country. Ease of doing business, right? If ease of doing business is important for constructing or creating an architecture for legal systems in a country, then economics is important. I mean, there are only 5 parameters in which now out of 10 parameters, we are scoring very high in 5, very low in the other 5. And one of the lowest score we get in enforcing of contracts, which is nothing but a legal entity. And that has to be understood through economic. I don't want to take more time, but I think it is central. And I wish there was even an embrace to, in the first place, let alone a bone-crushing embrace that I heard.
Thanks, Dipanshu and Yutank. I think 2 pertinent points mentioned by both of you, like one thing which Dipanshu mentioned about distributive justice and one Yutank mentioned about property rights. I think they are very important because there needs to be an economic understanding of these concepts before you can actually only think of it only in the legal terms. So, yeah. I will now turn to Divya and Abhishek, and I'd like to know your thoughts on high secondary level education. Like, should the concepts of law be a part of the high secondary education? Like there is science, you get to know a bit of commerce, bit of humanities. Should there also be an engagement with a bit of law? Abhishek, if you would like to go first. And
thank you for that, but I'm not sure that I'm competent to answer what kind of law should be taught. My commonsensical answer would be yes. But if I may, continue the discussion that Dipanshu had started, and sort of, twist your question a little bit and make it into economics. That how is it that we are teaching economics, perhaps in school but also in the university level. Many of the points that have been raised both by Dipanshu and Yutank are extremely important and thought-provoking. Dipanshu reminds us something very crucial that is actually not known to the extent that I know. Majority of economists do not talk about this, which is that what is there in the classical tradition. People are often very quick to invoke the name of Adam Smith and all of this. Very few people have actually read it. It's not taught in classrooms, from what I know about this. There is a centrality of I'm going to posit that it's extremely important that we have some kind of economic thinking that is considered in both in legal education for lawyers and all of this, but also that there is a need to rethink how economics is taught, how the subject itself is taught to economists. And only then can we actually fully understand the gravity of the question that is posed to us. As Dipanshu reminded us that what happened in the late part of the 19th century, and then it gained force in the 20th century in the academic literature, is that there is an understanding that in economics, that you can comprehend economic questions, economic problems, completely dissociated from politics or society. So if you go through an economics program, people going in the doing PhDs in top 20, top 10 universities, they learn cutting edge mathematical techniques. They are skilled at real analysis and linear algebra. They know almost nothing of sociology, next to nothing of history. That is to say, they are skilled at many, many things which have very little to do with human beings. This is not to say that mathematical things are unimportant or not useful, but this is to say that, if we are skilled, like if I'm given a hammer, then everything is nailed to me. So a lot of the times the way economists actually approach things is a very engineering mentality. That is, it's a top-down solution approach. Oh, this is a problem, we are going to build a bridge and the problem will be solved. That we have to design best kind of policies and so on. I think that is rooted in an understanding. I'm going to claim that this is a misconceived understanding of, because social reality presents itself as a totality. As Ashita, when she was introducing the concept and all, she said that that reality presents itself as a social totality. What we need is to understand social reality based on concepts and ideas which are social in nature and not purely economistic. If you look at the economic education, the way people learn and it's taught to us, and often we are also guilty of teaching the same things, is you conceive of a rational human being, rational in a very narrow, hyper-rational sense, what some people have pejoratively called Homo economicus. And there is absolutely no discussion of politics and society. For us to have a meaningful understanding of how the legal structure is, how economic ideas are implicated and how both of this, talk to each other, I think economists need to have an understanding of that you cannot actually talk of economic problems completely in isolation from social political. Just to give an example, if I may pick up, for example, the things that have been said before me, which is that the state and market interaction. If there is actually not much agreement if you talk to economists how they view the state. But if you go into a classroom or pick up a textbook, one might be mistaken to believe that there is probably one right idea, and then you have opinions, different opinions. That's actually not the case. Much of this is debated very hotly in the academic literature. So, for example, what is the role of the state? The role of the state, if you ask a neoclassical economist, mainstream economist, they would simply say that not much. That is to say, the provision of allocation of resources, it has to be done simply by market forces. And the role of the state is only to ensure that markets are in place and they are functioning well. And there are some occasions where you have market failure. We have to either create markets or there has to be some kind of state provisioning, but that has to be minimal. If you ask someone who believes, who is a Keynesian, they would have a completely different understanding of what the state is. They would say that if you leave markets on their own, they would not lead to a situation of, a very happy situation. That is to say, Keynes would show that there are occasions when you have an equilibrium with a lot of unemployment, low output, low income. These things can be a result of market equilibrium. So therefore, the state's role is to actually make sure that output is boosted in times of low demand and so on. if you look at it from a classical political perspective, that of Smith, or if Marx, who is a classical political economist, much in the tradition of Smith and Ricardo, it's a completely different understanding where you think of society as composed of social classes. You have landowners, you have capitalists, you have workers, and the state has to mediate the role of different classes. So the point is that I think it's extremely topical, and sadly it's a very hard question. If we really need to honestly sort of grapple with this question, we also have to, as economists, sort of rethink some of the way the subject is learned, taught, and thought of. Yeah.
Thank you, Abhishek, for such great insights on the, first of all, introspection, the need for introspection among economists to reimagine the way we are teaching economics and reimagine the curriculum of economics, not just at the higher education level, but right from the school education level. I would like to very briefly respond and try to address the question that Ashita has posed, that what is the need and how, is there a need to introduce law or education of law in the school curriculum at the school level? I believe that there is. It's going to. If it does happen, it's a great step actually. That if law can be, or the education of law, or the legal processes and legal systems can be introduced, can be integrated into our school curriculum, because currently the education system, our education system, is such that it is considered most appropriate. The education of law is considered most appropriate only at the higher education level, and that too primarily professionally. There is no emphasis at the school level on the need for the understanding of the legal processes and legal systems, or just simply the basic ideas of justice, equality, liberty, etc. In US, for example, a large number of schooling systems have introduced the basic education of law, legal processes integrated into their school curriculum. So there is a need for us also to adopt a similar kind of an integrated school curriculum, which fits well into our socio-cultural setting. Now, when we talk about introducing law into the school curriculum, it is really important to set out the goals very clearly, the goals and the objectives of such a curriculum very clearly. The idea should not be, the goal of such a curriculum would not be to produce amateur lawyers out of our elementary and secondary level students, right? Because the goals and the pedagogy of the school level education is very different from the higher education, the objective of a higher education system. So here, when we talk about introducing law or integrating law into the school curriculum, the objective should be to confront the students with the basic ideas of justice and equity and fairness, for that matter. And it should be to inculcate and incorporate an alternative approach to examining issues of timeless concerns to human beings, like those of, again, I'm stressing the need to understand and to incorporate alternative approaches to understanding these timeless issues that human beings have been facing, like those of property, power, inequality, justice, etc. And I'm not saying that these ideas have not been looked at or are not being looked at already as a part of our school curriculum. The perspectives that we are providing to our students to such ideas is through history, economics, political science, but definitely not from the perspective of law. The integration of the study of the legal processes into our school curriculum has to be not as an isolated course, not like a classic legal education course. It can probably be incorporated right from kindergarten to the high school level. And so far as the separation of the streams is concerned, I don't feel it necessarily has to be as a separate stream in addition to what we already have, like sciences, commerce, and humanities. And more so because with the new education policy of 2020, this archaic, watertight separation between these streams and the freedom for the students to choose from these streams is anyway going to ease out. So it should really be very integrated into the entire curriculum and not really be introduced as just a course a classic course of legal education at the higher secondary level. It has to be really a part of the pedagogy of the school education, right from the kindergarten probably, until the high school level, until the higher secondary schooling level. Yeah, that's what my thoughts are.
Thank you. I think Dipanshu wants to add something, and I'll welcome him.
Very quickly, when we say, introducing legal provisions of education at the level of curricula, maybe secondary, higher secondary, or high school. See, we live also in a country where there are three versions, of societal landscape, where the demonstrated value of education means very different to different sections. And, if you imagine someone who is coming from predominantly a farming community and maybe interested in continuing, let's say, in the business of farming. I'm talking about someone who's interested, not many are, but those who are, or maybe, you would want them to be educated about where and how the new farm laws have come in and how does it affect your own ability to work. If you ask from a general perspective, because I personally feel that a universalist approach to educating and deciding what should be in the curricula and what should not be, I think is not maybe the more ideal way of going forward. I think we've made that as a mistake in our education system quite chronically and as a structural issue. But there are certain aspects which you want everyone to be aware of. And I argued earlier this in a long column about the value of constitutional morality, making that as a yardstick for introduction in education for people in understanding what the values of the Constitution want to impart. I remember getting educated in a Catholic school, and those who may have got access on having this course called the Moral Science, which was with us for a very long period of time. What if, I'm just saying, you had a course on constitutional or public law provisions on human rights, on discussions which can make, as a student, someone more sensitive to the socio-legal considerations of a certain spatial dimension. So I think beyond looking at what Yuganga mentioned about integration of financial law or bankruptcy code, contract law, and a number of those aspects which are very important from a vocational perspective to given people across different ways. There is a case to be made in terms of making constitutional public legal education more accessible at a more decentralized and lower level. At the same time, for those interested in law, I think what we do is most of the time focus too much on very basic elements of economic thinking, microeconomics, macroeconomics, statistics, econometrics out of nowhere. And we try to coercively introduce some of these things and add to from a very distant, narrow neoclassical prism to a set of students who are not interested in that abstract reality and that process of mathematical formalism, which is so integral to the way neoclassical economics has evolved. It's difficult to explain, and I think that's the next set of questions maybe that Ashita had shared with us about how to make pedagogically some of these things accessible. So off to you.
Thank you. I think this was a very interesting insight. Like what I gained from all of you is this, that essentially it's not only about introduction of law into the curriculum, it's about connecting it to the reality and imparting education which is actually going to give you some kind of morality and understanding of things rather than just a black letter law. So similar to something what Avishek and Dipanshu were also mentioning in terms of the way economics is taught, whether it's at the elementary level, school level, or at the bachelor's level or further on, micro, macro, econometrics, and all this is just imposed on us without connecting it to reality. So similar to this question, I will want all of you to answer, but please be brief about it because we have limitation of time. There is this curiosity, which I also have, that what kind of challenges do you face when you teach economics to law students? So, and I'm sure all four of us, like five of us, including me, we all go through these challenges. So I'm just curious to know all your experiences, that what happens and how can we actually inculcate the thinking of economics, especially linking it to reality, in these law students. So I think I'll begin with Divya and then Yogank, Abhishek and Dipanshu.
Yeah. Thank you, Ashita, for this question. In my limited experience of teaching economics to law students so far, so one of the very basic important challenges that I have faced in my experience of teaching economics to law students is the fear of math, fear of that math phobia, that discomfort that most law students have with maths. So I believe that many students who, when they enter a law program, their expectation is that whatever math or whatever algebra or calculus that they had to do, they were done with until their school level, and now they won't have to see even a single equation. So when I talk about math, I'm not saying basic discomfort with doing simple additions or subtractions, but just those complicated looking equations, that first order differentiation, and that kind of mathematics is what I'm talking about. Now, the problem is that when we teach the basic models of microeconomics or macroeconomics, the introductory level, even at the introductory level economics that we teach to law students, the basic models also involve use of some math, right? So the challenge, then there is this challenge and the process that goes into trying and simplifying, or to an extent limit the use of math without compromising the crux and the main ideas of the models that we are teaching them, without compromising the implications of the model. And that should actually be the way the introductory level economics or these models should be taught to the law students. And another important thing that needs to be incorporated in our pedagogy of teaching economics to law students is to teach them applications of those models which are relevant for them. Most of the times, a lot of times, they are not able to link what we are teaching them. They are not able to link these basic models, the simple market model of demand and supply. They're not able to link it, not just with the reality, but also why and how it is relevant. Why is it important for them to learn these models? So we have to be able to make this connection so that they are better motivated to study and to take this course rather than just to fulfill their credit requirements. The second thing is at a broader level. The second challenge is at a broader level, which is difference in the approaches or difference in the ways of thinking. So most of the times, most economists, in economics, we are not usually predicting or considering all the relevant variables at the same time. We are holding a lot of variables constant and concentrating on the importance and trying to understand the implication of one particular variable. But this is not the way lawyers are trained to be thinking. This is not the way law students are supposed to be thinking if they're trained to be lawyers. They have to have a holistic view of the problem at hand. They have to take into consideration all relevant, all confounding variables at the same time. They cannot reject one variable. They cannot pay more attention to one variable at the cost of the other. So this is that discipline, the disciplinary limitation of economics that I have had to deal with while trying to relate economics, the basics of the economics to law students. And I'm looking actually forward to the experience of other panelists.
No, I agree with you, Divya, entirely. Let me add my 2 pence here. I think one of the reasons, one of the problems that I've found in this context is the very nature of how instrumentally students take education. And so if law students know, or if there is a dominant perception that economics is just a subject that you have to pass. Dipanshu mentioned about moral science. This was the dominant perception of moral science back in our schools, right? You just have to pass it. If that is the perception, then this perception largely is driven through discourses within the universities, not outside, right? So for as long as this perception exists, it will lead to a scenario where students will be relatively less receptive to this discipline, whether with maths or without it. Of course, math also has its own problems. The other problem is that the standard textbooks of Economics 101, let's say, are generally written or designed, for economics audience, not for legal audience, which means there is a problem inherently in the way in which economics is transmitted, so to speak, right, to law students. And so therefore, for instance, like Divya mentioned, considerable part of economic thinking that comes out of textbook, and most of these textbooks are written by Western economists, and so they have absolutely, very little relevance. Price is not discovered using demand and supply all the time. Only in competitive markets. Competitive markets are hardly existing. And so in some sense, students are unable to access their own experience through this. And so one of the things that is important is that economics, when it is taught to students in law, law students, it has to be taught meaningfully for a legal mind, or for legal thinking, or a mind that is already fertile for legal thinking. So instead of picking up topics from standardized textbooks, it would be better if economists engage with topics that relate. So I'll give you an example. Prices as signals. I remember last year when COVID, and it's an opportune moment to talk about it. When COVID struck, prices of masks and sanitizers shot through the roof, right? And the response of the legal response of the district magistrates and policemen around was to go against the black market use, right? So they announced, I know many cities, if the chemist or the drugstore is found to be selling masks at higher price, they will take away the license of the drug owner. Now, the problem why masks became expensive is because the raw material prices became expensive because the supply is inelastic. You need different kinds of adhesives, glue, cloth, elastics to be able to make a mask. Because now people need it suddenly a lot more, and the supply cannot be provided suddenly, the prices of raw materials also rose. And so what ended up happening? Drugstores and chemists stopped selling masks because they were fearful that the police is going to impound their space. Now, this is an interesting example that lends credibility to the idea. So legal thinking, think about regulation for that matter. We must teach externality. In order to understand environment or law related to environment, concepts of externality could be highly enriching for students. I don't even want to get into competition law cases and bankruptcy cases, which of course require economic thinking. But an extremely important aspect that economics teaches law students, and which should be brought in, is the idea of how static and dynamic views of the world is different. Static efficiency and dynamic efficiency is different. Short run or a present view of the world is different from the long run view of the world. When you look at the telecom cases, the 2G case, or the Vodafone case recently, each of these cases had a very high level of significance for how the telecom sector in India is going to unfold over time. And so the judgments or the policies that are drafted at the level of government in a very, very legalistic thinking, in a manner of very legalistic thinking, often fail to recognize the long-term implication of taking these decisions. Now, so these conversations have to be brought into the classroom. So in other words, what I'm trying to say is one of the difficulties is that conversations generally coming out of economics discourses may not necessarily be relatable to a law student. And in that sense, I would not really, even though I would really blame the way in which we look at education instrumentally for this. But I think there needs to be a culture where legal thinking devoid of economics, what kind of massive costs it imposes. 2017 Supreme Court case, Shiv Shakti Sagar sugar case, right? So here's a law, and only India can have laws like this, where a sugarcane mill cannot be set up close to another sugarcane mill as long as the distance is more than 15 meters. So new sugarcane mill has to come about 15 kilometers. So you can only set up a sugarcane mill beside a sugarcane mill if you're away 15 kilometers from the other mill. Now, now this is an interesting law. I mean, we have laws about alcohol shops outside universities, right? Certain meters, you cannot have cigarette and alcohol being sold outside university and public education spaces. Or for that matter, Supreme Court judgment where they announced that, public highways, the alcohol shop should be 50 meters. I mean, all of these cases, have huge impact in livelihood of poor people. And this goes for instance, licenses. If you restrict licenses for rickshaw pullers, they're only going to end up paying bribes to police officers or for street vendors. So we are talking about economics not being so lack of economic thinking impacting one of the most vulnerable population of the society. And part of this comes because of the lack of reception, or there's some sort of a barrier to understanding this within the classroom. And this needs to go by the type of discourse that emerges within the university spaces, that economics is not just a subject that lawyers have to study, a certain period of time and, once a week. It is embedded within across all disciplines. And I'm not even going into tax right now, In fact, in Shiv Shakti Sugar case, the Supreme Court mentioned that economic thinking is essential for taking decisions which have long-term implications that often lawyers miss. I'm sorry, I'll stop here for now.
Abhishek, since you're going to tell us about the challenges that you face when you teach law students, I mean, it will be more interesting if you can also tell us from the perspective of the political economy that you teach, the subject that you teach. I mean, that would actually give a good highlight to our discussion, but please be brief about it.
Thank you. Yeah. So, there are two aspects to this, and one aspect has been it's been highlighted very well, very articulately, both by Divya and Yugang, which is that there is a difficulty of teaching economics, to law students, difficulty with textbooks and mathematical formalism. There is another aspect, which is I've actually found that there are certain things. It's easier to teach law students, or at least I've found a greater amount of receptivity coming from law students, which is that often I've approached that, okay, how am I going to teach economics? I will try to teach it as a lay person would. I'm not teaching someone who is going to be a practitioner. And so in doing this, of course, you have to teach a little bit of the models and in the curricula, but then you bring in criticisms, which is to say that the exact cases of the things that have been mentioned by Divya, which is that, perfect competition or this thing. And when you make an argument that, look, some of these models these are mathematical models which have been set up to actually buttress a political point. That is to say, these theories come to the fore in a particular kind of time. And it basically shows that, we are living in a society which is largely conflict-free. And the markets as a social institution manage, and there should not be much dissatisfaction. Consumers come of their own volition, producers come of their own volition, they meet in the market. The result is amazing because you get the maximum happiness for the consumer. And all of this, the remuneration that you're getting is according to what economists call marginal product, or in the lay terms, that is to say, you are being remunerated according to the contribution that you make. So therefore, this kind of analysis rules out conflict. It's actually it buttresses a certain kind of ideological position and political position. When I make these kinds of arguments, and I also teach political economy as an elective, where of course I'm going to have much more elaborate discussions through the semester, I've actually found students to be much more receptive. They appreciate it very much. I think that they are more open because there is no disciplinary sort of anxiety, or there is an in-group, out-group loyalty. When you speak to economists, they feel like they have to defend. Oh no, but how can you say this about perfect competition? There is a defense mechanism kicks in. Sometimes it happens with students who associated, like, they are economic students and they feel like they need to defend something that they are good at. They are doing well in their classes. That is actually absent. And in my experience, that's been That's been a positive feature. I have seen, quite surprisingly, actually, to my surprise, I didn't expect this when I joined. A lot of colleagues are open to these conversations. They are open to sort of redesign curricula, introduce different kinds of topics and all of this, which is typically not the experience in other economics departments, all the ones that I'm familiar with. And students are also receptive. So just the other side of the picture, I suppose.
Yeah, I mean, just very quickly, I know we're short of time, but I'll actually agree with Abhishek here. In my own experience, actually, I haven't faced any problem or serious challenge in teaching basics of micro or macroeconomics. If you're talking about basics here, because if you go into courses like, I mean, Yugang teaches a course in institutional economics. I've been taking development economics this time. So those are different domains. I mean, when you go into domains, that's a different thing. But I'm talking basic courses. If you're taking that as I haven't faced actually much of a challenge. It's also about your own journey as a teacher. Last 8 to 9 years that I've been teaching, I've never taught a core econ cohort in India. The challenge that I face is when I teach a course to university abroad over the summer in North America, which is taught to a 3rd or 4th year undergraduate cohort. And it's there where I start kind of seeing that what Abhishek started with talking about. You're so embedded and entrenched in a certain way in which economics is learned and taught that the expectation is, and it's very interesting when I go into the classes, there's a chalk and a board and there's almost a space for equations and explanations already put out there. A teaching assistant of mine would always do that, before you go into the class. And I said, well, I don't use that. Not that I have anything against the use of mathematics as against music or anything. It's a language of communication. I have tried always in the way I teach almost all classes is to come up with 3 narratives or 3 stories that I want to use as a way of teaching a particular concept. I think Yugang has done that very eloquently here to talk about case laws while introducing it. And one of the reasons could be that your own journey maybe as a teacher was influenced largely by teaching law students at Jindal at the very initial stage where we had to make that adjustments very quickly, you see. And I think that's why being in an institution like Jindal, and I'll always compliment and be very grateful for that degree of exposure here, because I have taught from a student of art and architecture to a student of banking and finance to a student of liberal arts to a student of international affairs. Everyone is in the same room. Now, how to make sense to them, I think the only way I feel is that what really moves us as human beings, individuals, are stories and narratives. So once I kind of bring a sense of visual imagery and a narrative or a story to explain a particular concept as against a mathematical, I mean, both are their own words of abstract reality, right? A fictional novel or a mathematical model. To a student, actually, both are aliens. It's just that there is a phobia against one as against a lesser of a phobia against the other, right? So I think that the use of narratives, use of stories is a very powerful pedagogical technique. The other very quick point is in the first 3 to 4 weeks, when you're setting the tone for the course, the use of philosophy and history in introducing the discipline and its value to a student is a very important process. I consider this as in Avatar, you had this relationship between the warrior and the horse. For that to happen, their tails had to meet. You remember, I don't know, there was this, I considered that as a stage, that there has a bonding you need to make in the first 3-4 weeks. So if I get like the first 3-4 weeks with the students, I'm not doing anything which has to do with introduction to marginal cost or just ideas that why as a discipline one needs to be interested. So the philosophy behind it, the history. And once you have, then you say that, okay, there are few classes I'm going to take, which is going to be a hard pill to swallow. I would be using certain occasions, but I want you to be with me. I want you to hold and be in this process together. So a lot of times when I'm even teaching, equation, I'm purposefully making errors while talking about it, so that there is some degree of attention that a student is having, and they can correct me. Oh, sir, you're actually wrong. Oh, really? Is that so? And I look at the textbook. I've done so many role plays as a way to kind of get and see, because it's about attention. Once you get a student's attention, in fact, for that 1 hour, and use certain ways of theatricality or whatever you may call it, you've got them, right? And then the more difficult topics where for a fact it's going to be difficult for a student to follow, you can help them go through that. So it's a very, I think it's a very different experience. Every day is a new day, but that's the way I would like to put it.
Thanks, all of you. Actually, we are short of time, though, despite the fact that I really wanted to ask you a lot of other questions as well. I think what I'm going to ask you towards the end is this, and I'll request you to keep your answers like 30 seconds. How can we better integrate the effect of laws in day-to-day lives of people who study economics? I hope the question is clear. Okay. How can we better integrate the effect of laws in day-to-day lives of people who study economics? So something like farm laws, for example. So I think now I'll begin with you, Kank. Go on to.
Well, when you said keep your answers short until 30 seconds, that's when you really behave like an economist. Anyway, so
I can't help it. I am under a deadline.
That's good. That's good. I like it. Anyway, so very quick answer. I think students or anyone who considers himself or herself a student and who is interested to understand law, they should go into the field. We know that understanding, comprehending how India operates under the shadow of law is different from how a Western European country would. And therefore, educating Indians educating Indians law should not be a mimicry of educating an Englishman about law or German about law or Australian about law. And in that sense, we know, and there is no two way about it, we don't follow law as much as we follow norms. And in order to understand norms, people have to go out. So the best way to do it is to send students and go fetch their driving license. Let them try to get a license to a rickshaw puller. Let them try to go and file their own taxes. Let them actually try and set up a shop just for the sake of it, and see how law engages, interplays, continuously pushes them to navigate their spaces around its system, regardless of what is written on the paper, because that's really what matters. Of course, what's written in the paper is going to come out. Get them to sit in the court and listen to the judges, good and bad both, whatever type of judgments. This experiential learning is really what teaches them law. We tell them that legal, you study law by reading what is written in a statute, only to realize much later, the world is very different. And this is what actually makes, law, so we have to look at law as an art rather than a science. And I know this might be a controversial statement for many, but anyway.
This is important. I am so glad that Yugang mentioned this, because experiential learning is one. The other is that there is a huge emphasis that needs to be and ought to be made on clinical legal education as a tool for amassing all other. I always feel sociology, history, philosophy, they are the bridges between the gaps between law and economics. And the way you amalgamate these is to put everyone out in the domain. But you can't do it if you have 60, 70 students in the class. You say, you can do it when you have 20, 25 or 30 students to work around with. Because experiential learning and that process of exposure is something you can do it in batches. So I think there has to be a mechanism in a pedagogical discussion. I'm quite sure Srijit in the institutional mechanism of discussing need to look at this. So I think experiential learning is very important. That's the way you'll introduce not just laws, but just the thinking of exposure to looking at other ways of thinking. Because what is of interest to you, Ashita, and me, and Yugang, may not be of interest to a student. Most of them, they want to go into commercial practice in an elite case of education. But once you expose them to a little bit of a background, you might find that litigation may be of interest as well, and that's something we want to encourage.
Quickly, Abhishek and Divya, your thoughts.
Most of the important points have been made. So just briefly, I would say that the examples that you picked up, which is that of agricultural laws or the labor laws, I would say, in fact, I've done this in class and students respond very positively to this, which is that to look at the historical trajectory and understand this in a political economic context. That you cannot understand this without understanding that there is an agrarian crisis. And if you know that there is an agrarian crisis, depending on the political context and the balance of class forces, you have a certain kind of political ideas and dispositions who are more powerful. So this, you can imagine, is a right-wing response to a crisis which exists. And when of course, you have to flesh it out. But when you make this basic point, it's a lot of students, it seems to make sense. Same with the agricultural laws, the labor laws, which is that you have declining growth rates, you have stagnation. This is in the advanced world. Also, you have the precipitous was in the 2008. This thing for us in India, it's I think after 2012 onwards. It's hard to solve the problem because it's a problem of capital accumulation, which the economy is facing. So then, how do you this thing? Well, it's one of the right-wing response that the state has to this problem. So yeah, I already exceeded my 30 seconds. So yeah.
So I'll probably stick to less than 30 seconds because most of what I wanted to say has already been said. Very specific, very great examples have already been spoken by all three panelists. So I'm just going to suggest a very different and a rather more long-term approach to include law and legal processes as a part of our day-to-day lives. It has to really start from the schooling system. It has to be incorporated into the entire education system and not just as a professional degree at the higher education level. And that's how we will start really incorporating the basic ideas of the legal processes and legal systems in our day-to-day life. So that's it. That's all I want.
Thank you, everyone. This has been a very interesting discussion. In fact, the takeaway for me personally has been that you cannot, yes, in the pursuit of teaching economics and law, we have to teach these two subjects, but we should not make an attempt to disintegrate them with philosophy, history, or sociology. We rather need to integrate all these fields to have a better understanding or a holistic understanding of law and economics together. So I will now give the mic to Srijit, and thank you. Srijit, you're on mute.
Yeah, sorry. Thank you, dear colleagues, for that extremely informative and insightful session. There was the absence of a lawyer in the panel. By lawyer, I mean somebody born and brought up in a law school, not really members with advanced degrees in law. But obviously, the central idea of the panel was for the law to become a subject matter of your conversation. Hence, the panel is constituted in this way. Thank you very much. And thanks to everyone connected to us through JGU's YouTube channel. Our next session, Economic Analysis in Public Health and Environment, will commence at 1:45 p.m. Please stay connected or tune in the next few minutes. Thank you, everyone. Thank you very much. Good afternoon, everyone. Welcome to the 6th technical session of the National Virtual Conference on Economic Dimensions in Judicial Decisions. I'm Srijit SG, Executive Dean, Jindal Global Law School. This session is themed Economic Analysis in Public Health and Environment Domains. The search of law and economics as a method has brought in many insightful notions into the regulation of public health and in the global protection of environment. Concepts of externalities, costs, and efficient outcomes helped us better streamline regulative and legislative efforts. This panel will deliberate on such and similar influences and impacts for the next. The distinguished panel for the day comprises of Dr. Nupur Chaudhary, Assistant Professor of Law, Center for Study of Law and Governance, Jawaharlal Nehru University, Professor Dr. Tarini Mehta, Associate Professor, Jindal School of Environment and Sustainability, Professor Dr. Charu Sharma, Professor and Associate Dean, Jindal Global Law School, Ms. Kritika Subramanian, Policy Analyst, Cuts International. The moderator of the panel is Mr. Abhishek Kumar, Partner, Indic Associates. Welcome to the 6th and the last technical session of this conference. Over to you, Mr. Kumar.
Thank you, Srijit. Really wonderful to be a part of this discussion. I was earlier scheduled to be a speaker, but happy to moderate, and which is a pleasure actually indeed, because this panel may be the last one, but I guess perhaps the most relevant one in the context that we are facing right now. So health has never been more important as a public policy area than it is in the wake of pandemic, which has kind of exposed all of us to the areas that we need to focus on. Which is basically human capital. So I want to say a couple of things before I really start out. One is that I'm very, very happy and honored to be part of this panel. And the second is that this panel also has 3 academics and 1 public policy practitioner. In my role as a moderator, I have also been a public policy practitioner, but I will try and chip in wherever I can with my experience and understanding of the subject. Also, what is interesting about this panel is that we have a lot of women. So there is often a complaint that gender participation in most of the panels is a problem, but I think we have a very, very good women-led panel. And I would request my panelists to also reflect on the inherent inequality when we speak about health and economics, where gender is an important component, which is often not mainstream as much as it should be. So without much ado, I just want to set the context and also very, very grateful to JGU and Cuts International for organizing this discussion, because I think it's high time we started talking about the role of courts and the judicial system, which is not only the Supreme Court, by the way, it is high courts, the lower courts, and we have to have the judicial machinery work in tandem in an integrated way. So, and this is something that has been written about in the past. When you get into the literature of public institutions, courts, because of the power that they wield on lawmaking, play a very, very significant, important role. So it is also an opportunity to reflect upon the role of judiciary and judicial decisions in mainstreaming health, both from the public health as well as healthcare point of view. So thank you once again to the organizers for this timely discussion. The context that I want to sort of set out before we begin this discussion is about really the opportunities and constraints that we are living in. I think it would perhaps be appropriate to, first of all, send condolences to all those who've lost their lives due to pandemic, but also to acknowledge that there has never been a time in the past where health and some other fundamentals which directly affect human capital are critical, very, very critical. So the major paradigms that major narratives that we have in the country today, I think it's important to sort of reflect upon them. You have a country like India, which which has its own growth trajectory, and this growth trajectory is placed in the larger context of sustainable development as well. So not only do we need to industrialize and provide meaningful opportunities to the young population that India has, but we also have to do it in a way in those frameworks which were not typically applicable in the context of several other countries, because sustainable development as a discipline has also been evolving, and there are newer frameworks that we need to be bound by when we're looking at our development paradigm. So within the sustainable development context, we have also the duty to preserve and provide for public goods, and which is typically something that is often seen in the as a responsibility of the executive. When matters often come to courts, one will agree that the courts are under tremendous pressure because they have to look at the legal technicalities, but they also have to look at and must look at the larger justice that they seek to deliver, which may be in the context of how will it really impact number of people, the scale of operations, etc., which may have a lot of implications in terms of employment, in terms of larger well-being for the environment and public goods. So I think it's important to keep that at the back of our mind. The third important aspect that I want to sort of draw attention to is the fact that we are also, even without pandemic, we are also the kind of economic model that we have come to practice as a society, and I'm not particularly talking about just India, but across the globe, has led to increasing inequalities. And these inequalities are manifested in different forms, but the effect of these inequalities is something that is often felt when we suffer a shock, whether it is economic shock or a health shock that we are witnessing currently. The fourth important aspect, where we have often seen that legal technicalities fail to address this important aspect, is the availability of resources. This availability of resources can be seen again in two dimensions. One is what is available with the governments to really put out in public goods. Every state government is their financial resources are shrinking. Central government is fighting a pandemic war, but also the efforts to sort of strengthen the narrative on more equal society and generate resources alongside is a very, very big challenge even for the central government. So I think these four important points need to be sort of borne in mind when we reflect upon the judicial system and how one looks at health in that context. We've seen that a lot of narrative has also come around on the aspect that the way forward to deal with the problem that we're dealing with will have to be need for communal efforts. Everybody, every stakeholder has to come together and chip in with their efforts. Now, courts, which are part of the larger political economy environment, also often end up mimicking the same behavior as the larger society is part of. So one critical question that I would like my panelists to sort of reflect upon in their specific questions or at the outset is that how should a legal system take into account such a complex, such a wide gamut of things when delivering justice, because it is essentially bound by the legal technicalities, but also must look at the larger justice. So these are the 4 points that I thought would be appropriate to bring forth. My last important point that I want to speak about a little bit is that you have a lot of cases in the recent past and even earlier where we've seen a lot of debate that has happened around the role of courts and the larger environment that needs to be preserved and conserved. We have cases like iron ore case in Goa mining. We have cases like sand mining. NGT has sat upon several of the cases. We have emissions case where Supreme Court decided on, looked at public health dimension as well as economic dimension also. So, so we're increasingly seeing that more and more disputes are landing up at tribunal level, are landing up at high court level, are landing up at NGT level, and also for the attention of the Supreme Court. So, so this trajectory kind of says something very important. And that important aspect is that when you are developing in the framework that we are bound by, which is sustainable development framework, you are often going to have confrontation with some of those frameworks. So what should be the right balance? How should one look at these things? Is a court system, is a legal systems, are our lawyers properly trained to address that kind of a complex balancing act? So with that, I will open up. With that, I will open up my first. I'll put out my first question to the panelists. Is really looking at the trajectory of number of cases that have come around in the recent past, which is oftentimes we've seen that when a court which has environmental dimension and decided upon by the courts, we've seen that there's a trend of a blanket ban. You know, there is binaries that we've observed in the decisions. I'll give you an example. Say, for example, housing sector. Now, housing is recognized as a, after automobiles, the highest a sector which has the highest multiplier effect in employment generation through the number of ancillary activities. But if you have a construction activity happening somewhere, which confronts with the environmental frameworks, does a blanket ban kind of an approach is something that is sustainable? Could there be alternatives that one can think about? So I think I'll begin with that fundamental question, and I would ask you to sort of also add more examples in your rejoinder or response to this question. So with that, may I bring in? I will go according to the windows that I'm really looking at. So there's no particular alphabetical order. So may I bring in Dr. Charu Sharma to begin with? Ma'am, floor is yours.
Thank you. Thank you so much, Abhishek, if I may. Yes, the context that you've sketched is definitely the most pertinent in which India is struggling. Public health, the crisis, the cataclysmic thing that we are all facing. And I think you rightly put it, that whether it is the judiciary, whether it is the policymakers, whether it's the Union Parliament, the parliamentarians, whether it's the healthcare workers, everyone is firefighting, right? And it is definitely, everyone is scared, and there's a need for a very strong leadership and confidence building. That's like, I just wanted to start with that. Confidence building, not only by the people who are governing us, maybe by also the judiciary in how they're handling the matter at the moment of COVID-19. There are so many distress calls going out every minute that the nodal officers who have been appointed in Delhi by the Delhi High Court for maybe a 40 group of hospitals, they are unable to do that. Whether our system has failed and whether we were unprepared for it are all questions gradually going to end up in the courts. Because the right to health, which may not have found a very specific written recognition in the Constitution, but has definitely been recognized under Article 21 of the Constitution by the Supreme Court, and very recently as well. So that right to health for every citizen is at the moment under, it's not there. If I'm breathing the air, I'm contracting this virus, it is no one's fault, but the fault might have been that we did not plan properly for it. I think all of us are agreeable on that. As far as the repercussions of this public health scare and the emergency that we are facing, it will go on to every sector, I believe. Not only socioeconomic, but people's mental status, people's motivation. If we are talking about well-being and sustainable development, we are definitely talking about well-being of the person, and then of the community, and then of the nation. So when we are looking at laws, and this is purely academic, because I'm an academic, when you're talking about imposing blanket bans, in times of emergency, your rights, fundamental rights could be restricted. And probably the social distancing and wearing of masks and fining people who are not wearing masks was one thing which we have seen. And for that, on that matter, there have been so many skirmishes between people as well as the police. And the police are the only people who are, try to firefighting everywhere. So those kind of violations of a person's liberty and the government's right to impose certain restrictions on your liberty in times of emergency are understandable. However, if these matters and such matters go to court, and suppose the court comes out with a blanket ban, you talked about the construction sector. I'll just come to that in a bit. Then there is the sand mining sector. We can even talk about that. But I'm just talking about today and present circumstances. So if criminal cases come to the courts for this, then obviously the courts are going to look at it, not looking into it without any kind of economic perspective, but purely within the dimensions of the parameters of the law. And if law, they're going to try and then balance out the right of liberty that I have or you have with the pandemic situation and the emergency and the rightful way and the manner in which government has given out this this ordinance or whatever law or policy that please wear your masks and try and save yourself, as well as if you're not wearing masks, you're killing another person. So that's very serious. So the restriction like that is acceptable and should be acceptable to people, at least now when we are seeing death all around, utter chaos. As far as total and blanket bans and how do they impact people, whether they're socioeconomic, again, employment, unemployment, bankruptcy. Yes, that's a very, very important thing, which whether it is the Supreme Court or the National Green Tribunal, they have looked into these and have made and delivered judgments which are probably for that particular case. At the moment, you see a number of judgments having been delivered. For that particular case, they have gone over and beyond, I would say, not only examining the parameters of the law, but at times, and I think Professor Sudarshan said it once, that of course, when judges are making a decision, at times they've also laid down legal policies. So within that ambit, if I can say so, I'm just paraphrasing him, he said policy, but I would say legal policy. So say, for example, sand mining. You talked about sand mining. I'll give you an example. Sand mining and sand mafias are very common, and housing and construction sector does need sand and cement making and so on. Now, if specific regions have a specific reason and it is impacting this sand mining, illegal sand mining is impacting the riverbeds, and because of that, water scarcity is there, and because of that, irrigation is impacted, then what will NGT do? In these circumstances, NGT comprises not only of judicial judges, as in who are looking specifically into laws, but then the NGT also has experts. So these experts are scientific experts, maybe economic experts, and along the whole bench would then sit on a judgment and might ban a certain thing that this is not going to happen. Say, for example, what comes to mind, because I'm a Delhi person, what comes to mind is a total prohibition on, burning waste or burning a stubble in and around the Delhi NCR. That there was a ban, total ban. Now, because of that, and because I'm staying in Sonipat, many students who were doing small projects came up to me saying, well, the farmers are not happy. They are not happy and they will not accept this ban, ma'am, because they say, well, this is the only way which is most convenient to us. We've been doing it for eons together, and this is the one which we know. Why should we invest in buying some technology to cut the stubble? And, we don't have that kind of money. They were told then that there are so many alternatives. So the NGT not only put this ban, but it came out with discussions that there are alternatives to that. And the government was ready to give loans and did give loans. So there's this chain of events which happen by a decision which is taken. And that decision has so many repercussions. But we cannot just, isolate or label the judiciary or the lawyers in not thinking out of the box. Probably, as an academic, one would say that, well, if you're only confining yourself to the law parameters, please understand that there are so many implications of your judgment. So this is the time when specialist tribunals, especially for the environment, are very, very pertinent. And the capacity building for these specialist tribunals, whether it's scientists, whether it's biologists, zoologists, or economists, in fact, becomes very important. So for me, when you ask me, even the housing sector, the court has provided a number of workable alternatives, like fly ash from alternative sources and thermal powers. So things are moving, probably, and this is not myopic. This has short-term and long-term implications. I think I'll stop here and let others join in what comments they might have. Thank you.
Before I go to the next speaker, it's a very, very interesting thing that you said and very provocative. And I just want to sort of take it to Dr. Tarini Mehta with a little bit of provocative angle to the same question. You said two very interesting things. One you said is we need more specialization at that level, but also because the trickle-down effect is so huge. It's a paradox that, as specialists, I may ignore the subsequent trickle-down effect. So the intent of really asking a question of courts really taking something in a blanket form is to really, really look at that nuance. Dr. Mehta, I will be slightly provocative, and I will also bring in not just the court, but also NGD, and just slightly being provocative in the sense that should National Green Tribunal, in the context that Dr. Charu Sharma really spoke about, should also be actually National Systems Tribunal because of the interlinkages that are out there. And if you can also reflect in your response to the main question that I asked, the kind of competencies that are really needed in order to take that on. You're mute, so you'll have to unmute yourself.
Thank you, Professor Kumar. I hope I'm audible. I think I am audible. Right, so this is a very important issues that are being raised, and especially at this time when we're facing the pandemic, and in addition to the pandemic, we are facing some of the worst crises in humankind. It's going to be even worse in the years coming. I'm talking about climate change and the kinds of impacts climate change is going to bring, the kind of impact the biodiversity loss is already bringing. You have about 1 million species at the brink of extinction globally. So this is going to have huge impacts on human life on planet Earth. So in that sense, this is a very critical period. And of course, COVID is just, made very apparent to us that something is really going wrong, that, we need to do something in order to, in terms of systems, but also in terms of the way in which development is taking place, the way in which human societies are moving forward and progress and the markers of progress, and everything needs to now be reevaluated in many ways. So in this sense, what I want to look at is kind of turn the kind of go back to the beginning, in a sense, let's say, or to the original question that why do we even have environmental law? Why do we need environmental law? We have, property law, we have criminal law, we have, civil laws, we have all sorts of other legal systems. Why do we need environmental law? And the reason we have environmental law grew particularly in the 70s and so on internationally is because of the need to protect the environment. So then again, these are all basic questions, but it's something which we tend to forget in the larger debate when it comes to a particular project or a particular judgment of the NGT or the Supreme Court and so on, is that why protect the environment? Why is it important? Why not just continue on the way we are? Continue to cut down trees, cut down forests, build industries. Why? Because we need to develop. Now the question is that, is this actually development? Because the first one question then is, who is this development benefiting? Who is this development for? If you look at the progress and development in India itself, in our country itself, this development model has led to a huge gap between rich and poor. People in rural communities are continuing to suffer. Himalayan region is an example of this, where the rural communities in the Himalayan region, whether it be dams, other development projects, the benefits don't reach them. The benefits reach, people living in urban areas miles away, who are disconnected from the realities of of the impacts of these projects and so on in these very sensitive regions. So who is this development for? And if you are trying to raise the living standards of people, then we need to kind of also look at that and say that what is the standard of living? What is it? Are we just looking at it in terms of material progress, which is an important factor, but can you have, so for instance, COVID is an example of this. You have a house, you have a car, you have money, you don't have health, you have nothing at the end of the day. So that's where environment comes in. If you don't have clean air, you don't have clean water, you have food that you're eating is laced with pesticides, cancer cases are increasing because of this. Every day there's huge increases in cancer cases because of pollution of water sources. Groundwater is depleting. You're not going to have water, and so you have the water wars rhetoric, which keeps coming up that, in the future, water is going to be the next point of conflict between countries. So if you don't have these aspects, then can we call this development? And this is the direction that India is moving towards. This is the direction globally we're moving towards. Climate change is an example, the clear example of the fact that this development trajectory has not worked. Now the other aspect comes in that the developed countries have had sort of a head start on development, but at what cost? They've had a head start in development. Their model of development has become the model of development that the world aspires to. But on the other hand, they have decimated their forests, they have decimated the oceans, and today we are facing, serious issues of climate change. COVID itself is a zoonotic disease. So the connections between COVID and biodiversity loss also need to be kept in mind. So COVID originated because of an animal, because of a bat. Other species have also been connected with this aspect of COVID, but also it's because of biodiversity loss, because of habitat destruction. And the increasing biodiversity loss is leading to greater interaction between humans and various species. And so this element, now when you add to this the fact that climate change is going to lead to the release of many more viruses. And there's a lot of scientific research on this. Viruses trapped under the permafrost are going to be released. So we don't know what kind of the next 50 years, 100 years, what kind of a world we are actually bringing for ourselves and for the future generations. Because they're the ones who are going to be faced with a world where water is polluted, rivers are polluted, there's diseases, there's no tree cover, you have oxygen bars opening up. Why should we have? If you think about these things, and in a way, because this is the kind of world we're living in, it's almost becoming normalized, but it should not become normalized. We should be questioning that why are we heading towards a world where you have to have oxygen bars? And it's a very cool thing, but is it actually? It means there's a crisis. These basic building blocks of life. So in that sense now, the role of the court comes in because of the fact that unfortunately our government, our administrative, the government structure, administrative structure in India has failed to implement the environmental laws. So there are a number of environmental laws in India. Even if those laws were implemented in itself, even if we don't talk about the improvements needed and so on, just implementing the laws themselves industries need to set up sewage treatment plants. It's a simple law that needs to be implemented, but you have, why are the rivers polluted? Why are the groundwater polluted? Because industries are not setting this up. Now then you have laws in place for that. You have fines in place for that. The laws are not enforced. So this is where the courts have had to come in. And Indian courts, as we all know, have played a very progressive role, and they have actually set an example internationally as well, in terms of the right to life, the expansion of the right to life, which Dr. Sharma talked about earlier in terms of the right to health. So this expansion of the right to life is a very progressive, very creative expansion. And the thinking behind this was that, as the Supreme Court said, that life does not just mean animal existence. It doesn't mean just, to be alive. It means having a life of certain dignity. And a life of dignity means you have to have certain basic elements. So food, health, water, clean air, clean environment. So in that sense, the right to clean environment became a part of the right to life under Article 21. Now, in the same way, the courts have had to step in a number of cases. There are a number of historic cases where the courts have not just passed orders, but they've had to monitor the implementation of their orders. Again, because of the fact that the orders failed to be enforced and implemented effectively. The NGT then was developed to be a specialized tribunal in this regard to, again, focus on environmental cases. The reason being that environmental cases are so complex that you need a specialized tribunal in order to be able to deal with this. And ideally, that tribunal should have a range of experts in different fields and so on in order to actually be able to come up with decisions which are have all the scientific basis and so on, because environment is an extremely complex field. And even in terms of, for instance, the application of a principle such as the polluter pays principle, if you don't even to understand, what is the extent of the pollution, what should be the extent of the compensation, that also requires a scientific analysis of the pollution levels of harm, and so on and so forth. So in that sense, the National Marine Tribunal was an important step that has been taken. I think we're, it'll be another discussion that we can take up here to look at what the NGT needs to be strengthened and so on. But the fact is that we need the court, whether it be the NGT, whether it be the Supreme Court, whether it be the High Court and so on, because of the fact that we need to protect the environment. So we need to kind of reverse the question backward. And the reason why we need to protect the environment is because we need to ensure a certain quality of life and standard of life for people. And that is the rhetoric of sustainable development is everywhere, sustainable development. But that's what sustainable development is meant to do. It's meant to be development that, while catering to the needs of the current generation, also meets the needs of future generations. So now sustainable development needs to be brought about. Now sustainable development needs a certain kind of policy approach, certain kind of planning. And if that kind of approach and that kind of planning is not happening, then where does a citizen go? A citizen will go to court and say that, I have certain rights, and those rights are based on certain needs. I have a right to life because I need clean air to breathe. So in that sense, I think this entire conversation and discussion needs to be we need to kind of go back to the original question of what are we doing? Why are we doing this? What's the purpose of this entire exercise that we are engaging in when it comes to environmental law and so on? Now, in the context of sustainable development, you have a lot of very positive examples. So the Nordic countries are a very positive example of sustainable development. They've been a leader in terms of sustainable development and sustainable, as well as in the happiness rankings and so on that come out. So in that sense, there are examples of countries that have made sustainable development a part of their planning, the policies and so on, and have actually implemented this. And this has had a positive impact on their citizens, on the standard of life, quality of life of their citizens. Of course, now the Indian context is much more complex than the Nordic countries, so it's going to be much more complex exercise. But it is an exercise that needs to be done, and in that sense, then the NGT, the Supreme Court becomes, watchdogs in that sense to ensure that A, the laws be enforced, B, the basic needs of people be provided and be protected. And that's where they've had this expansion, where you have the expansion of the right to life, where you have an expansion of these laws in that sense to ensure that there's greater human rights in this entire framework and protection of people and their interests.
Thank you, Dr. Mehta. I mean, before I take it to Dr. Nupur, it's my comments in the middle are just basically snowballing into making this question perhaps even more interesting, because the previous two speakers have already added some very interesting dimensions to it. But just on a side note, you did speak about science-based approach, scientific approach. We just recently held a dialogue at Rajasthan, where we placed, on air pollution. And I think one of the outcomes of the dialogue was that the clear message that I think in terms of technical detail, there is enough out there for everybody to acknowledge. What is really needed are two really important aspects, actually three important aspects. First, the resources, which are economic resources that are needed to be generated in order to address both public health and healthcare. The second is the role of institutions and how those institutions can play an effective role. And of course, the third was a multi-stakeholder approach. Taking it to now, Dr. Nupur, you have the advantage of coming in towards the end. The snowballing effect that I was trying to introduce to this is that the same question gets another added dimension added to it, which is that is the blanket approach often taken by the courts the reflection of the lack of capacity and not having the adequate ability to look at different components in detail and then coming to a more staggered, perhaps layered solution?
Yes, thank you, Chair, and thank you to JGU and Cuts for inviting me today. As you correctly said, Abhishek, I've had the advantage of listening to both Charu and Tarini and then coming in, so my job is a bit easier. I just want to start by making some brief comments before I answer your question. So the first thing is to reiterate what Tarini and Charu to an extent also mentioned, is that the whole point of this event is also, there is a presumption behind this event, right? The presumption is that the judiciary is not the best actor to take economic policy decisions per se, right? So under what conditions should they come in? And because it is happening, so what should be the conditions that would justify their intervention, right? So first, before we come to before I answer that question, the first thing I would like to say is that economic growth per se cannot be the objective of any state policy. It has to be human development, right? And that, as Tarini rightly mentioned, that has both material and non-material aspects. This presumption that economic growth, leads to human development is a very weak one. There is enough economic literature that suggests that economic growth as a measure per se is very aggregative. It hides jobless growth, hides environmental destruction, and so on and so forth, right? And we are, just like the COVID crisis, we are also at the brink of a huge environmental crisis. So business as usual cannot be tolerated under any circumstances, which means that economic impact of not only executive and legislative, but also judicial decisions need to include long-term environmental consequences, right? And there is also this, we see it very quite often, that is there both within the legislature, judiciary, as well as executive, this idea that all environmental destruction is restitutive, can be restituted. There is an over-application of the polluter pays principle because of this presumption. And that is a completely false presumption, right? Not every environmental natural habitat can be restituted. That's something we need to all understand as a community, right? And therefore, there was this whole debate about go, no-go areas, right? When Jairam Ramesh was the environment minister at that point of time, right? And the second thing to also say as an addendum to this first comment is that environmental conservation per se makes eminent economic sense. Essentially, it is good to preserve the natural capital, right? And it ensures long-term economic growth and development. So this is not a binary at all, right? My second comment is briefly that because that was what the concept note seemed to suggest, that judges should not be economic actors or actors taking economic policy decisions, right? So I agree with that presumption that judiciary should be an adjudicative body, right? The basic function of the judiciary is to adjudicate disputes. But because there are basically two reasons, one historical and one just the way the setup is done. One historical reason is that we've always had judicial activism, and therefore there has been, through the public interest litigation movement, the judiciary has come into the policy space, right? And the second aspect is that in many instances, the judiciary has had to do that because both legislation or policy has been unclear, and therefore that gave them discretion to interpret provisions in a certain way where two or more choices could have been made vis-a-vis economic, right? Which they have done so, right? Now, given this presumption, this thing is to ask, the question to ask is that under what conditions should the judiciary, so general condition is that judiciary should not be an economic actor, and deference need to be shown to the executive and the legislature, right? And this is even more true for the NGT rather than the Supreme Court and the High Court, given the institutional structure of the NGT as a tribunal, right? But under what could be the conditions which would justify, so what would be a justifiability standard for the judiciary to intervene, right? I would suggest that there are two conditions that needs to be fulfilled for the judiciary to come and intervene. One is when it would be, one can say that there is egregious violations. So there is massive and sustained statutory and constitutional violations, and also violations of the court's judgment and orders. And I'll give you two cases in which this has happened, because these cases were highlighted, both the Mopa Airport case and in the Deepak Kumar case, which is about mining. In both these cases, the first response of the judiciary was not to ban. In fact, the response was to actually give more and more time to the executive to come up with solutions, right? And they, first of all, the judiciary was able to establish that there were massive violations, statutory violations, which were compounded by the fact that judicial orders were being violated. So if you look at the trajectory of the case, all these cases have been heard for more than 5 years and more, right? So the ban comes in only after half a decade of hearing. So that one needs to keep this in mind, when one tries to suggest that the ban is the first response of the judiciary. It's never the first response of the judiciary, right? So the second thing is that, and one condition being massive and sustained statutory violations, and second would be, I think one aspect in which the judiciary should intervene under one condition is that when there is great environmental or health disaster that is impending, right? So under these two, if these two conditions are satisfied, I think there is a very good case for the judiciary to intervene and to actually suggest economic choices, right? Now, I think I would just as a addition, I would like to mention that I am not a very good, I don't believe, let me put it like that. Let me make a more reasonable comment. I'm not a very good supporter of the suo motu cognizance by the NGT specifically. I find it very problematic, and I think it's a very important issue under what circumstances you are taking suo motu cognizance, and for what purpose. Because what has happened with the NGT suo motu actions, at least, that there is and this has also happened with Supreme Court to an extent, but it's a constitutional court, so one can at least give it more liberty. There has been an occupation of the field, I would suggest. So that we see in Godavarman. It's a great case for that, where you've basically taken over the entire forest governance of the country. The NGT has done that similarly with environmental accident cases throughout COVID. Essentially, you're becoming a governance institution, you're replacing the executive. That is what has happened. And I think this is very problematic because with suo motu cognizance, there is a complete silence of who is an affected party. So suo motu cognizance is happening along with the fact that there are affected parties coming and putting in their petitions, but entities also taking suo motu cognizance. So because the whole institution structure of suo motu cognizance, the rules are not clear, I think that has a very problematic impact. So my last comment is that if one were to agree that under certain very specific conditions, we accept the judiciary should intervene and make choices which have economic implications, what should be the standard of review? I think I would like to suggest that there would be a procedural aspect in which the judiciary should be looking at ensuring fidelity to the EIA procedure, which means that the kind of review that the judiciary needs to make is a fine-tooth comb review, is a thorough search and scrutiny of the EIA process. So the EIA authenticity of the EIA report made by the project component, was all aspects considered by the EAC and the SEAC? The reasons were there reasons given for the decision, and what is looking at the public hearing procedure? This is what the court needs to do in terms of a procedural review. In terms of a substantive review, I think the court has done that in certain cases, like where, example, in the NGT, for the NGT in the Sudeep Srivastava case, it has said that sustainable development as a principle, if you were to apply as a standard of review, you need to look at equitable access to natural resources, public participation in environmental decision making. These are important aspects, and I think what specifically the NGT has done, because it's possibly it could do it because the principle of sustainable development, as along with precautionary principle, is also mentioned, and the polluter pays principle is mentioned as a principle to be applied. So they've actually developed the jurisprudence around it. The other thing is the carrying capacity. So the NGT has looked at at specific instances, looked at the carrying capacity, and therefore instituted a ban. So bans have been local. First of all, this idea should be challenged that bans are national. There is no national ban. Right? There are local bans, and that ban was given after a long hearing, after establishing that there have been massive violations and it is beyond the carrying capacity. Right? So that's something to be kept in mind. Finally, coming to your question about, what should the NGT do? I mean, in terms of, I think I agree with Tarini. NGT is, is institutionally more capable of looking at environmental disputes specifically, which have economic policy implications, than the Supreme Court, or because it is a body which has experts. And if you look at how the jurisprudence has developed, it has taken in independent testimonies of experts. It has set up committees which look at fact finding. So there has been substantial institutional innovations by the NGT to respond to this question that what if you don't have the expertise? What do you do? Then you go beyond your own institutional in-house expertise and look at that. And that's something that the Supreme Court and the High Court have also done through amicus. So I think, just the first question, basically that's my intervention to begin with. Thank you very much.
Thank you. I think these opening remarks have given us enough food for thought and has provoked me definitely. I would just like to sort of react very briefly on this, and then keeping the time also into consideration.
I'm sorry, can I just add to what Nupur said? Nupur, thanks a ton. Abhijit, just give me 2 minutes.
Yeah.
Just wanting to add to, very rightly, Nupur has brought out the nuanced things which one ought to be seeing. But the question, I think, going back to the whole conference theme, what are the economic impacts of judgments, and whether the judiciary is mindful of these economic impacts once it makes judgments, whether it's the NGT or whether it's the Supreme Court and the High Courts. Probably all of us would agree sitting here in the panel that there have been cases wherein, and recent cases, not going even back to 15, 20 years, 3-4 years ago, most of the judgments in respect of environmental law, or even in respect of just specific application of tax laws, at times the judicial benches have gone into an analysis of economics and law. It is not that they've been unmindful of the economic impact. Rather, in fact, in the very often cited case of Shiva Shakti Sugars and Sri Renuka Sugars, this was the case wherein Mr. Justice Arjun Sikri delivered a judgment where economic considerations and impact of closing down or refusing to allow a sugarcane crushing factory to operate was like kind of debated. And here the court not only refers to the economic analysis, which Richard Posner, or to Ronald Coase's the Western economic analysis, which some might say it's absolutely not applicable here or we shouldn't look at it. Even so, it is not that the court has not gone into an economic analysis and economic impact in what Nupur was talking about in cases where the courts have very, very clearly, whether it's the NGT or even the Supreme Court, not looked into the EIA processes. Like the Society for Protection of Environment and Biodiversity 2016 case, the court has looked into the law, severed out the law which was bad, looked into the principle of non-regression, and also looked into the economic repercussions for giving an environmental clearance for building and construction projects. So one can't say that the judiciary are totally unmindful of the economic impact. I think the larger question, which I'm sure, Abhijit, you are going to come about to us, is whether within this context, the judiciary should be sensitized, and when there are projects which come to the judiciary through a PIL, whether there should be any kind of economic impact analysis already available to the judiciary to be able to make decisions which will have an economic repercussion. Doing an economic audit might come later, but probably capacity building, that's what I said. So that's what I wanted to say. Thank you.
No, thank you. Thank you very much. I just want to sort of reflect upon what has been said so far. And in the interest of time, the subsequent questions, we will try and make it 2 minutes each response. Just a couple of things. In my own research around economic impact of court judgments, Supreme Court and otherwise, one thing has really come out, and this is also coming out of this discussion, which is that on similar matters, the judicial principles do not have consistency. You mentioned Shiv Shakti. Shiv Shakti is an exception. Majority of the cases in the recent past that I'm aware about are not seen in the same way as Shiv Shakti is. Number of questions. Shiv Shakti, I think the economic impact in question was about 300 crores. When you look at other cases, you're talking about 1,80,000 crore and humongous cost, and not just the direct cost, but also costs which have a trickle-down effect, as Dr. Sharma, you rightly said, on banking, on employment, on a number of other things. So I think one of the important things that is coming out from this is that the nature of the cases, and there needs to be this exercise that the nature of the cases, common judicial principles do not exist. There is a high degree of variation in how the court treats each case differently. And actually that can also be seen in how lawyers, same lawyer representing different cases, have a different argument because they are actually representing a particular client. So this is a structural issue, and I think what can perhaps help, that can be a question that you might want to answer, is how to develop that consistency of judicial principles. One very quick remark on Dr. Nipul, you said that ban is not really the first instinct of the court. That again stands challenge. If you do look at the emission bans case and BS3, BS4, you have two things that can be questioned about when the economic impact is concerned. One is that enforceability, because if the intent of the court was to really prevent emissions, then it failed to do so. The second aspect that is there is that the entire judgment was in the context of public health, and only emission component was taken up. But the auto fuel policy very, very clearly talks about 4 other components to reduce emissions, which are related to governance, which are related to the structure and design of the vehicles, etc. So you're taking out one component, going out to look at that single component while 3 other components are ignored from the same policy that is challenged over here. So anyway, so these are open questions that we have. I'd like to come to a very, very fundamental question before I come to the processes. And processes of assessing economic impact is I think, well-stressed point, everybody has emphasized upon it. But a very fundamental question before that is that...
Mr. Kumar, if I may interrupt you, I had a few thoughts and I thought I'd just share it with the panel.
I'm bringing you in, right? I'm bringing you in with this question on the context. So first is EIA, SIA, and EIA, economic impact. Why? The larger sense that is coming out from this discussion so far is that environment subsumes almost every other interest, right? So will that not be putting blinders and looking at something in silos, whereas the need is to look at something holistically and assess the larger justice? And this is where I want to bring you in, Kritika, because you have been analyzing a lot of these cases which actually deal with these larger questions. Yes, Kritika.
Thank you so much. Am I audible?
Yeah.
Yes. So I just wanted to first just a few reflections on the points that Dr. Sharma, Dr. Mehta, and Dr. Chaudhary made on the previous question on looking at different challenges. And one of the things that I wanted to point out was the study that was being carried out by CUTS International. One of the studies that we were looking at aims to sort of objectively assess the unintended economic impacts through an evidence-based analysis and also a detailed consultation with different stakeholders. So two of the projects that I was involved in was the Goa iron ore mining and also the sand mining case in Gautam Buddha Nagar. So the aim was to sort of take into account the ex-ante estimates of the economic impact of judicial decisions using a systemic and sort of a structured process. The idea was to foster a discourse on broadening the considerations that courts could possibly take into account while making a decision. So just sort of moving in specific focus to the sand mining case. Most countries, what happens is that sand mining is officially regulated through a national mining and environmental protection legislation, with authority for regulation devolved to the state or the district level. Legislation is usually accompanied by non-binding guidelines to improve the sustainability of the activity. This governance structure sort of ensures that many small administrative entities have responsibilities for implementing and enforcing these regulations. The lack of these enforcements of regulation in India is a common issue that we have found through our case studies and analyses. There's also an inherent push that I have noticed that the government needs to take on sectors like the construction and the infrastructure development industry, with sand being used as one of the main components for the extraction from rivers as a core material in the construction and development industry. It is having a severe and widespread impact on its rivers and coasts, as mentioned by Dr. Mehta. The construction industry needs to be slowly weaned off the river source aggregates, either through substitution of materials or alterations in building designs and methods so that extraction is reduced to a minimal. This will ensure that there is a minimal negative impact on the environment and the ecology. This type of a societal shift that I believe is similar, that is required to address climate change, that will necessitate changes in the way that sand and river is perceived and that cities are designed and constructed. This is broadly these are the thoughts that I had that I thought I could share with you, and perhaps hear from the other panelists as well.
Thank you, Kritika. I think we're moving towards second fundamental question. I think the first segment itself has been very, very thought-provoking. I would like to go back to the question on the point on regulation that you spoke about. Now, Supreme Court in particular, or courts in general, like to take mostly a very conservative view when it comes to intervening anything that has come from a regulator, precisely for the reason that regulatory bodies essentially have to have the expertise that is needed to handle the sectoral complications, right? If you are talking about if you're talking about regulatory bodies and regulations not being adhered to, and that's something landing up in the court, then we are really opening up a very important fundamental question, which is that in the first place, when the courts take a very conservative view, and only rarest of rare cases where the regulation is challenged, when it lands up in the court, the court's deciding upon it, and the so critical question that comes in is where this is, I would like to also bring in Dr. Charu Sharma, that there is an implicit admission in this process of the lack of capacity to deal with different complexities, economic, health, environment, and all kinds of complexities. So what should be the ideal process that the court should actually follow in order to have a better, more informed adjudication? Question for the panelists. Dr. Sharma, can I bring you in?
Am I audible now?
Yeah.
Yeah, okay. I think, Abhijit, you're a policy person, so you've kind of taken the discourse in a very, I think, tangential way, going about questioning, if you're questioning what the judiciary should be doing when it is looking into regulatory dimensions.
That's not the question that I had asked. The question that I'm asking is that there is a convention in the country. I'm taking off from where Kritika had left. And Kritika has said in most of the cases that where she has studied and Cuts International is working on are the questions at the intersection of law and economics, wherein most of the times what is often found is that the regulations have not been adhered to, right? In general, the principle is that since regulations are housed with the necessary expertise, and that is the reason why courts really do not interfere or are averse to taking up cases where regulation has not really adequately responded. So in very rare cases, in my understanding, only 2 cases where regulatory decisions were challenged in the recent times was a cryptocurrency case and the court of judgment. I have not seen any other case that has come out of the regulation that has been challenged in the Supreme Court.
Here, I think in context, we are talking here when we're looking at either the public health emergency or we're looking at environmental dimension of maybe a regulator. Now, Rupert just talked about the way the Godavarman case was taken over by the Supreme Court. Supreme Court sat in as a governance body. Almost that administrative function is being taken up by the court. However, having said that, if you're looking to, I would agree that if there is a dimension, especially in environmental and ecological cases, where there is a research body or a cadre of people who can add to certain dimensions of certain projects, which are maybe referred to it by the central government or the state governments. And if there is enough research, when the question of regulation or regulation being violated or not enforced goes up to the court, as I said, that there is enough material ex ante for the court to consider, to call upon the consultants, that could be very, very, I think, productive and beneficial for the court to do its job then. The job being, here we're not looking into what is the economic impact, what is the job being at the moment, whether the law and the regulations have been followed. If they've not been followed, the reasons we know, now maybe we can provide a direction. So probably creation of a cadre, like we have the Indian Forest Services, we have the Indian Police Services, and I've always been very, very eager that there is suddenly, like Tarini was saying, if you don't care about the environment is killing you. We see this today. COVID is hitting everyone. Environment, it is a long-term thing which you should be working about. So the small-term issues, small-term steps that we need to take, if I may say so. And along with that, the judiciary and the other governance institutions, probably maybe a creation of a very strong cadre of research scientists who have the capacity and who keep on working, like the JGU-Cuts is working, like the Vidhi policy centers and so on and so forth are working. That information should be made available to the court, where the court and such institutions, the court can call upon the material and the research so that they're already forewarned, they understand, and then they probably go on. And which the court does, mind you. I'm not agreeing with you totally. The court does it. And in fact, the earlier laws, I remember reading the object and aim of a particular law, there used to be some kind of an economic impact assessment kind of a note always attached to the aims and objectives of a particular law which was enacted. So the judges had the benefit of reading that and then determining what is the larger objective of the law. So if nowadays, of course, it's missing. We keep on looking into the archives within the discussions and the debates which happen in the parliament, and oftentimes the economic impact of a certain law would also be missing as to how much money the law would have, how much money is the government going to put into making a law. So that dimension is missing. So if all this is considered then by policymakers, probably the job of the judiciary might, they'll have a better sense of where they'll be ending by giving a particular decision in a particular case.
No, I think very valid point, and you've raised a very, very interesting point, and this is actually the question that we should all be tackling right now, and I'd like to take it to all panelists, is that we earlier spoke about consistency of judicial principles on a similar matter. I think that's a need of the hour. Some kind of analysis, research analysis needs to be done on that count. The second is the same courts in some cases refer to a committee or a set of researchers or experts, but in other cases do not while arriving at a decision. So Dr. Sharma really kind of already mentioned the framework that this needs to be seen through. Let me take it to Dr. Mehta, followed by Dr. Mathur and Kritika to reflect on the same proposition, please.
So the main issue that we are kind of having to deal with, and the reason why this is happening, why these debates are also taking place now, is one is, of course, this has always been there from the time that the Supreme Court and its activist jurisprudence with regards to the environment, that perhaps the Indian judiciary is too activist, and so there's been this constant debate. And yet on the other side, we've had the arguments that there was no other choice. They filled the gap in terms of environmental governance. They expanded jurisprudence which protected the rights of people and so on. So you have this debate has been active for several decades now. The NGT has got added onto this debate at a time when you also have the government trying to weaken environmental laws, and we see this with the environmental impact assessment norms, where you have the government trying to open up various sectors, in the mining sector, for instance. And so in the midst of all this kind of a focus, of course, in order to economic progress is the main aim, and then with COVID issues and economic losses due to COVID, this pressure has increased. So you have more pressure now being put on natural resources. And now this debate has come around the NGT. Now the NGT, it's a tribunal, but it does have, one of the aspects is that a case, particularly if you're looking at a regulation has been violated. The environmental law, in other words, has been violated. The Water Act has been violated. The Air Act has been violated. The NGT has jurisdiction to look at that particular violation. So that is the more simpler, according to me, issue. The issue which becomes deeper is then how should they respond to those kinds of issues? So the blanket ban, sort of what you were talking about. Should there be a blanket ban? Are they the correct body to be imposing such major decisions which have an economic impact? That's so that kind of aspect is coming. And so when a law is being broken, it's much easier. There's a law. An industry has not put in place a sewage treatment plant. It should have done this. The law is broken. This is much easier. Now, what do you do with major hydropower projects? An EIA for the hydropower project. And there have been a number of interesting cases come out of the NGT where different types of decisions have been taken by the NGT. So in the case of certain hydropower projects where the EIA was flawed, the NGT has set aside the environmental clearance. In the case of other hydropower projects with similarly, flawed different aspects of the EI process, EI report being flawed, the NGT has not set aside the environmental clearance. And very often when it has not done it, the reasoning given is that this project is important for development, for national, in terms of the development, in terms of, for instance, the Renuka Dam and so on. So now this becomes another question to, these are the kinds of tricky sort of decisions which the NGT has to take, in this context. How do you balance environment and development? Now, in this context, what I want to bring into this debate is also the aspect of, again, trying to look at this issue from a broader angle, because I kind of feel that if we look at it from a broader angle and we kind of keep the end goal in mind, then we'll also be able to understand or be able to come to some sort of a preferred approach or a better approach or some sort of a beginning of trying to understand how should the NGT, how should the government, how should anybody that is dealing with the environment deal with the environment, So now in this context, we have the economics and we have the environment. And now one of the problems which was, is this sort of, that these two are seen as being separate, two different boxes. You have the economic gains and losses, you have economic progress and the environment. And for some, and the kind of debate and that has been there for decades, which is why we're in the position we are today, is because it has become, even though it is not said so much, the rhetoric is sustainable development, but the underlying belief is that you need to sacrifice the environment for economic progress, and that it is all right to sacrifice the environment, that it is, normal, it is all right, we normalize this, But actually, first of all, that is, an extremely flawed view because of the fact that you can't, as I already said, you can't have progress and development if you're sacrificing the basic building blocks of life. So you're sacrificing quality of life. Now, if you're looking at this from the point of view of ecosystems, right, and the services which an ecosystem provides. So as an adjudicator, whether it's an NGT, whether it's a policymaker, whether it's someone sitting in the looking at an EI report and deciding whether a hydropower project should be set up, the consideration has to be broader. It has to be in the point of view of now this particular resource, let's say a river, the hydropower project is being set up. This particular river provides a number of ecosystem services. Those ecosystem services include provisioning services. So the provisioning of for instance, water, irrigation, hydropower, all this is provisioning services. It also has regulating services where it plays a role in regulating various key basic elements related with biodiversity in ecosystems, without which you can't have ecosystems, without which you will ultimately not have the river itself. And then it also has a role to play, ecosystems have a role to play in supporting services, in supporting the ecosystem itself, and cultural services, so the spiritual, aesthetic, recreational values, which river, for instance, in this case, provides. So now, as a decision maker or policy maker, you need to be able to look at a resource and say that this particular project, this hydropower project, is going to provide this level of economic benefit, but also there is going to be losses because of the impact, the environmental impact of that particular activity on that resource. Those losses are going to have other impacts. So those losses are going to impact the regulating services, the supporting services, the cultural services. Now, some of these services that an ecosystem provides are irretrievable. They're irreversible. And
Dr. Mehta, if I can direct this, all very valid points. Would you recommend a process that perhaps courts can actually follow, which has had a proven acceptance by the judicial system as well as yielded positive results? What can be that process?
So in terms of courts, the process that they need to follow and the process which to different levels of degrees of success they have followed, in some cases they haven't. But again, the problem which the NGT faces in terms of this process is that environment is extremely complex. You need to have then a very varied expertise, and that is something which
multi-stakeholder research.
Exactly, plus the actual expert members of the NGT itself need to have those different levels of expertise. So that is one of the challenges when it comes to such cases. But then from a broader point of view, this kind of an approach needs to be there, not just at the NGT. So what I kind of feel is this debate needs to move into, in that sense, your area, the policy area, that we ultimately need to, the court should, if you look at it from the other point of view, we should not have to go to the court. If you see that as a point, why should we have to go to the court? We have environmental laws, we should have processes in place. The court should be the last resort. They should not be the first resort, but they are, which means that something is also going wrong at the policy level. Now, at the policy level, then these ecosystem services, etc., all this needs to come into a strategic environmental assessment approach at the policy level, where all these projects will be looked. So in that sense, economics should not be seen as divorced in that sense, or this kind of a debate where economics is environmental decisions are impacting economics, whereas actually sustainable development means that the three.
I may have to come in. No, point well taken. Absolutely, all valid points and well taken. I may have to come in because we have to ration the time. We have some students who posted questions. I'll come to Dr. Nupur. Briefly, Dr. Nupur, if you can reflect on the question, what processes can be followed by the courts to have a better balanced judgments, which takes into account economics of it, but also the social and environmental mandates?
Yeah, so I think 2 points. One is that what was suggested to us as one of the things that was that we were posed as questions was that should there be a formal economic impact assessment report that should be provided before, to the judiciary before such a decision when they're considering such decisions. So my thing is that my response is that firstly, the economic impact assessment de facto is already there within the arguments of the state and the project proponent. If you look at all judgments, de facto they do make the economic impact. Their whole point is, if you look at even by the kind of claims that are submitted, the admitting that they have violated environmental provisions comes much later. Firstly, you will provide the idea that you have a huge economic impact will be felt if the project does not go ahead, and then comes the admission that there were environmental violations, right? So that's already, although not formally, but that's already part of the judicial process, I would say. Now, economic impact assessment as a formal process, the cost-benefit analysis thing was mandatory by the Planning Commission for public funded projects. And that was done away with when we went into the PPE, the triple P kind of project area. Now, the question is that the problem is that who will do the project? The problem with the EIA report is precisely that. Who does it? The project proponent is paying for that. So who will pay for the economic impact assessment? Are you asking the state to do it, or will the project proponent be doing it? And then the fundamental question is that also that it is again an aggregate, it's of an aggregative nature, no? You're not going to disjoint. And is it going to be in the form of an affidavit? Because the EIA is kind of an affidavit report, because you have an environmental management plan post the approval of the project that you have to follow and justify, right? So you're actually reporting on what would be the environmental impact. So, the nitty-gritties have to be looked at. But it's a good idea actually, because I think it's very important that in fact of de facto making a larger, very vague ideas about economic development or from a project triggered by a project, you make an affidavit and you say that I think this A project is going to have this economic impact. Right? I think it's a good idea to have a economic impact assessment of a project, right? And but the problem is not about it's always the M&E part, which is the Achilles heels of environmental law. You see, it's the monitoring and enforcement. So if it's in a kind of form of an affidavit, you need to ensure that the project proponent actually follows through, right? So the other aspect I would like to talk about is, the question that was posed to us about the economics of polluter pays principle. We have a CPCP formula which is supposed to calculate environmental pollution, the damage for environmental pollution, which is now being applied by NGT across all the cases. From 2019 onwards, that formula has been. But there has been no discussion of the formula. How did you come up with an approximation of these values? right? Moreover, again, even if you apply that formula, is environmental compensation actually reaching affected people? We have no evidence on the ground of that. So you collect environmental compensation, but there is no disbursement of that compensation, right? Because again, monitoring and enforcement is a problem, right? Finally, the other important, interesting question that was asked is that should CAMPA funds be directed towards COVID crisis? Now, CAMPA fund, this has been a problem with all funds that are being collected for environmental restoration. So you have the District Mineral Fund, the CAMPA fund. There has been huge pressure from the executive to divert the fund for all non-forest purposes in a certain way. So nature conservation is never used for nature conservation. There is a lot of pressure, political pressure, to divert it. So I think it may create a bad precedence if you are going to accept that these funds, which are meant for nature conservation and environmental protection, is diverted for other purposes. So it may create a bad precedence, but given that, I think it is interest. One could imagine that if you were to use CAMPA funds and give it for to Gram Sabhas for their forest management activities, that would have a massive livelihood impact. It would stop. It would provide for livelihoods at that rural level, and that would reduce migration. So one can reimagine that. But per se, my first response is that one should not divert funds, which has been happening. Okay,
yeah,
and sorry, I know. Okay, sorry, yeah.
This is very interesting because a lot of places the funds are there, but they are not actually even utilized, right? District Mineral Fund is one example, and health, it can be actually effectively used for health for the mining victims. I have questions. It will be disservice on my part if I do not let some younger minds participate into this discussion. And we will do a rapid fire, a minute each. We will take up 3 questions, and because we are also rationing time. The first question, I'd like to actually begin this with Kritika, a younger colleague, and then we will follow the reverse flow. So the first question is, can we expect a judicial federalism or a uniform judicial order in the situations of emergency health crisis? For example, various high courts are entertaining multiple PILs on similar emergency health concerns at this juncture. Very quick response. Kritika?
So, can you hear me?
Yeah.
Okay. So I think the pandemic has been very damaging, and it has also opened the eyes of the people for the importance or how pertinent it is to have universal and robust public healthcare systems and the need for everybody to be covered under this system. The situation today across the country is that despite public health being historically understaffed, under-resourced, they've also really stretched themselves to meet the needs of the challenges of the COVID-19 pandemic. Kerala is one example where the public health services have done a remarkable job of containing the spread of the pandemic, especially through their primary healthcare systems. So perhaps the pandemic will play a role of a catalyst in leading a change in people's perception, and that can also lead to a rejuvenation of the public health services, because political will flows through the public. And if the public takes a greater interest, then obviously the governments will also have to respond. And just a digression would be also the budget. Although around 3 to 4% of public healthcare and publicly organized healthcare would be a good starting point to put in place at least a basic kind of universal healthcare system. The 15,000 crore rupees allotment that was given by the center for the health sector that was sanctioned along with the first lockdown is a welcome step. My only point is that a little bit more was needed in the routine annual budget of this year and those of the last 4 years. Just my final concluding point would be a point that the Delhi High Court had made, which was that just because someone is poor, the state cannot allow him to die. After all, health is not a luxury and should not be the sole possession of a privileged few. Thus, I think it's the responsibility of different arms of the government to keep in check and balances of each other and to closely monitor the extent to which prices of medicines, vaccines, and medical services are reasonable. If evidence points to the fact that cost is an impediment to access of resources, judicial bodies really need to step in to set the situation right. I think I'll pass it over to other panelists and hear out their thoughts as well.
Dr. Mathur, we're doing the reverse order. You may come in first. A minute.
Was that for me?
Yeah, so we're doing the reverse.
Okay, sorry. Yeah, I agree with Kritika more or less. I mean, my first impression is that I think high courts are very important at this stage because they are much closer to the ground than the Supreme Court. But I think there is a role for the Supreme Court not to supplant the executive, but to make it accountable in terms of huge equity issues are there at stake right now. Just the vaccine pricing issue itself. So I think that is an issue that the high courts can't deal with, but the Supreme Court is very much within its remit to deal with right now. So I think that's important.
Dr. Mehta?
Yeah, so I think again now this brings us back to the interesting role that Indian courts have, keep playing or have to play. The COVID crisis is an example of again various aspects of administrative failure, government failure, policy issues, the vaccine pricing, and so on. And so the courts stepping in, the Supreme Court taking suo motu cognizance, and Supreme Court saying that high courts are better equipped to deal with these cases because they are more, they're in each state, so they can kind of respond to the problems in that state. But again, this is something which it needs to be dealt with. Again, finally, the decisions, the policy gaps, and so on need to be addressed so that we don't have courts having to take this. My main point is that the fact that courts have to step in, whether it be the COVID crisis, whether it be the environmental crisis, shows that there's a huge governance failure taking place. And then these issues cannot be solved by courts ultimately. There's just decision will be taken, but ultimately there's, the governance gap, governance failure is going to keep coming up in different forms. And now with COVID, it's a huge human rights crisis taking place. It's a medical crisis taking place. And that needs to be addressed by policy, by government.
Sure. Dr. Sharma, same question.
Thank you, Abhishek. I think the question is very pertinent. Why is there a confusion in everyone's mind who's sitting right next to his phone or on the laptop and reading the news or listening to the news? The media is showing what it is showing, and the question probably was answered itself by the Honorable Supreme Court in the proper treatment of COVID-19 patients and the suo motu case which is going on. Public health is a state matter, right? So Delhi High Court or Karnataka High Court or the Bombay High Court, they're best equipped to deal with the matter at hand. The Supreme Court taking its constitutional duty to kind of provide a bridge and direction where there is none between interstate exchange of information, interstate transport, railways taking the oxygen tanks along. There's so much to do. It is not only between the center and the state, but it is within the state itself. And that is what the Supreme Court and each of the High Court probably and the district magistrates are doing at the moment. That is providing the mechanism, providing ease of access to the raw materials or to the oxygen or to the medicines which are there. And that's why it's very pertinent that the courts have taken up their constitutional duty. They're trying to do best firefighting. Of course, there also, there is, as Professor Mehta said, and I think others as well, there is a failure on part of not planning the disaster management action plan in respect of COVID. And the failure, of course, is not, I wouldn't say that it is entirely upon the government. It is people who have also, violated the norms and gone ahead into crowds and markets and so on and so forth. So there is a lot of things which are required. And first of all, I think it is people like us who need to abide by certain things. If we have to stay at home, we stay at home. And if the others are doing their job, we should be helping them in doing their jobs. Thank you.
Yeah. No, thank you. We have several more questions, but we're also running out of time. You also said that what should be the responsibility of people? When you think of the polluter pay principle, you always, one thing is, okay, enterprise dimension, but we often forget the consumption dimensions. We are also polluters by consuming a lot of things beyond our requirements. So who is really accountable for that? See, these are open questions. I hope that some of the unanswered questions can be documented and circulated to the panelists for their reflection, should they wish to reflect. That will really help the younger people who are interested in these discussions. I would like to sort of, 3:15 is the cutoff time for this. I would like to sort of bring out some of the important things that we discussed today. I think one of the first and foremost things that we discussed is that everything is subservient to environment, and public health, both healthcare. Healthcare is essentially curative aspect of it. Public health is preventive aspect of it. More we care about environment, more we will usher in public health infrastructure. So that's a paramount thing, and everything should really flow from that understanding. So Supreme Court in this case must be a watchdog, an effective watchdog, and in doing so, it can only be an effective watchdog if it also plays its part, which it is duly mandated to also strengthen the subordinate judiciary. Rather than being apologetic about the workings of the subordinate judiciary, I think the higher courts need to step in and strengthen their capacity as well. The third important part that we've seen is regulation plays an important part, and many of the cases where health has regulation has not been adhered to, where regulators are supposed to have the expertise, and there's a tacit acknowledgement that both regulators as well as court systems can do better by referring technical matters to a group of experts, and such experts should be multi-stakeholder experts, essentially, so that a wider perspective is brought in. The couple of more points is that yes, the process of referring should be more of a norm to expert committees than an exception, and judgments like Shiv Shakti, sugar mills, etc., their essence should be taken in order to guide the judicial principles on economic and health and other aspects as well. The last thing that has come about is that there is a need, which I have already spoken about, there's a need to federalize the judicial, economic, and environmental and social thinking through the entire chain, rather than having a disproportionate expertise at different levels of judiciary. I think this requires a systems thinking, this requires a system change, this requires actually many more discussions like these, and we hope we can actually federalize many discussions like these more in future, so that our expectation from each other are also get more refined alongside our understanding of the complexities that come along. On that note, again, I'd like to extend gratitude to JGU and Cuts International for organizing this. Vice Chancellor Professor C. Rajkumar, I've known you for some years, very, very able leadership. Thank you for organizing this. Been a pleasure. Thank you.
Hey, thank you so much, Abhishek, and thank you to Charu, and wonderful seeing you, Nupur, and thank you, Kritika and Tarini. So good that you all were part of this session. I really appreciate your valuable comments on this was a very important panel, and there couldn't have been a better panel to end this two-day conference as we move into the validity session. So thank you very much. We will be starting the validity session shortly on gazing the crystal ball, a step into the future. Dr. Montek Singh Ahluwalia will be delivering the keynote address, along with Dr. Frederick Jenny, Emeritus Professor of Economics from the Essex School of Business in Paris, will be delivering the validity address. So we'll take a short break and we'll be back in, say, 8 to 10 minutes. Thank you. Sure. Good afternoon to all of you. Good morning to others who may be watching from Europe. And it's such a pleasure for me to welcome all of you to the second day validity session of this conference, specifically on the theme, Gazing the Crystal Ball, a Step into the Future. I would like to welcome all of you to this validity session. I sincerely hope that all of you and your families are safe during these extraordinarily difficult times. As institutions, we have a responsibility to continue to drive change and impact, especially in these unfortunate times. And this was the reason why OP Jindal Global University and Cuts International decided and stood by its decision to host this conference even at this time. Therefore, with a commitment to continued evolution and reforms in the way in which our institutions will respond to very many issues, including the current theme at hand, the law and economic analysis of judicial decision making, which has never been more important than now, at a time where additional demand as far as justice in various forms is the collateral damage of the ongoing pandemic. OP Jindal Global University and Cuts International had collaborated to organize this national virtual conference on economic dimensions in judicial decisions across the last 2 days. I welcome each and every one of you to this validity session. My very warm welcome to Dr. Montek Singh Ahluwalia, former Deputy Chairman, Planning Commission of India, and Dr. Frederick Jenny, Emeritus Professor of Economics and Co-Director, Center for Law and Economics, Essex School of Business, Paris, and Chairman, OECD Committee on Competition, for taking time off their precious schedule to be here with us and to be part of the validity session. Thank you for being with us. My special gratitude to Mr. Pradeep Mehta, Secretary General of Cuts International, as well as who has been with us in these 2 days and joining in partnership with OP Jindal Global University to host this conference. Last 2 days, we have witnessed over 45 thought leaders, including judges, legal practitioners, experts from the government and regulatory bodies, representatives from the private sector, academicians and scholars, representatives from media and civil society, including consumer protection groups, environmental advocacy groups, and trade unions, come together across 8 thematic sessions and 2 plenary sessions that included 4 keynote addresses, a book discussion, and a special judges colloquium to deliberate on some important issues related to the economic dimensions in judicial decisions, with hundreds of viewers witnessing these intellectually engaging deliberations. This pandemic has brought us under the lens various issues of justice, and using economics in judiciary will be an important next step to making the judiciary more effective and more impactful. At the same time, with economies breaking down across the globe, judicialization of the economy will be instrumental in paving a brighter post-pandemic future in our nation. Therefore, now is an important moment for us to reflect on how we can strengthen institutions such as the judiciary and the economy of our nation to strengthen our system. We draw upon experiences from different parts of the world, and I'm very happy that Dr. Jenny will be sharing those experiences as well. Today, we are in the esteemed presence of 2 leading stalwarts, Dr. Ahluwalia and Dr. Jenny, and I'm sure the next few moments will be highly enriching for us to envision this very future. Now I call upon Dr. Frederick Jenny, Emeritus Professor of Economics, Essex School of Business, Paris, to deliver his validity address.
Well, good afternoon, and many thanks to OP Jindal Global University and to Cuts and to Professor Rajkumar and Pradeep Mehta for inviting me to address this really important conference. I want to share a few thoughts about the multifaceted interaction between law and economics, and I will focus on 4 points. This topic, of course, is a topic which has been of interest to me all my academic life as a teacher and also all my professional life, both as an economist and as a judge. So let me start by saying a few things about market economy in general, and to remind all of us that market economies are based on transactions, and that transactions require legal instruments to take place. From an economic standpoint, a transaction is a situation where a supplier of a good or a service and demanders enter presumably voluntarily, into mutually beneficial exchange. And that is, at least from the economic standpoint, an exchange in which is such that none of the transacting parties is worse off, and some or all of them have a benefit. So this is what a transaction is. Second, a market economy is based on the interaction between myriads of economic transactions, which reflect the individual choices of the parties. Now, when it comes to individual choices of parties to a transaction in a market economy, we know that the behavior of the parties in the transaction, and therefore the outcome of the transaction, will be shaped by the values of the parties, the incentives that they have, and the constraints that they face. Within the constraints that they face will come, there will be various types of constraints. The scarcity of their resources, for example, the technology, which determines how the resources can be transformed into goods and services which are being transacted, the environment of the transaction, but also the legal framework in which the transaction takes place. And this brings us closer and closer to the issue of law and the issue of a judicial decision. Laws shape the incentive and impose constraints directly or indirectly on transaction between the parties to the transaction. They allow or reward certain types of behaviors which are considered to be socially desirable, and they discourage some other behavior. This can come about through, for example, the allocation of property rights, which determines who owns what and what can be exchanged, or through implementation of labor laws, which define the type of contracts that individual workers and firms can enter into, and of course those that are prohibited, or family law, which allocates assets and obligations among the family members, or environmental laws, which constrain the production of some goods and impose costs on polluters because of the negative externalities that they impose on society, or through the implementation of contract law, which sets the conditions under which obligations are exchanged between the parties to a transaction, and also provides for the resolution of dispute between the transactors, and therefore allows non-instantaneous contracts, or through bankruptcy law, which organizes either the reorganization of the bankrupt firm or the distribution of its remaining assets among the various categories of creditors, and therefore makes credit possible, or through competition law, which discourages and sanctions certain cooperative practices or abuses of dominance by firms with market power, or through unfair competition law, or through consumer protection law. So I've only given some examples of the constraints which are imposed by laws on transactions, which are economic in the sense that they are based on the exchange between two or more parties of services or provision of goods. So the legal framework shapes the incentive and the constraints of economic agents, whether they are consumers or business firms or even regulators. Thus, what the laws do is that they allow or facilitate or control certain transactions, with the result that the laws, in fact, determine the result of economic activity. Not only what can be produced or traded or consumed, but also what the distribution of benefit between the transacting parties is going to look like is determined by law, as well as what cost the trading parties will incur if they enter into a transaction, or how they will share the risk. All this is determined by the combination of laws. So laws are usually important for economic activity. On the other side, laws prohibit, rightly or wrongly, certain transactions and therefore prevent the emergence of some goods or services. So my first message is that there cannot be economic development or a market economy without a appropriate and effective legal background to this economic activity. By the way, we found this out very stunningly in the 1990s, when for 10 years after the fall of the Berlin Wall, and that is from 1990 to 2000, Russia, which arose from the demise of the Soviet Union, which had switched from a centralized economic model to a market economy, so its GDP fall continuously when everybody was expecting that the move to a decentralized market economy would have led to a fast development. And the reason for this unexpected result is that in the former Soviet economies, there were none of the laws which were necessary background to support a market economy. Something, by the way, which had been overlooked by a number of international donors, which thought that liberalization would necessarily lead to a development of those economies. Second, when we look across the world and when we compare the situation of various developing and developed countries, it is immediately obvious that countries which have a poor set of laws or a corrupt or dysfunctional or inefficient judicial system fare economically much worse than the other countries. If you ask yourself, why is it that Nigeria and Korea, which were at the same level of economic development in the 60s, have diverged so much, it is fairly clear that the quality of the legal system and the judicial system in Korea is much better than that in Nigeria, and that this explains to a large extent what happened to the evolution of those two countries. Let me now move from this general idea about the relationship between law and economics to a more detailed view of those two fields, and to try to bring to you the fact that both law and economics are faced or confronted analytically with some of the same issues. Let me give an example. Advances in behavioral economics and the development of artificial intelligence raise questions about the implicit model on which both the legal approach and the economic analysis rest.
Yes.
This model assumes that decisions are the result.
I'm on a Zoom call. आपने मुझे कुछ भेजना था. I'll do it later, okay?
This model assumes that decisions are the result of a deliberate process of choice by individuals. This assumption explains why individuals who violate the law should be sanctioned, or why individuals should, as a general rule, be held liable for the damage that they have caused. This is also the reason why we believe that economic transactions entered into by individuals or firms are welfare increasing. But the development of behavioral economics, as well as the technological progresses in artificial intelligence, suggest that many decisions are not the result of a deliberate process of thinking, but the result of what Kahneman, for example, called fast thinking. In other words, the fact that individuals or firms rely on heuristics and have decision-making process which are fraught with all kinds of biases. As a result of this, the manipulation of the decision-making process by third parties becomes possible, as we observe, for example, in the digital world. Now, one of the consequences of this is that the decision of individuals or firms will not necessarily be consistent and will not necessarily be rational. The same individual may be led to take contrary decisions on the same issue depending on how the context of the issue is presented. A number of countries have used those results for policy purposes. I can give you two examples of this. One of them is that when it comes to organ donations, for example, the same people will not react the same way if they are told that they are assumed to be willing to give an organ upon their death unless they sign an affidavit stating that they do not want their organs to be harvested, or if they are told that they are assumed not to be willing to give an organ after the death unless they sign an affidavit explicitly stating that they allow their organs to be harvested after their death. And a lot of countries, particularly in Europe, have shifted the presumption from the presumption that people didn't want to have their organ harvested to the other presumption, the contrary presumption, with the result that there's been a massive increase in the number of transplants which have been possible thanks to the increase in the number of harvested organs. Another application of this principle is the question of whether in countries in which class actions are possible, for example, for consumers to get compensation for the harm that they have suffered from unreliable suppliers, those class actions should be of the opt-in type or of the opt-out type. Very different results from the economic point of view will be obtained depending on the formulation of the alternatives for the decision makers. Now, this has deep implications for the notion of free will and rationality, which are central both to law and economics. Indeed, the repressive laws are based on the principle that they will deter socially objectionable behaviors if parties who may be tempted to break the law are rational. Now, if it turns out that parties are not rational, then the legal system as well as the economic system tends to break down. Third, let me address very briefly the role of the judiciary and the importance of the judicial decisions. The first role of the judge, of course, is to see to it that legal prescriptions are respected, and that is to enforce the law. In doing so, the judicial decision inject into the system the kind of legal predictability which will allow economic operators to anticipate what could be the benefits or the cost of entering in a transaction with another economic operator. For example, an investor can evaluate the risks associated with an investment given the provisions and the jurisprudence in the bankruptcy law and the effectiveness of the judicial system to uphold the bankruptcy law in case of default of the borrower. The second role of the judiciary from an economic standpoint is to compensate an aggrieved party in the case of a default by one of the parties to a transaction. The law will tell the parties and the judge which damage can be compensated, and therefore what is the counterfactual that should be used to assess the damage. And the judge will have to ask the task to apply the rule to the facts of the case and therefore to assess in the particular case at hand the amount of damage. Now, this may require quite a bit of knowledge of accounting and economic understanding by the judge. The third role of the judge is to interpret the contract in the rather frequent case where the contract between the party is either incomplete because they have not anticipated all the possible circumstances which could affect them, or even because they have included provisions in their contracts which are contradictory or unclear. To illustrate this point, the result of the judicial proceeding will economically be very different depending on whether the judge takes a literal view of the contract and considers that any missing provision in the contract is not part of the contract, or whether the judge takes a wider view and tries to establish, by looking at the object of the transaction, what the parties would have agreed to if they had anticipated the circumstance that they encountered. Or, third possibility, if the judge considers how the law was meant to be interpreted in such a circumstance. There's also the case where the law itself is unclear and where the judge may have to interpret it, unleashing an anticipated economic consequences. In such a case, the judge may bear a considerable indirect economic responsibility. To make this very personal, I've lived through such a case in France when I was on the court. The case was a civil liability case. a man was born deaf, mute, blind, and paralyzed because of a diagnosis mistake made by the obstetrician of his mother. And his mother would have aborted if she had known that she was giving birth to a crippled son. So the son was seeking damages from the pediatricians for being alive. Now that case raised many complex philosophical and legal issues, as you can imagine. No one in France had ever claimed before that having been born could be a source of a prejudice that had to be compensated. So after much soul searching, the French Supreme Court decided that indeed being alive in such terrible circumstances could be a prejudice which needed to be compensated. Now, one of the consequences of these decisions was that all obstetricians were terrified at the idea that they could be held liable to compensate damages if they made diagnosis mistakes. And they all took hugely expensive insurance policies, which increased considerably the consultation fees and disrupted the market for obstetrician services, up to the point where the French Parliament intervened to prevent a repeat of such a case. Now, this is typically a case where a decision which is based on very high legal and philosophical principles has unintended economic consequences, which are seriously important. So all this suggests to me several observations. First, the economic dimension of human activity is getting an ever-increasing importance at a general level. Part of the reason is that after many centuries of very slow growth, we live in a period where technological progress allows economic development to take place when the economies are well managed with a realistic prospect that poverty can be wiped out from the surface of the earth and that general welfare can be increased. At the same time, we live in a period where the predictable economic risks to mankind have increased. For example, climate change, which was the topic which was discussed just before this session, and the warming of the planet are a real threat to our own survival. Second, as countries develop more and more, people have the possibility to access the judicial system. Thus, the management of resources is gaining importance, and the economic dimension of judicial decisions is likely to be even more closely scrutinized in the future. Second, in a number of cases, to assess damages or to set penalty or to interpret the law, the judge will need a keen understanding of business strategy, economics, accounting, and or finance. So the question of whether judges should have an economic background himself or should be able to rely on economic experts, and if so, under which circumstances, is going to be an ever more crucially important question. I personally believe that judges cannot entirely rely on experts because they have to ask specific questions from the experts, and formulating such questions requires some understanding of the economic issues. Therefore, I believe that judges should be educated in economic matters during their formative years, just as I believe, by the way, that economists should be educated in legal principles. This is all the more so that we are in a period wherein the digitalization of the economy means that many of the classical concepts that are used either in law or economics become obsolete. For example, the experience in many jurisdictions has been that it's very difficult to apply labor laws to ecosystems when trying to deal with the likes of Uber, because the relationship between the platform and the driver doesn't fit the categories of employees or doesn't fit the the contractual relationship between two independent entrepreneurs. The traditional notion of a vertical hierarchical firm does not apply to ecosystems. The idea that the provision of a service gives rise to a price is often defeated by the fact that apparently free services are routinely offered. The idea of market has to be redefined to include the possibility of multi-sided market and cross-product subsidization. So my last point is on the efficiency of the judicial system. The economic effectiveness of the judicial decision hinges not only on the ability of judges to grasp the economic background and direct or indirect consequences of the cases that they deal with, but also with their ability to deliver their judgment in a timely fashion. As we all know, justice delayed is justice denied. But in many countries, as more and more people rely on the judicial system to deliver judgment, as many cases raise more and more complex issues, and as the importance of the judicial function is not always fully grasped by governments, the judicial systems find themselves more and more unable to deliver judgment in a timely and or economically relevant fashion. I know that this is an issue in your country. It is also an issue at the European level. The risk in such situations is at three levels. First of all, that ex ante general regulations replace general laws, which are exposed with ex post analysis of each case. Second risk, that competition between national judicial systems lead to a possible loss of national sovereignty in some countries. Third risk, that reliance on alternative dispute resolution mechanism may come to be seen as a way to bypass the inefficient court system and to be more relevant than judicial decisions. In Europe, for example, in the area of competition law, the frustration with courts reviewing the decisions of competition authorities has led the EU executive and the governments in several countries to adopt tools that would in fact allow them to bypass the courts. For example, competition authorities can now impose interim measures before any substantial analysis, or they can enter into deals with the firms which avoid the pain of having to. The recent proposal concerning the Digital Market Act in Europe similarly proposes to allow the European Commission to prohibit a number of practices without having to define relevant markets or even an anti-competitive effect of those practices, and without having to look at specific cases. The second risk, I said, is that firms may decide to have their legal issues adjudicated in a different country if the judicial system of this other country is considered by them to be more effective than the judicial system of the country of origin of the firm. We have this case in Europe, where in France, intellectual property cases were dealt with by generalist judges, which were very slow and not very realistic economically. Germany created a specialized intellectual property court, which was rapidly seen as being more efficient and faster than the process in France. And a lot of transnational firms in Europe have moved their intellectual property issue to make sure that those issues would be looked at by the German courts rather than by the French legal system. Finally, there's the risk that firms, when they have a difficulty, which may have an important economic impact, decide to rely on alternatives to the judicial system, for example, on arbitration, rather than going to court. This may be in the private interest of the firm, but it's certainly not in the public interest of the development of a stable, transparent, and predictable legal system. What should I conclude of this? Well, the economic context of judicial decision is ever more important, as I said, and judicial systems are in competition with alternative modes of dispute resolution or of interventions into market mechanism. So it is crucially important that courts be given the resources to deliver swift and economically relevant judgment, and that judges be educated in economics to better assess the economic impact of their decision, and to be able, whenever they have a degree of discretion, to take into consideration the economic consequences of their judgments. Many thanks to you.
Thank you very much, Professor Penny, for that fascinating and indeed compelling tour de force on the very complex issues surrounding law and economics and how it informs judicial decision-making process. I am also grateful to you for sharing some experiences from the French jurisdiction and how that has shaped the evolution of law and economics in your own jurisdiction. Let me now request Dr. Mantak Singh Ahluwalia to deliver his keynote address. Dr. Ahluwalia, over to you.
Thank you very much. It's a great pleasure to be participating in this concluding session. You know, I especially one which has so many friends, Pradeep Mehta, and of course, Professor Jenny, I've interacted with before, and it was nice to interact again, and I hugely enjoyed the very knowledgeable and instructive address that he's just given. Actually, you rightly described it as a tour de force. And I just want to reassure you that there's no way that I can match that. In fact, when I was asked to speak, I pointed out that it's a little odd to be giving a keynote address on a valedictory session. It's more like sort of a farewell address or a goodbye note. So I assume that everybody has heard what Professor Jenny said. And I agree with all of what he said, actually. So I'm going to, give us sort of Indian perspective, not as an economist, but more as someone involved in policy. You know, I want to clarify, I think Dr. Jenny quite rightly said that he's strongly in favor of judges learning more economics, just as he's in favor of economists learning more law. But you know, I have to tell him that the role of economists in policy decision-making is minuscule compared to the role of judges. It's a great mistake to think that economic policy or even economic legislation is actually dominantly done by economists. It's not. And I think that's a separate issue. I mean, how carefully do we go into the structure of our laws and whether they correspond with what we think as economists would happen? I won't go into that, but I just want to make the point that you can teach the economists, and you should teach the economists more about law. I mean, simply because in a rule of law society, all economic decisions should be and are contestable. And in the end, the signal that the system gives is the signal which comes out of the courts. A good friend of mine, the former judge of the Supreme Court, said, we're not infallible, but we are the final word. And that's a very powerful position to be in. No economist is the final word. And in fact, economists routinely get discredited every 15 years and fashions change, which is actually quite good. So let me, with those words, give you what, as an economist, I think it's relevant to think about. One is that, you know, a long time ago, economists came to the conclusion that the performance, economic outcomes and economic performance are not the result of just economic policy. A very important determinant of whether economic policy, whatever it is, has the impact that you expect it to have is really the role of institutions. Institutions very broadly defined, but clearly the legal institution becomes a fundamental underpinning of a lot of this. So this goes back to the work of Douglas North, that the role of institutions are not just a sort of neoclassical, marginalist, market type analysis. You've got to see how will a policy operate given the kind of institutions that it's going to function in. And I think there are two broad institutions that I would identify. One, at a very abstract level, is the level of social trust. I mean, that's not easy to define, but there has to be some assumption that the system is actually going to be fair. Now, by the way, whether that fair system is a rule of law system or a fair system that isn't a rule of law system, more like a rule by law system, is a separate issue. But of course, in our case, we are a rule of law system because we don't have the kind of level of trust that would justify going by a rule by law type of system. There just isn't that kind of trust. So we do need a well-functioning legal system that would command respect, that would create a sense of certainty amongst economic participants, that would enable investors to make investment decisions, saying, okay, this is what I think, these are the rules that I have to observe, And if my actions are challenged, or if I am in some sense, somebody does something that I don't like, I can take them to court. And that somebody could be either the government. I mean, you may have a conflict between an economic agent and a government. You may have a conflict between a consumer and a producer. I think Professor Jenny's example of the obstetrician in France who was sued by somebody who he failed to diagnose would be seriously compromised before he was born is an example, and there are many, many others. And then, of course, you can be sued by other. Company A may be sued by Company B. Company A may be domestic and Company B domestic. Company A may be domestic and Company B may be foreign. But all of these need to have a sense that the laws are clear and the laws are going to be carefully and fairly and independently implemented. Now, I think there wouldn't be much debate on this. And I think it's very clear that, we fall short in many dimensions. Now, the most obvious, and I think something which we could actually resolve within a few years, is that we don't have enough courts, we don't have enough judges, we don't have enough expertise amongst the judges. And that too, by the way, as Professor Jenny said, you could react to that by simply setting up more specialized courts, which would by definition have judges who would then learn up the relevant economics. Or you could do what we've been doing, which is actually, in my view, not very sensible, which is to create tribunal kind of systems, where one of the judges involved happens to be a retired judge of the High Court, and the other fellows are either former civil servants or technical people or something. And I know that many of our most distinguished jurists have said that this is the wrong way of going about it, because all these decisions ultimately become subject to a final decision in the Supreme Court anyway, and it would be much better to have specialized courts rather than, as somebody called it, tribunalize the justice system. I wasn't very convinced of this earlier, but when I think about it, I am much more convinced about it. It's absolutely true, by the way, that given the volume of work and the number of people, we just don't have enough judges. And frankly, that's something which, if the government, both the central government and the state government, were willing to put a little bit of money into it, this is a problem that could be solved in 5 years, and quite frankly, it ought to be solved in 5 years. That's one point. Second, which is a little more different, is the difficulty of how do you choose judges. Now, that, of course, as you know, is currently a matter of huge controversy in India. Is the present system, the collegium-based system, the best system, or should we have a national judicial appointments commission, the best system? That has run into problems, and the courts themselves have rejected the idea of a national judicial appointments commission. We need to consider whether sticking with the present system is indeed the best. My personal prejudice is that it isn't, and we should be going to something like the National Judicial Appointments Institution. I think a third and very crucial thing here, which again is something which is internal to the judiciary, is the adoption of procedures that do not encourage huge amounts of delay. And my suspicion is that, again, this is something as an economist I cannot claim to have any knowledge about, but my suspicion is that if we were to subject Indian judicial procedures to what I would call state-of-the-art judicial procedure analysis, they would come to the conclusion that the thing is designed to make cases last for 20 years. I mean, there's no reason at all, in my view, even for complex cases, why both sides cannot be expected to submit extensive written submissions, but limit their argument to whatever it is, 1 hour, 2 hours, 3 hours, instead of having multi-day kind of argumentation, which takes up a huge amount of time. So I do think that these are very doable. These changes will only happen if somebody within the judiciary or the former judiciary or something, develop a momentum that would give the political system a little bit of strength to promote this change. And I think we need to do that. Now let me come to another issue, and that is really more to do with the clarity in our laws. I feel that if we are going to be a rule of law society, and I think we have to be, because we are not the kind of society that could possibly be a rule by law society. It has to be a rule of law, and the judiciary has to be seen to be independent, and people should have recourse to the judiciary. Now, one of the critical things there is that the laws themselves must be much more carefully drafted than they are. And I think there are two deficiencies in this as I see it. One is simply that the government does not have access to sufficiently skilled lawyers. If you were to look at what the government pays its lawyers and what, let's say, a moderately successful lawyer earns outside, you have to assume that there's no way that they can attract good lawyers to do all the hard drafting work. I can tell you that as a former finance secretary, we spent a lot of time in trying to work out what the purpose, what the tax changes we wanted. But none of us had the technical skill to make sure that the way the thing was written up actually led to the intended effect. So there's a lot of discussion on tax policy that gets translated into a whole lot of legislation, and there's not enough high quality input to make sure that the legislation, when it goes before a judge, would be interpreted the way you meant it to be interpreted. Now, of course, we also have problems where in the famous Vodafone case, for example, we went through a very tortuous process, and the issue really was that this is what the company concerned understands the law to be. And of course, they have organized their lives in order to take tax advantages, which is what all companies do. And it would be reasonable to assume that the Supreme Court is the final arbiter of what the law was. Well, the Supreme Court actually ruled in favor of the company and against the revenue side. And we went and retrospectively, we didn't actually amend the law, we retrospectively clarified the law in order to have the same effect that an amendment. Now, this clearly, to my mind, was a mistake and shouldn't have been done. And I think you need to be very clear that when you've drafted a law, that's what you've drafted. And when the Supreme Court has interpreted it, you cannot say they got it wrong. You can say that was never our intention, and if we drafted it wrong, we better change it now. But then that change should be prospective. You cannot have a situation where an investor acts in a particular way, thinking that this is what the law actually requires him to do or allows him to do, and finds that that judgment is vindicated by the Supreme Court, and then the government takes a different view. Now, that's one example. We can find other examples of this kind. But let me give you a different type of uncertainty that gets created also. This is to some extent the consequence of the introduction of or the sanctification of public interest litigation way back in 1979. And let me say, I'm in favor of public interest litigation was meant to protect the interests of those who are voiceless and who otherwise would not actually get any hearing in the law. I'm not sufficiently knowledgeable about this, but the first actual case was about some prisoners that had been held without trial in Bihar for God knows how many years. And that's exactly what the PIL, to my mind, originally was meant to be. But then later on, it grew into all kinds of things. I mean, it grew into people who could, for example, when it came to land acquisition, you could have land acquired for a public sector project. You could challenge that acquisition on the grounds that it's unfair. Now, the truth is that the law was pathetic and the law should have been changed. But when people acted under a particular law and then you tried to stop it, you do introduce a huge amount of uncertainty. And you know, this didn't make that much. I mean, in the even in the 1990s, the Narmada Bachao Andolan, Meda Patkar launched a very major campaign against the progress of that project. The project has been very successful since then. And I think she had some effect in the sense that people saw that you needed to do more, you need to do more compensation, etc. So on the whole, that thing did not lead to the obstruction of the project, although those who went to court were very unhappy that all they got was a little bit more support and not an actual stoppage. But you know, later on, I mean, let's take, I'm saying all this really to provoke Pradeep, who's written a whole book on Supreme Court judgments. So if I get it wrong, maybe when he comes in to say his bit, he will clarify. But you know, I was very struck, for example, in the coal case way back in 2012 or something, when a large number of coal block allocations was challenged on the grounds of all kinds of procedural improprieties. Now, you know, it's a different thing if a coal block allocation is challenged on the basis of a specific allegation of malfeasance, which could be there. I mean, you know, you can't, but then that should be judicially looked into. In this particular case, a large number of coal block allocations were challenged because it was felt that the procedure that the government was using to allocate these coal mines was somehow defective. I'm not questioning whether that was a correct judgment or not. As a matter of fact, the government, even that government decided that it would be much more transparent to allocate the coal mines by auctioning, because that would be transparent, and that was the right thing to do. But the point is, having been following a certain procedure and having allocated a whole bunch of coal mines to people, the court decided to cancel all these allocations irrespective of the individual merits of the case. So now this has an interesting question. You have an investor who might have said, look, I don't know what other fellows did, and maybe they did something wrong. I didn't do anything wrong. If there was something wrong with the procedure, that's not my fault. I mean, you're the government, you're doing the procedure. I accept your procedure, I apply, you give me the license, I go and invest. And suddenly you say it's canceled. You know, it has to be accepted that that, to my mind, is not the kind of signal that would encourage a lot of investment to take place. And I think connected with this is another dimension. And that dimension is that there's been a structural change in the Indian economy following deregulation. See, earlier, everything was being done by the government. Now, I wouldn't say, rightly or wrongly, there was social trust. I mean, in my view, what the government was doing in the 1970s during the control regime was economically disastrous. As a matter of fact, the best PIL would have been if Rahul Bajaj had challenged the government in 1980 under a PIL that the licensing system that was in place is damaging India, damaging the people of India, preventing the reduction in poverty, etc., he would have been right. But through the 1980s, when a very control-oriented economy was being operated, and PIL had been established as a legal institution, nobody challenged it. After the reforms in 1991, because the actors became not public but private, immediately the level of social trust disappeared. People were willing to trust the government making these decisions, in my view wrongly, because the government made wrong decisions, but they're not at all willing to trust the private sector. And therefore, I mean, we should have anticipated that you're not going to have the same level of trust. Therefore, you need to double and treble the level of transparency. But I think that the shift from the public sector mode to the private sector mode hugely increased the importance of credible institutions and the importance of a legal system in which people would trust in fairness. So I think the two separate issues that I'm talking about. One is we got to recognize that as we give such a big role to the private sector, which I think is the right thing to do, we have to be sure that they're operating under a regulatory and a legal system which does not allow them to manipulate the rules to their advantage, does not allow them to get any unfair advantage, subject them to competition, and then with competition, if they win, good luck to them. And I think that's actually a political transition, which I don't think has yet quite been made. I mean, today, for example, people are still not willing to see that maybe many of our public sector companies should be privatized. There's very strong opposition to that. I mean, there's a presumption that a public sector company somehow, no matter how inefficient, no matter how uncompetitive, should continue to be supported, whereas the private sector really cannot be trusted. This is 30 years after reform. This perception exists. I think it needs to be addressed head on, rather than doing it through reforms by stealth. We also, I think, need a much clearer understanding of what the consequences of particular laws should be. Let me just give you one example and then I'll stop. You know, after this horrible incident of a rape in Delhi, I think in 2012, the Nirbhaya case, there was a huge and understandable anger. And many NGOs, not all, but many were arguing that one of the things to do is to strengthen the law against rape. And they would say death penalty should be made mandatory. Now, you know, when this was discussed internally, it was pointed out that if you make the death penalty mandatory, the two things will happen. If the case has at all any uncertainty, judges will actually acquit rather than convict, because nobody would want to convict if there's even the slightest shred of doubt. Equally, if the death penalty is made mandatory, there'd be a very strong incentive on the part of the perpetrator of the crime to kill off the victim, to get rid of evidence. So now these are, you know, it wasn't easy to make these points in the heat of opinion at that time. But these were important points. As a matter of fact, we didn't make it mandatory. The death penalty was included, was left in, but in the rarest of rare cases, etc. And amongst many of the people who agitated on this, they were not happy with that. So I think we need to consider this whole issue of the design of the law. I mean, if you want judges to hew as closely as possible to the law as it is written, then the law must quite clearly indicate the intent of government and parliament, so that the judges can say that's clearly what is mean. Now, if it's badly drafted and open to multiple alternative interpretations, you're only you're generating uncertainty, which no legal system can really resolve. I mean, those are some of the points that I have. Let me just say that I thank you for inviting me, and I look forward to Pradeep correcting all the many mistakes that I must have made in these few minutes. Thank you.
Thank you, Dr. Ahluwalia. It was no less than a fascinating keynote address. And in fact, you did build upon what Professor Jenny had reflected on, particularly bringing the Indian context, but also a very important aspect which many people may not fully understand and appreciate, that, you know, I will say, you mentioned that economists are not so much involved in lawmaking in India. Even lawyers are not so much involved in lawmaking in India. Most of the time, the lawmaking process is done in closed doors, largely led by civil servants, and on fewer occasions when it ends up going to the Parliamentary Standing Committee, there are opportunities for a more public consultative process. But I think it is only fair to say that both lawyers and economists need to play a much stronger role in the lawmaking process itself. So thank you very much for that, you know, really fantastic keynote address. Now I'm going to invite Mr. Pradeep Mehta to deliver the vote of thanks and concluding remarks of this conference.
Thank you very much, Raj. Thank you very much indeed. And it has been a fascinating 1 hour, I would say, to hear both Fred and Montek speak. It's always such a delight, the kind of wisdom that they have, and to be able to learn from them, which I continue to do. Let me start with two givens in our Indian judicial system, Fred, particularly, which is important for you to appreciate the kind of inherent drawbacks which the system has before we expect the judiciary to be able to decipher, to be able to appreciate the economic sense of any particular matter which they have to adjudicate about. It so happens that our former law minister, finance minister, one of our very brilliant lawyers, Arun Jaitley, if you remember Fred, Arun Jaitley, made a statement in the parliament one day in the 1990s. This is what reforms have led to is the failure in the quality of judges, because all good lawyers refuse to join the bench, and the practice is so enriching. And this is something which I can see myself happening in the sense that even if you look at the present crop of our Supreme Court judges, most of them, they are not even half as good as they were about 10 years ago. And I'm sure Raj would agree with that statement. So that is one given that is very important. The second given is what liberalization has done, is to build up a system of corruption which is so endemic and is so ingrained now at every level possible. Just the other day, we heard the former Home Minister of Maharashtra asked to resign because he had told one assistant sub-inspector of police, which is probably the lowest officer in the police ranks, to give him 100 crore rupees a month. And this is being done. I mean, this is just one example which has come to light, but otherwise one can come across several such examples day to day. So now in the book that I've written is that we know that these things are given this part of the system. So what I've tried to write in the book is that, can we think about an alternate remedy? Fine. Montek spoke about the coal mine scam, the 2G license scam, etc. Undoubtedly, there was a lot of hanky-panky in it. Now, in the coal mine scam, particularly Montek has rightly said, there were a lot of procedural issues which were highlighted by the judiciary, that these procedures were not followed. I too remember that two honest civil servants were also caught in that war of having been punished, when I'm sure that none of them took a dime or a nickel or a paisa in that particular transaction. They couldn't have done it, knowing them so well. And procedurally, they were certainly at fault. Now, why were they at fault procedurally, Montek? This is the important thing. If you look at the machinations which went on behind the scenes, part of the coalition politics. Coalition politics often makes people to do things which they're not to do. The telecom minister from DMK said it very bluntly. He said, I am the telecom minister of India, and I'll decide what has to be done in the telecom sector. So he dropped aside the first come first scheme, and I beg your pardon, he brought it up instead of going in for auctions, even at that point of time, in the 2G scam, and allocated spectrum and licenses to friends who could cough up money. And in the context, you were right. There were 4 foreign investors also who were caught in that. The Russians, the Norwegians, and the Emiratis, 3. And sorry, there was one more, and coming through Singapore. Now, their argument was what you rightly said, Monty. You said, look, we entered this company knowing that this is what the company is all about. And these are the licenses that they have got. So we joined them as equity partners, and we started to running. Now, all these licenses were cancelled. They all had to pack up. And if you remember that it was during your time when it also became a international diplomatic political issue, with especially the Russians raising noise. Norwegians kept quiet. They did not make such a noise, etc. Now, so the suggestion that I have made in the book is that the court should understand that you are dealing with corruption, a system where a lot of these corruption leads to travesty of justice, rule of fairness goes to hell, and what only matters is to how you do it. So what could be the alternate? To give an example, some excellent helicopter that we had purchased, and we discovered later that there was some corruption in it. Do we cancel the order? There was nothing wrong with the helicopter. There was something wrong with the transaction. So even at that point of time, I had argued with the opposition party, then opposition party, which is BJP. I said, why do you want them to cancel the helicopter deal? Let it come. You penalize the helicopter manufacturers for having violated the agreement that you should not have paid this kind of commission to an agent and so on. The same thing is happening, Fred, in the Rafale deal that India has now got with France. Again, allegations being made as to what is happening. Now, what does it mean? Is the Rafale aircraft bad? No, it is not bad. So the point what I'm trying to make is that the judiciary should be aware of the kind of reality. And Montague also hinted at the fact is that even the judiciary can be politicized, which has happened in our country. A former Chief Justice of India has now become a member of the upper house. For what reason? Another former Chief Justice of India became a governor of a state. And we know, and this is criticized badly by the legal fraternity itself, that you don't do these kind of things, but you know that these kinds of things are happening. So the point what I'm making is that, look, can we think of a remedy which will allow this transaction to go on and the transactees, the transactors to be punished adequately? It can be done, as it is happening in the coal block allocation. The CBI court is still continuing and still finding people with the fault of that. Now, in terms of the law in economics, I mean, this is something which, in many cases, what we found that Supreme Court has appointed committees to assist them on technical matters or on matters which are, which require very detailed field work and so on. And even during the PIL stages, Montague, if you remember, during the time of Bhagwati and Krishna here, commissioners were appointed by the court to go and verify whatever has come, whether the Bhagalpur blinding case. So commissioners were appointed. Now these are all experts. They could have been experts, they could have been non-experts. But what I'm trying to say is that the system that we are suggesting is something which needs to be institutionalized. And rather than to cut off the head to cure a headache, you can't cure the headache by cutting off the head. You require a head. So that is what is the argument. Now, when you talk in terms of the investor uncertainty that we have seen, like the Vodafone case, Fred, just to tell you about the Vodafone case, it's a very classic case of how Government of India levied retrospective tax. The Supreme Court struck it down. And then, as Montague pointed out, the then finance minister brought in a law to clarify that, look, this retrospective, and that the Supreme Court order which came was also very good. I mean, coming from a well-known judge whose understanding about economics was one of the good ones of our judges, Kapadia, if you remember. So we all know that these things can happen, and that fact is that that led to uncertainty. Even the next government which came in kept on promising and hee-hawing but did not remove that retrospective taxation provision at all. So I don't know. I mean, reasons for which I do not wish to go into. I do not wish to go into the details of the reasons here. Now, in order to improve our investors' certainty, we are engaged in the World Bank's ease of doing business rankings. We have been fighting. That is something which government has been proudly pursuing. All governments since past so on. One of the biggest problems we found is in the area of contract enforcement / dispute resolution, which is still bad for reasons what we have already spoken about. The specific relief act in India was amended to allow a court to appoint experts. So legal provision, even the civil procedure code allows experts to be formed, to be established by the courts to deal that. But it has not been happening in the manner that it could happen. That is what our plea is. Now, my contention is that the Supreme Court should highlight the key judicial principles that it seeks to uphold and not stick to only delivering judgments. There's one particular order that I have written about and spoken about is the Shiv Shakti sugar case, where the judge was wise enough to point out the judicial principle of that what you require is understand the economics of any order that you're going to pass and whether it is going to provide overall justice or not, comprehensive justice. That we all expect to have become a kind of a precedent. It has not been happening. Now, in order to come back to the point about corruption and the system with the way it is, I don't think it's going to change. In one manner or the other, our politics has become so dirty that corruption is going to be a part of it, except that maybe at the very high places today it is absent. Now, what we have recommended is that the Supreme Court must set unprecedented fines and penalties on officers and politicians involved in corruption or malfeasance. And also, what we don't have under the Indian law is also to order disgorgement so that public money is returned to the exchequer. We don't have a Lincoln's law in our country, with the result that corrupt officers can get away with the money that they have made and the state has no right on it. I mean, they have done it in some cases, but those are case-to-case basis. We require a law like that. We have spoken about increasing the number of judges, etc. We also, I don't know how it operates in France or in some other countries, but in India, we follow an old colonial system of summer holidays and winter holidays. The courts are totally shut. The courts don't follow the normal work you and I follow on a daily basis, that you could take your annual leave and what have you. So that is something which many have argued again and again, that you require, because of the fact is that the number of cases. So only the other day in this conference, one of our noted lawyers, Abhishek Manu Singhvi, said that since the pandemic, the total pending cases in our courts was 3 crores or 30 million. They've gone up to 40 million now. 25% increase in 1 year because of the pandemic. Courts are not able to function properly. Even virtually, a lot of cases being disposed of, but they are not able to do that. So you can imagine the situation is only getting worse. And therefore, we need to ensure that the system becomes a little more, and that the taxpayer is able to get his money from this. Another suggestion which has been there for a long time is to split the Supreme Court into 2. Constitutional Court and Appellate Court, the way you have in many countries, including in France. And the Appellate Court can have dedicated chambers for commercial and financial matters, the one in which you served, and Cour de Cassation in France, for example. And then to also follow the same thing, appoint economists and finance experts on the commercial benches and courts. Now, what India has also done in order to speed up dispute resolution is to pass the commercial benches and courts law, to set up special courts to deal only with commercial disputes and benches in the high courts to deal with commercial matters. This has been very laggard. It's hardly moving properly in spite of the law. But what we've said that this needs to be expedited. And secondly, to appoint economists and finance experts which can to hear cases involving law and economics, whether they are competition laws, sectoral regulatory laws, contracts, auctions, PPP contracts, and the like. Now, our judges are fairly, I mean, humility is not their character, not in their character in that sense. That if you suggest training to judges, then they look at, they frown at it. They say, what training are you going to give us? So what we have suggested is orientation. What the National Judicial Academy does in Bhopal here is to do what are called retreats for Supreme Court judges, and which is basically where people like you and me are called to give a lecture on some aspects of the other, but they are not called training sessions at all. But in the cases of commercial courts, etc., there is a need for a mandatory basic orientation. Secondly, an important thing that you suggested by us and was also debated in the conference with a fairly good support was to set up an institution to do ex post analysis or even ex ante analysis of cases which involve economics. This could be with the Supreme Court itself or the Law Commission or the Niti Aayog. Niti Aayog is the central think tank that we have, which can monitor and evaluate cases of the Supreme Court, High Court, lower judiciary, tribunals, and even regulatory bodies, so that the understanding about it, including the knowledge about it, improves, and that a new narrative is built up that, look, these things are important for us to understand, that you can't afford to let them go by default. With that, let me thank both Montek and Fred for this, for their wonderful participation in this closing session, and it's been a very good learning exercise for me again. Raj, I would like to thank you and the Jindal Global University in particular for partnering in this particular colloquium. And there would be a record. All this is being recorded, so that this would be available for any of us to even view at a later stage. And let me also take the opportunity to thank all the participants of all the 45 thematic sessions in the conference. Thank you, Raj.
Thank you very much, Mr. Mehta. And I want to, of course, thank all the viewers as well. As I mentioned to you earlier, we've been on live in Facebook and YouTube, and we have had participants not only from India, but also beyond, and we'll share those proceedings as well. I also want to take this opportunity to thank all the staff of Cuts, as well as the IT staff in particular of OP Jindal Global University, staff from my own office, particularly Abhinav Madan, as well as Ashish Bharadwaj, the Dean of our Banking and Finance School, who worked with me and Pradeep to put together this conference. I deeply appreciate the time. Once again, I want to thank Dr. Ahluwalia and Professor Jenny for joining us in the session, which has culminated a very successful conference. Thank you very much.
Thank you. Before I forget, let me also thank my staff who have worked very hard in making this conference. Amol Kulkarni, Sakhi Shah, Kapil Gupta, and Pragya Singh.
Great. Thank you.
Thank you.
Thank you very much, Raj. Goodbye.
Thank you. Very good to see you. Take care of yourself.
Bye, Fred. Take care.
Thank you. Same to you.